ನನಗೆ ಆಗ್ಲಿಲ್ಲ ಅಂತ ಬರ್ಕೊಟ್ಟಿದ್ರಲ್ಲ ಅದು ಕನೆಕ್ಟೆಡ್ ಯಾವ್ದೋ ಫೈಲ್ ಕಳಿಸಿದ್ರೆ ನೀವೇ ಚೆಕ್ ಮಾಡಿದೀನಿ ಅದು ನಿಮ್ಗೆ ಬರುತ್ತೆ ಯಾಕೆಂದ್ರೆ ದಟ್ ಇಸ್ ಕನೆಕ್ಟೆಡ್ ಟೇಬಲ್ ಮೇಲೆ ಇಟ್ಟಿದ್ದಾರೆ ಅದ ಅವತ್ತಾಗಿದ್ದು ನೆನ್ನೆ ಡಿಸ್ಮಿಸ್ ಆಗಿದ್ದವತ್ತು ತಪ್ಪು ನೀವೇ ತಪ್ಪು ಏನ್ ಬೇಕೋ ಗೊತ್ತಿಲ್ಲ ನಿಮ್ಮಿಂದ ಬಂದಿದ್ದೀನಪ್ಪ ನಾವು ಅದನ್ನ ಏನ್ ಕೊಟ್ಟಿದ್ರು ಅವರೇನು ದಬ್ಬಾಕಿ
Requesting my lords to kindly take up a pending matter at 2:30.
Pending matter.
Pending matter.
Which
Petition
classification?
Seeking for mandamus, education matter recognition.
Recognition for that form
Change of
3.
Governing council. Change of governing council.
That
I've
will
made a
have to be heard.
representation.
It cannot be done like that. Monday.
Monday.
Great. Question matter. Application matter. That the university not permitting the petitioner to attend the exam.
ಯಾವ exam?
15 university means Bachelor of Veterinary Science.
Veterinary science. Attendance then a problem.
Yes, shortage of.
ಎಷ್ಟಿದೆ attendance?
Shortage.
ಎಷ್ಟಿದೆ?
67%.
70 ಬೇಕು.
75%.
75?
Yes.
ವೈಶಾಲಿ ಹೆಗ್ಡೆ ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿ. ಸರ್ವ್ ಮಾಡಿ 2:30.
Please.
Adjournments.
Okay, we make a mention, this is a code all 21 excise matter. The United Breweries' entire manufacturing plant has been seized by the excise authorities as of yesterday. It's an illegal seizure, my lords. Hence, we're moving this matter for 2:30.
Monday.
My lords, 2:30, my lords.
2:30, we
The
can't
entire
hear you.
plant is shut, my
We
lords.
can't hear you at 2:30. It will be taken up on Monday.
My lords, the only request is,
2 days, nothing will happen. We also would not be sitting post 3 o'clock, so it can't be taken up.
entire plant and raw
We
material.
will list it and adjourn it because we are not sitting beyond 3 o'clock.
My
it will
lords,
come
may
up on
request
Monday.
before lunch, my lords, request.
Monday it will come up. Thoroughly.
Lordship, a fresh matter, my lordship, GM Police, my lordship, is a classification. The explosive licensee is not being
Fresh
permitted.
matter won't come to us.
Only old matter.
It's only up to 2018.
Monday. Adjournments. List number 1, page number 1, serial number 1 and 2. Page number 2, serial number 3 to 8. Page number 3, serial number 9 to 16. Page number 4, serial number 17 to 23. Page number 5, serial number 24 to 30. Page number 6, serial number 31 to 39.
The 31, that's, there are some possibility of settlement. We will report it on 23rd.
31, you are for the petitioner.
Petitioner and one
And
more
counsel
connected
for the
petition is
petitioner
filed.
submits that there is a possibility of settlement.
Settlement, we will report it on 23rd.
If the matter is taken up on 23rd, settlement could be reported, relist on
Model will kindly
23rd.
be explained.
Interim order earlier granted is
One
extended.
more petition is filed in respect of the very same crime,
Connect with
3313 of 24.
of
24.
24,
And this petition is filed by the in-laws and fresh petition is
498.
490.
Connect with Swans. It'll come here or it'll go there, whichever it will.
Page number 7, serial number 40 to 48.
Not serial number 40, my lords. Can be 2 weeks time maybe.
You are for? petitioner.
I'm for petition, my lords.
The request of counsel for the petitioner relist on 20, after vacation,
This
Released
this matter,
on,
charge sheet is filed, my lord.
charge sheet is filed. FIR challenge, yeah?
Also,
Not senior is out of station, kindly.
Why you challenge FIR, charge sheet has been filed.
ಆಗ್ಲೇ ಮಾಡಿದ್ದಾರೆ.
File a
Evidence
petition
ಹೋಗಿ.
for challenging the charge sheet.
Yes, nuts, but there is
I verify, released on 23rd, 40.
My lords, serial number 47, my lords. I may be permitted to withdraw, my lords.
Petitioner is before this court seeking for the following relief, a memo dated 5/4/2024 has been filed by the counsel for the, signed by the counsel for the petitioner has been filed, which reads as under. This is pending for evidence. Accepting the said memo and the submission of counsel for the petitioner, the petition is dismissed as withdrawn. 46. Petitioner is before this court seeking for the following reliefs. Memo dated 5/4/24 has been filed, signed by the counsel for the petitioner, which reads as under. Accepting the memo and the submission of counsel for the petition, petition is dismissed as withdrawn.
Page number 8, serial number 49 to 57.
Serial number 51, I am perfect. There's a week time.
Hmm?
Serial number 51. Week's time may be granted.
ಇದ್ರ ಹಿಂದೆ ನಿಂತ್ರೆ ಕಾಣಲ್ಲಪ್ಪ, ಸ್ವಲ್ಪ ಸೈಡ್ ಬನ್ನಿ.
Inform the
51.
respondent presented.
I am appearing for R2.
You're up. You want,
Started.
A short amount.
the request of counsel for the petitioner released on 4th June.
Serial number 54, my lordship, that this is, sorry, is not in a.
Notion 54.
You are unveiling that 54, serial number 54.
Ah.
The petitioner counsel met with an accident and he is not able to come. That kind of
Ah,
request
this
it
is
like
right.
after.
Learned,
Vacation.
it submitted that the counsel, arguing counsel for the petitioner has suffered from an accident. Released on 12th June. ಬರ್ತಾರಲ್ಲ, fracture ಆಗಿದೆ.
Yes. After vacation.
Page number 9, serial,
Interim.
serial number 58 to 68.
Serial number 58, my lord. I am for the petitioner.
Hmm.
We have to secure the further documents, my lord. We inform the senior counsel.
You're informed.
Yes.
58 at the request of counsel for the petitioner released on 4th June.
That's all.
Page number 10, serial number 69 to 75. Page number 11, serial number 76 to 83. Page number 12, serial number 84 to 90.
88, my lords. 2 weeks accommodation.
88 at the request of counsel for the petitioner released on 4th June.
Watch up. Serial number 90, my lords.
Hmm.
Inform the other side. Senior is unavailable today.
90 at the request of counsel for the petition released on 4th June.
Same order may be.
Interim order extended.
Serial number 87, my lords.
Hmm.
2 weeks time will be done. 2 weeks.
87 at the request of counsel. Have you informed the respondent?
Yes, it's a government knowledge. Government.
Government. Yes, Prasad.
Government ಅಲ್ಲಪ್ಪ, BS ಪ್ರಸಾದ್ ಇದ್ದಾರೆ.
I will inform, my lordship. I will inform.
4th June.
My lordship, same connected matter is serial number 56 also, my lordship.
ಯಾವುದು?
Same connected, serial number 56. There are 3 matters,
56.
same party.
56 connect to so and so and released on.
4th.
Yes,
Published.
list 2,
List number 3,
3. ಏನಂತ ಹೇಳಿದ್ದಾರೆ?
Serial number 30.
Monday. List 3, all of them will be repeated on Monday.
Oh.
My lordship, serial number 36.
Wherever
Serial number 30.
Inform other side after vacation. Serial number 3.
serial number?
Serial number 4, my lordship, number 3.
ಈ ಕಡೆ ಬಾ.
ಏನ್ parted ಏನಿಲ್ಲಲ್ಲ?
ಇಲ್ಲ.
4 at the request of both the councils.
Serial number 5 also, my lord.
Released on 4th June, 5th, 5 at the request of both the councils.
Yes, ma'am.
4 your lordship.
ಹಾ,
ಹೇಳಿ
4 ಹೇಳಿದ್ರು. ನೀವು ಅಂದ್ರಲ್ಲ.
ನಾನು 5.
ಅವನು ಫೋನ್ ಮಾಡಿದ್ರು ನನಗೆ.
ಅಲ್ಲ, ನೀವು ತಲೆ ಅಲ್ಲಾಡಿದ್ರೆ ಅದಕ್ಕೆ ಕೇಳಕ್ ಹೋಗಿ. 5 ಕರೆಕ್ಟಾ?
Yes.
Yes,
At the request of both the councils released on 4th June.
Serial number 36, my lordship, list.
36.
Sir, 36, 2 weeks time, my lordship.
36 ಯಾವ ಲಿಸ್ಟ್ ಅಮ್ಮ?
Serial number first list.
ಫಸ್ಟ್ ಲಿಸ್ಟ್. ಇವಾಗ ಲಿಸ್ಟ್ 3 ಹೇಳಿ.
My lord,
Serial number
list 3,
92.
field number 3.
ಹಾ,
May I request for the date of 16th or any date thereafter? The senior council engagement and we have some difficulty in it.
3 at the 16th.
List three, serial number three.
List 3, CL number 3, 16th.
Serial number 92, my lords.
List 3,
My lord,
Anything
list 3,
else?
serial number 13,
15,
13, my lord.
13.
Interim order may kindly be extended.
Yeah, all interim orders will be extended and they will be
Great.
repeated on Monday.
Grateful.
That's all. Your list
Serial number 36.
36.
Uh,
ಏನಾಗ್ಬೇಕು?
2 weeks time, my lordship.
You're for?
Respondent number 2.
You inform the petitioner?
ಇಲ್ಲ, phone ಮಾಡಿ ಹೇಳ್ತೀನಿ, intimation ಮಾಡಿ.
36.
Number 30, my lord.
36 at the request of counsel for respond number 2 released on 4th June.
Serial
number
30, 2 weeks time, my lord.
32,
No, 30, my lord.
30.
Interim order may be extended.
Have you informed, who are you for?
I am for the petitioner, my lord. We call them.
There are so many other counsels here. Have you informed all of them?
No, list number 1, my lord.
List number 1, serial number 30, ST Prashant Kumar, Devraj,
Yes, my lord.
Raghu Prasad. ಎಲ್ಲ ಇದ್ದಾರೆ.
Call Raghu Prasad in the morning, but they did not answer. my lord.
Then wait till it comes.
I'll inform them. my lord.
You inform at 30.
My lord, serial number 92. The matter may be posted after vacations. It is for settlement as the parties are not available.
92, the counsel for the both-
Petitioner.
Vishnu Hegde did not come last time. They submit that the matter is settled and if it's taken up after vacation, settlement would be reported, released on 11th June.
Great.
List number 1, order serial number 1.
Who is
Hello,
R2?
For the petition.
Who is R2?
Complainant, my lords.
Complainant, private, police.
Lords, these all matters are private only, my lords, because of the simple reason that there was a common issue involved. All of them were connected with another batch. When we pointed out they are not the same issue, these 4 came to be delinked from that batch and that was disposed. These, my lords, will have to, that issue is now sorted in terms of whether the inspector or the deputy superintendent of police has to register the FIR was the issue involved there. Now, my lords, in all these cases, the deputy superintendent of police only has registered the FIR, so that issue is no more
Yes.
to be dealt with. Though we don't have per se an objection to all of these being tagged along, they'll have to be heard independently.
Okay, but still services to be effective.
Please, my lord, there is one office objection on behalf of the respondent. We'll comply very shortly. All pages on the statement of objection are not signed. I'll sign it.
Serial number 1,
And for the petition, within 2 days, I will take steps to.
that counsel for the petitioner submits that he would make payment of necessary process fee within 2 days.
Please.
If needful is done, registry is directed to issue notice to respond number 2 returnable by 11th June. If process fee is not paid by full raja ideyalappa. By 10th April, petition would be liable to be dismissed for non-prosecution. Counsel for 1.1, 1.2, and counsel for respondent number 3 seeks for, counsel for Lokayukta, na?
Please, my lord.
Lokayukta seeks for and is granted 3 weeks time to comply with the office objection, released on 11 June.
Serial number 2. 30.
Obliged, my lords, deeply obliged.
Interim order, my lordships.
ಯಾವ್ದ್ರಲ್ಲಿ? 1 ಅಲ್ಲ?
Yeah, 1.1. I
1 ಅಲ್ಲಿ
repeated.
interim order. 2?
For the petition.
ಬಿ ರಿಪೋರ್ಟ್ ಆಗಿದೆ. ಬಿ ರಿಪೋರ್ಟ್ ಆಗಿದೆ ಅಂತ.
Please, my lords. I have no commercial interest in the said.
Irrespective, once the B report is filed. When was the B report filed?
Dated on. ಬಿ ರಿಪೋರ್ಟ್ 7/11/18 ಬಿ ರಿಪೋರ್ಟ್ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ರು.
2/11/18 ಆಮೇಲೆ ಏನಾಯ್ತು?
8/1/2019 ಬಿ ರಿಪೋರ್ಟ್ ಅಕ್ಸೆಪ್ಟ್ ಆಗಿದೆ ಸರ್ ಪೋರ್ಟಲ್.
ಆಗಿದೆ.
ಆಗಿದೆ
ಯಾವತ್ತು ಅಕ್ಸೆಪ್ಟ್ ಆಗಿದೆ?
8/1/2019.
8/1/2019
ಬಿ ರಿಪೋರ್ಟ್ ಅಕ್ಸೆಪ್ಟ್ ಆಗಿದೆ.
ಯಾರು ಪ್ರೊಟೆಸ್ಟ್ ಮೆಮೊ ಏನೋ ಹಾಕಿಲ್ಲ. Petitioner is before this court seeking for the following relief. Learned SCGP on instructions from Acer Court Budi. Submits that a B report was filed on 2/11/2018, which was accepted by the court on 8/1/2019. Thereafter, there is no protest memo which has been filed. In that view of the matter, the above petition having been rendered infructuous, petition stands disposed.
Obliged. Serial number 3. Varun Ara.
Lords, I filed my retirement, my lords. I have informed the petitioners. Even yesterday I have mailed them and
Acknowledgement produce ಮಾಡಿದೀರಾ?
ಮಾಡಿದ್ದೀನಿ.
ಎಲ್ಲಿದೆ?
Lords, page 3, my lord. Page 2.
25(3) na? To engage another counsel. Page
When
3 is
yesterday I
in
have,
You are requested to collect, ಇನ್ನ collect ಆಗಿಲ್ಲ.
ಆಗಿದೆ. They had sent one person by name Ningraju. In the memo, my lords, page 1, they have collected on 23rd. Even yesterday I have mailed them and even through call I have informed them the case is
Counsel for the petitioner has filed a memo dated 25/3/2024 seeking permission to retire from the matter. Along with the said memo, a copy of the wakalatnama handed over with no objection, as also an email addressed to the petitioner on 21st March 2024 are enclosed. The memo also bears an acknowledgement of receipt of the NOC wakalatnama and papers by one Ningaraja, who is a representative of the petitioner. In that view of the matter, the memo of retirement is accepted. Shri Varun RR is permitted to retire from the matter, is discharged.
Please.
Registry is directed to print the name of the petitioners in the cause list and relist on 16th April. If there is no appearance on behalf of the petitioner on that date, petition will be liable to be dismissed for non-prosecution.
Serial number 4. RB Deshpande.
Under the caption. Memo of
For
retirement.
the, memo of retirement, map retirement filed by the earlier.
ಆಗಿದೆ, ನೀವು appear ಆಗಿ.
I'm the NOC.
Shri RB Deshpande has entered appearance for the petitioner. Hence, memo of retirement filed by Ms. Rakshita DJ is accepted. She is discharged from the matter. Registry is direct delete her name as that appearing for the petitioner. Yes. Who is this impleading applicant?
Impleading application, what is that, my lord? Earlier, my lord, it is the ACP, my lord. Now Lokaita. That is the, for that reason, my lord, I filed the application, my lord.
Allow ಆಗ್ಬೇಕದ?
Don't allow.
ಇಲ್ಲ.
The
In view of the judgment of the division bench, all matters pending before the Anti-Corruption Bureau have been transferred to the Honorable Lokayukta.
Lokaita.
In that view of the matter, IA 1 of 2024 has been filed, accepting the reasons stated therein, the said application is allowed. The Honorable Lokayukta is brought on record as respond number 3. Shri B.V. Patil accepts notice for respond number 3. Counsel for the petitioner to carry out necessary amendment, file amended cost act.
They also filed the objection to the.
Filed out.
So far as ACB is concerned, my lord, they already filed in the name in the.
The same may be adopted, my lords.
Shri
That
B.V.
doesn't change the
Patil
facts of the-
submit that the objection statement filed by the ACB will be adopted by the Honorable Lokayukta has the objections of the Lokayukta.
Please.
His submission is taken on record. The objection filed by the ACB is treated as objection of the Lokayukta.
Then
ಆಮೇಲೆ
IFR, stay for one. My lord.
stay 18ರಿಂದ ಇದೆ.
ಅಲ್ಲ.
Ready, you have to argue.
No, my
the-
lords, it's a
Already
trap
filed.
case. It's a trap case. We are ready. We filed our
Also
counsel.
ready,
We'll
madam.
argue.
I'm also ready, my lord.
Argue ಮಾಡಿ.
My lord, this is the case, my lord.
Hmm.
Kindly see the complaint, my lord, in page number 25, my lord. This is the complaint.
Page
filed by-
number?
Page number 25, my lord.
Yes.
ಬೆಸ್ಕಾಂ ಅಧಿಕಾರಿಗಳು ಲಂಚಕ್ಕಾಗಿ ಒತ್ತಾಯ ಮಾಡುತ್ತಿರುವ ಬಗ್ಗೆ. ಸ್ವಾಮಿ, ನಾನು ಹಾಸನದಲ್ಲಿ ಎಲೆಕ್ಟ್ರಿಕಲ್ ಗುತ್ತಿಗೆದಾರನಾಗಿದ್ದು ಹೊಸದಾಗಿ ನಿರ್ಮಿತ ಕಟ್ಟಡ ಮತ್ತು ಹೆಚ್ಚಿನ ಸಾಮರ್ಥ್ಯದ ವಿದ್ಯುತ್ ಸಂಪರ್ಕವನ್ನು ಕಟ್ಟಡ ಮಾಲೀಕರಿಗೆ ಬೆಸ್ಕಾಂ ಇಲಾಖೆಯವರಿಗೆ ಒದಗಿಸಿಕೊಡುವ ಹಾಗೂ ಕಟ್ಟಡ ವೈರಿಂಗ್ ಕೆಲಸವನ್ನು ಮಾಡಿಕೊಂಡಿರುತ್ತೇನೆ. ಹಾಸನದ KH ರಸ್ತೆ ಬಳಿ KDBಯಲ್ಲಿ ಚಂದನ್ ಎಂಬುವರ ವಿಜಯಲಕ್ಷ್ಮಿ ಎಂಬ ಹೆಸರಿನ ಗಾರ್ಮೆಂಟ್ ಫ್ಯಾಕ್ಟರಿಯಲ್ಲಿ ನಡೆಸುತ್ತಿದ್ದು, ಈ ಫ್ಯಾಕ್ಟರಿಯನ್ನು ಚಂದನ್ ಅವರು ಈಗಾಗಲೇ 5 HP ವಿದ್ಯುತ್ ಸಂಪರ್ಕವನ್ನು ಪಡೆದಿದ್ದು, ಜೊತೆಗೆ ಹೆಚ್ಚುವರಿಯಾಗಿ 20 HP ಸಾಮರ್ಥ್ಯದ ವಿದ್ಯುತ್ ಸಂಪರ್ಕ ಪಡೆಯುವ ಬಗ್ಗೆ ವಿದ್ಯುತ್ ಗುತ್ತಿಗೆದಾರ ನನಗೆ ಗುತ್ತಿಗೆಯನ್ನು ನೀಡಿದರು. ಇದಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ನಾನು ಫ್ಯಾಕ್ಟರಿಯಲ್ಲಿ ವೈರಿಂಗ್ ವ್ಯವಸ್ಥೆಯನ್ನು ಮಾಡಿ ಹೆಚ್ಚುವರಿಯಾಗಿ 20 HP ವಿದ್ಯುತ್ ಒದಗಿಸಲು ಕೋರಿ ಅಗತ್ಯ ದಾಖಲೆಯೊಂದಿಗೆ ಚಂದನ್ ಅವರ ಪರವಾಗಿ ನಾನು ಹಾಸನದ ಚೆಸ್ಕಾಂ ಇಲಾಖೆಗೆ ಈ ಬಗ್ಗೆ ಸುಮಾರು 15 ದಿವಸ ಹಿಂದೆ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸುತ್ತೇನೆ. ನಾನು ಸಲ್ಲಿಸಿದ ಅರ್ಜಿಯ ಬಗ್ಗೆ ಈ ಬಗ್ಗೆ ಸುಮಾರು 5 ದಿನಗಳ ಹಿಂದೆ ಚೆಸ್ಕಾಂ ಇಲಾಖೆ ಅಸಿಸ್ಟೆಂಟ್ ಇಂಜಿನಿಯರ್ ದೀಪಕ್ ಎಂಬುವರ ಬಳಿ ಹೋಗಿ ವಿಚಾರಿಸಿದಾಗ ನಿಮ್ಮ ಕೆಲಸ ಆಗಿಲ್ಲ, 2 ದಿವಸ ಬಿಟ್ಟು ಬನ್ನಿ ಎಂದರು. ಆಗ ನಾನು 2 ದಿವಸ ಬಿಟ್ಟು ಎಇ ದೀಪಕ್ ಅವರನ್ನು ಕಂಡು ವಿಚಾರಿಸಿದಾಗ, ನೀವು ಬರೀ ಬಂದು ಹೋದರೆ ಆಗುವುದಿಲ್ಲ, ಕೆಲಸ ಮಾಡಲು ಹಣ ಕೊಡಬೇಕು, ಹೋಗು ನಾಳೆ ಬರೋಣ ಎಂದರು. ನಾನು ಅದರಂತೆ ನಿನ್ನೆ ದಿವಸ ಚೆಸ್ಕಾಂ ಕಚೇರಿಗೆ ಹೋಗಿ ದೀಪಕ್ ಅವರನ್ನು ಕಂಡು ವಿಚಾರಿಸಿದಾಗ, ನೋಡಪ್ಪ, ನಿನ್ನ ಕೆಲಸ ಆಗಬೇಕು ಅಂದರೆ ಲಂಚ ಕೊಡಬೇಕು, ಮೇಲಿನವರು ಸಹ ನೋಡಿಕೊಳ್ಳಬೇಕು, 20,000 ರೂಪಾಯಿ ಕೊಟ್ಟು ತೆಗೆದುಕೊಂಡು ಬಾ, ನಿನ್ನ ಕೆಲಸ ತೆಗೆದುಕೊಂಡು ಹೇಳಿದರು. ನಾನು ಅಷ್ಟೊಂದು ಎಂದಾಗ ಅವರು ಸಹ 15,000 ರೂಪಾಯಿ ಎಂದು ಕೊಡಬೇಕು, ಇಲ್ಲಾಂದರೆ ನಿನ್ನ ಕೆಲಸ ಆಗಲ್ಲ ಎಂದು ಲಂಚಕ್ಕಾಗಿ ಒತ್ತಾಯಿಸಿದ್ದಾರೆ. ನನಗೆ ಲಂಚ ಕೊಡುವಂತೆ ಒತ್ತಾಯಿಸಿದ ದೀಪಕ್ ಅವರ ಮಾತನ್ನು ನನ್ನ ಮೊಬೈಲ್ನಲ್ಲಿ ರೆಕಾರ್ಡ್ ಮಾಡಿಕೊಂಡಿರ್ತೇನೆ. ಸರ್ಕಾರಿ ಕೆಲಸ ಮಾಡಲು ಲಂಚಕ್ಕೆ ಒತ್ತಾಯಿಸುತ್ತಿರುವ ಹಾಸನ ಚೆಸ್ಕಾಂ ಇಲಾಖೆ ಎಇ ದೀಪಕ್ ಅವರಿಗೆ ನನಗೆ ಲಂಚ ಕೊಡಲು ಇಷ್ಟವಿಲ್ಲ. ಎಇ ದೀಪಕ್ ಅವರ ಮೇಲೆ ಕಾನೂನು ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಪ್ರಾರ್ಥನೆ. ನನಗೆ ಸರಿಯಾಗಿ ಬರೆಯಲು ಬಾರದ ಕಾರಣ ಹೊರಗಡೆ ಕಂಪ್ಯೂಟರ್ ಟೈಪ್ ಮಾಡಿಸಿಕೊಂಡು ಬಂದು ನೀಡಿರುತ್ತೇನೆ. This is the complaint, my lord. My submission is that, my lord, so far as the complainant work is done, my lord, it is not pending. One Chandan work is pending there. Chandan work is concerned. I'm not on that point, my lord. Kindly see that page number 113, my lord.
113.
Regarding the sanction is concerned. Page number 113, my lord. Page number 113.
Yes.
The last 14, my lord, column 14, my lord. Sakshama Pradhikara Adhikari.
113 alla.
113, my lord.
Wow.
Deepak Kumar, HR Sahayaka Engineer.
113.
113.
114, 113 ತರ ಕಾಣ್ತಾ ಇದೆ.
In that, my lord.
ಮುಖ್ಯ ಇಂಜಿನಿಯರ್.
14, my lord.
Yes.
Sakshama Pradhikarika, that is the sanctioning authority. That is
Chief engineer.
Chief Engineer, Chancellor. Now I'll take lordship to the page number 331, my lord. And the relevant is that, my lord, in the page number 335, my lord.
335.
331 is the sanctioning order issued by the authority, my lord. That is the Karnataka Vidyut Prasarana Nigama.
ನಿರ್ದೇಶಕರು.
That is the issue. He is not the competent person to issue the sanction order, my lord. The sanction which is, it is a illegal order. That is my only one submission is there, Karnataka.
Lords, the latest judgment of the Honorable Supreme Court in 2019, I don't have it readily, I'll submit it, my lords. It says that an absence of sanction per se would be a scope for interference in under 482. But in the case of there being a sanction, faulty one, that has to be gone into in a trial.
Faulty sanction is different from an incompetent sanction. If the sanction is now by Nirdeshakaru, who doesn't have the power, and even in the charge sheet, you mentioned that the sanctioning authority is the chief engineer. Is a misrepresentation, misstatement, false statement?
What I would most respectfully submit, my lords.
You yourself have not even said it is the director. You have said it is the chief engineer.
In the charge sheet, my lords.
In the charge sheet. So why do you have to say chief engineer in the charge sheet when it was by the director?
But invariably, my lords, my respectful submission would be that this has to go through a trial where it would be an appropriate place to decide as to who is the sanctioning authority and whether he has applied his mind on.
You place the judgment to say
I'll place the judgment.
whether that would cover a
Lords,
misstatement.
even otherwise, my lords, I would rely on the judgment of Subramaniam Swamy, my lords, which says that all provisions of PC Act should be interpreted to meet the object of the statute. Here, my lords, is a case where he has been red hand caught in a trap proceeding, and because of a formal trap, clean trap agide, red hand trap mahazar ide, pre-trap mahazar alli
Trap is
ಕೇಳಿದ್ದಾರೆ,
there
charge
must be
sheet
valid
ಹಾಕಿದೆ.
sanction.
Charge sheet ಹಾಕಿದೆ.
Actually ಹಾಕ್ತೀರಾ trap ಅಂತ.
Lords, trap ಅಲ್ಲಿ he explicitly demands, trap mahazar alli he is caught red hand receiving the money also.
Produce that judge. Relist on tagging for some time that it comes for respondent number.
I'll produce that judgment and all other relevant judgments on sanction.
6 and is granted a week's time to produce certain judgment that he wishes to rely upon. Relist on 16th.
Please.
You can melody entry, madam.
ಏನ್ ಒಂದ್ ವಾರದಲ್ಲಿ ಏನಾಗಿದೆ?
Oblige.
Charge sheet ಆಗೋಗಿದೆ.
Charge sheet ಆಗಿದೆ, but valid sanction ಬೇಕು ಅಂತ ಅಷ್ಟೇ. That only on that ground.
See.
Oblige, deeply.
Serial number 5, SB total.
But in this case, my lords, the petitioner number 1 is no more. And
Complainant is no more ಅಂತ ಬೇರೆ
Please.
ಹೇಳಿದ್ರು.
And complainant is
Petition number
also
2?
no more. Only petitioner number 2 is there, my lords.
He has been bedridden. He has admitted to hospital because of heart failure and the kidney failure, my lords. What are the suit? Allegation is that, my lords, this petitioner number 2 helped the petitioner number 1 in obtaining the GPA. That's only based on PCR, this complaint was filed. This FIR was.
And what is the allegation against petition number 2?
Petitioner number 2, my lords, at page 10, my lords, of the PCR, my lords. Not even in page number 11, my lords. They, since they are closed, the para number 4, my lords, at page 10.
One nimsha.
Please.
Page number
10, my lords.
10.
Please.
Yes.
Private complaint, my lords. The complainant submits that on the 2nd week of April, she came to know that a partition has been taken place in the family and the same was registered before the office of the sub-registrar Sringeri on 22/5/2014. The same is not within the knowledge of the complainant. After coming to know of the fact, the complainant came to Sringeri and inquired in the concerned offices and has obtained certified copies of the documents. After the receipt of the documents, the complainant was shocked and surprised to know that a power of attorney of her has been produced before the sub-registrar Sringeri. In fact, the complainant has not executed any power of attorney. The alleged power of attorney is created by the accused number 1 with the help of accused number 2. That's the only thing, my lords. The accused number 1 and 2 are close relatives and friends, and by colluding each other, they have created alleged special power of attorney. The stamp paper has been taken at Sringeri and alleged power of attorney has been executed before the notary at Bangalore. And in the next para, my lords, at para number 6, my lords, the complainant submits that she has not executed any power of attorney to anyone. The accused number 1 and 2, by colluding each other, oppose the signature of the complainant. And
investigation agilva.
Investigation, that's what, my lords. I requested him to send the documents, my lords. But since he was hospitalized, my lords, I have to get those documents.
And stage, how do we?
This complainant also filed a suit, my lords, a partition suit in 2018. And nowhere in the GPA nor in the document, my lords, and they are not even blood relatives. They are only friends, my lords, because that is the only allegation. Not even in the GPA, this petitioner number 2 has signed, my lords.
It's in favor of whom?
It's in favor of the complainant, my lords. The GPA was created by petitioner number 1.
In favor of?
In favor of complainant. That's complaint number 2.
Complainant is supposed to have executed a power of
attorney that was created by the.
In whose favor?
My lords, they were family members, my lords, because they represent.
Who is appointed as attorney?
Attorney is Krishna Rajit, petitioner number 1, my lords.
Petition number 1.
Please, my lords. This complainant was also residing in Bangalore, my lords. Since the petitioner number 2 was residing in Bangalore, based on that, this complaint, since they were close friends, my lords.
There is no stay.
There was no stay.
Investigation
So I just have to get those documents.
Investigation ಏನಾಗಿದೆ? SCGP. Investigation ಏನಾಗಿದೆಯಪ್ಪ?
Please, while is misplaced, I'll get the instruction.
Let us see what the investigation, please. And SCGP seeks for and is granted 10 days time to ascertain the status of the investigation. Released on 16th April. Please.
Serial number 6. Madhuri Gaikwad.
ಕಡೆ ಕಾಣಲ್ಲ ಹಿಂಗ್ ನೋಡ್ಬೇಕು Yes.
For the petition.
Yes.
The petitioner is accused number 2 in this crime 5 and 4 of 2017, Milord. Milords, initially there's a lease agreement between Confident and Nippon Milords, dated 17/9/2012 for 33 months, Milords. Thereafter, they stopped paying rents in July 2014, and a termination of the lease is sent on 7/4/2015 and 17/6/2015. Thereafter, they invoke arbitration proceedings, Milords, and execution proceedings. And the arbitration proceedings is invoked on 23/7/2015, execution on 7/10/2016. After invoking both these proceedings, Milords, they come and register an FIR against the petitioner and others, Milords, on 28/11/2017, Milords, that they have not paid them the rents, they have cheated them, Milords.
Yes.
Milords,
You paid the rent.
Milords, the petitioner is a director, Milords, who has already resigned from the company, Milords.
Where is the resignation letter?
Milords, it was produced along with the memo on 8/2000.
On?
She resigned on 3/4/2017, Milords. The resignation letter and DIR
12.
12 is produced, Milords.
And the year 12 was filed on?
3/4/2017, Milords.
3/4/2000. When was the complaint filed?
28/11/2017, Milords.
On 7/12/2017.
Please, Milords.
You resigned on 3/4/2017. The payments have been not made for which period?
Milords, in this, there was a 60 lakh deposit, security deposit, Milords.
The payments have not been made for which period?
July 2014 till 7/4/2015, but
You
there
were a director during that.
Milords, please, Milords, but I was not in charge of day-to-day
That is to
activities.
be inquiry.
Milords, even if we look at the lease agreement, Milords, at page 19, Milords, annexure
Yes.
3.
The lease agreement is 17 September 2012. From 2014 to 2017, you are not paid.
Milords, but I was
And
not.
thereafter
I
you
was not
resigned.
I was not the signatory, Milords. It can be seen that one Iqbal is the signatory, Milords. He was in charge, Milords. I was just a director, Milords.
Yes, but you are a director.
I was a director, Milords, but I was not. Further, Milords, they have not arraigned the company also as the accused, Milords, in their FIR, Milords. Only they. So at that point, accused number 1 and 2 are the directors, Milords.
Are you going to pay the amounts?
Milords, there is an arbitration proceedings and execution proceedings pending against the company, Milords, and they have filed.
That doesn't matter. Even if civil remedies are there, criminal proceedings also.
Milords, I am no longer a part of the company, Milords, because.
In 2017.
Please, Milords.
You were when the payments were not made.
Please, Milords.
So you are responsible.
Milords, yes, as a company, Milords, but I have resigned from the company, Milords. I was not in charge of the company.
Sorry, madam. Can't accept that.
Milords,
That is the only ground. Not
Milords, no,
accepted.
Milords, even there's no preliminary inquiry, Milords, against, if Milords may look at the complaint.
There's no preliminary inquiry required for this. What is the preliminary inquiry required for this?
Milords, the same day they have, because there is a civil proceeding, Milords.
It may be.
Milords, when there are civil,
It's
there
the
are.
offense under 420 which has been alleged that you are not paid. The fact remains that you are not paid.
Milords,
Unless you show that it has been paid.
Milords, that matter is pending against.
That doesn't matter. That's for recovery. This is for a criminal offense. Both are sustainable.
Milords, in this, I have no, even if we read the complaint, Milords, there is no allegation against me, Milords. The complaint can be looked at, Milords. The only allegation is that I'm a director, my lords, but nothing. They say everything is against accused number one.
I've
my lords.
absconded. They're not available. They tried to reach you. You're not reachable. You did not pay.
My lords,
ಏನ್ ಬೇಕು?
page 17 and 18, my lords, they are given the direct
Page
details of.
15, page 15 is where the
15,
allegation.
please, my lords, 14, 15. But the only, they have just named me because I'm a director, my lords, but there is not even a single specific overtax, my lords.
That will come about in the investigation and in the trial.
My lords, page 17 and 18, my lords. Even,
Sorry, madam. Third,
my lords,
petitioner is before this court seeking for the following relief. Respondent number 2, landowner, had filed a complaint on
lords, if I may, my lords.
28th November 2017 with the Ashok Nagar Police Station, on which basis crime number 514 of 2017 came to be registered under section 406, 420 and 34
My lords,
of the IPC.
if I may, I'll check what is the status, current status of the payment, my lords. A date may be fixed, my lords. I will get back on that, my lords.
You-
And because there is an execution petition pending, my lords. I will see what is the status, my lords, because
Payment ಆಗಿದೆಯಾ?
Payment agreement. My lords, my humble submission, my lords, is last time we gave an offer, my lords. Whatever 8 lakhs is deposited, that may be released to us, plus 2,75,000, both the cases may be withdrawn here as well as in the execution petition, my lords.
my lords,
It's a very, very, very nominal and reasonable kind of an offer, my lords, considering the kind of deficiency that's there in the payments done by them, my lords. 8 lakhs already they have deposited, plus 2,75,000 is what we asked them.
my lords, I will seek instructions on that point, my lords. A date may be
We're
fixed. my
arguing
lords.
for some time. Learned counsel for the petition seeks for and is granted a week's time to ascertain if the petitioner is willing to make payment of the balance amount due to a respondent or not. Relist on 16th for further hearing at 2:30 PM.
Please, careful, my
My
lords.
lords, the stay may be granted.
Interim order earlier granted is extended to.
Much obliged.
Please, my lords.
Serial number 7, SN Nayak.
Despite the order dated 22/3/2024, none appears for the petitioner today also. It appears that the petitioner is not interested in prosecuting the matter. Petitioner is dismissed for non-prosecution.
Serial number 8, Sri Ramesh Babu.
Petition, please.
Yes,
I seek
substituted.
1 week time allowed, the authorized signatory is,
The application ಆಗಕ್ಕೆ ಎಷ್ಟು adjournment ರೀ?
my lords,
5 ನಿಮಿಷ application.
I understand, my lords, the authorized signatory is having personal inconvenience.
Learned counsel for the petitioner once again seeks for a short accommodation released on 5th June.
Much ob-
Hearing on IA, serial number 9.
Hearing for
Okay,
the
moving
respondent
on.
number 4. I'll comply the office objection now itself, my lord. Kindly permit.
Counsel for respondent seeks for and is granted a day's time. Seeks for and is granted a week's time in Raja ಇದೆ.
Affidavit ready this, I will file now itself.
To comply with the office objection. Relist on 4th June.
Serial number 10.
Hearing for the
Srivastava.
petitioner's counsel. Senior is not well. I request for a week's accommodation.
There's an appearance made by the counsel for the petitioner. He submits that the arguing counsel is unwell. Relist on 7th June under the category admission.
Objection.
Serial number 11. PM Mohan Kumar.
For the petition.
Yes.
Case where, my lord, interim order.
Tenal interim order. Yes.
It's a case where, my lord, case has been registered as the instant of second respondent
Hmm.
for the offences punishable under section 153A 295A 66A of IT Act.
Hmm.
The complaint is at page number 12, my lord. Copies at page number 14.
Yes. Hmm.
Accusation is there. He has commented on the photo of Dr. B.R. Ambedkar on WhatsApp group, which led to the leading to filing of a case against the petitioner.
So it is from your mobile.
That's the accusation. It was,
It's from your mobile and you have made all this. This one is not the right thing to do.
but it's a case where, but
Freedom of speech cannot extend to all this.
Sorry.
Freedom of speech is there.
Yes, my lord, there is
But you
absolutely,
can't-
I'm not,
Nim number ado.
yes, my lord, it's my number only. It's the accusation. Right, the WhatsApp group not deliberately insulting to anybody or with the
is
intention to hurt
It
anybody's
is
feeling.
insulting. It is insulting.
Right, my submission of the court is, my lord, it was not actually sent by my mobile. In fact, was not a deliberate, intentional act of sending him that kind of statement in the WhatsApp group. Right? Insofar as there should be a mens rea and intention to.
That
provoke-
cannot be ascertained in 482.
That's absolutely correct. Right?
If it is not your number, if you had not sent the message on the face of it, we would have intervened. The statements that you have made are definitely not good, not correct.
Definitely, ma'am. I'm not admitting or
It is from your
elaborating
number.
on the point that it was correct only or it's right, it's wrong. But the question is, Manad, whether was there any mens rea or deliberate intention to make such a.
ಟ್ರಯಲ್ ಇಲ್ಲಿ 482 ಅಲ್ಲಿದ್ದೀರಾ. We cannot ascertain mens rea in 482.
Definitely, Manad. But in my respectful submission to the court is, Manad, a few judgments of the apex court wherein clearly held that there should be a mens rea which intended to provoke the.
ಟ್ರಯಲ್ ಅಲ್ಲಪ್ಪ, ಇವಾಗಲ್ಲ. 482 ಅಲ್ಲಲ್ಲ.
I may permitted to pass.
482 ಅಲ್ಲಿದೆಯಾ ಕೊಡಿ.
The
ಇದು ಆಫ್ಟರ್ ಟ್ರಯಲ್ ಇದು.
That's after trial, but the observation of the apex court is, Manad, with respect to the intention of the parties insofar as they making such statement.
How do we ascertain that in a 482?
That's the second judgment is on the point, Manad.
482 ಅಲ್ಲಿ ಇದ್ರೆ ಕೊಡಿ.
482, Manad.
Where
It's
is
not
it?
direct. This 2017 volume 7 SCC 760.
2017
volume 7 SCC, Mahendra Singh Dhoni versus. It says aggravated form of insult to religion perpetrated with a deliberate and malicious intention to outraging religious feelings, beliefs of a class of citizens, disrupting public order is necessary. Athara ಏನು ಇಲ್ಲ. And secondly, Manad, if your lordship appreciate the first judgment, if subsequent to these kind of activity, if there is any sort of disorder in the public harmony, then and the intention should be gathered from the surrounding facts and circumstances of each case. Not arguing, saying that it's correct or morally right to make such comments. But the issue is, Manad, there should be an intention to outrage the feelings of certain classes of persons to attract section 295A.
You are 153 ಅಲ್ವಾ?
295 and 153.
295
Both
ಇದೆಯಾ?
both are. The next judgment is in respect of 153A. Manad. A couple of judgment where the court, the apex court has considered even the unconditional apology also. But the question is, Manad, there should be a subsequent sequence of events or the subsequent events which should lead to such a kind of situation, and the intention of the parties or malicious intention of the person who have committed the offense has to be taken open. Of course, whatever the rights available, so far the freedom of speech and expression is very much restricted as per Article 19(1)(a).
19(1)(a) ಅಲ್ಲಿ ಬರಲ್ಲ.
ಬರೋದಿಲ್ಲ ಸುಮ್ಮನೆ restrictions ಇದೆ. ಇದ್ರ intention ಏನು ಇರ್ಲಿಲ್ಲ, ಬಟ್ ಇವನ್ ಐ ಎಂಕ್ವೈರ್ಡ್ ವಿತ್ ಬೇರೆ ಯಾವ್ದೋ ಗ್ರೂಪ್ ಕಳ್ಸಕ್ ಹೋಗಿ mistake ಆಗಿ ಈ ತರ
482 ಅಲ್ಲಿ ಇಂಟೆನ್ಷನ್ ನೋಡ್ಬೋದಾ? is the only issue.
The first judgment, though after trial, the court, the apex court has held that there should be an mens rea and intention. even in second judgment and third judgment also. There should be a presence of mens rea. The absence of mens rea, these offences quite sensitive, my lord. I do agree, but the question is, my lord, it's not a deliberate one which wanted.
In both these judgments, the court came to a conclusion that the statement made did not satisfy the requirements 153 and 295.
And observation.
That is a categorical conclusion that the court came to. Illy, we are unable to come to that.
In support of the complaint, my lord, he has not given any documentary evidence or prima facie evidence to show that I've actually sent it.
WhatsApp group message ಕೊಟ್ಮೇಲೆ ಇನ್ನೇನ್ ಬೇಕು?
My lord, may make one submission to the court. The court considers my unconditional apology in the form of an affidavit. And the court considered it because it's not deliberate one to hurt anybody and there was no subsequent any event as such.
ಯಾರಾದ್ರೂ ಇದ್ರೆ ಅವ್ರು accept ಮಾಡಿದ್ರೆ close ಮಾಡ್ಬೋದು. Respondent appearance.
The notice has been issued and they are not before this.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಬಂದಿದ್ದಾರಾ?
ಇಲ್ಲ, ಅಲ್ಲಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಸ್ಟೇ ಆಯ್ತು. ಹಾಗಾಗಿ
ನಿಮ್ ಫ್ರೆಂಡ್ ತಾನೇ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 ವಾಟ್ಸ್ಆಪ್ ಗ್ರೂಪ್ ಕರ್ಕೊಂಡ್ ಬನ್ನಿ ಅವ್ರನ್ನ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಅವ್ರು accept ಮಾಡಿದ್ರೆ try and get it.
Try to get.
The counsel for the petitioner seeks for and is granted 10 days time, released on 16th. These judgments will not help you.
My respectful submission to the court is. Yes, I do agree.
One effort you can make if they accept your.
Yes, I will make my sincere effort on this issue.
Serial number 12.
I'm a proxy counsel, my lord. Advocate on record is not well.
Not well. He's not been coming for such a long time.
He instructed not well today.
None appears for the though the counsel for the petitioner is not present, he is represented by a proxy counsel who submits that the counsel for the petitioner is unwell. In that view of the matter, released on 11th June under the category admission.
Interim order.
Interim order earlier granted is extended.
13. Sushmita K.
I appear for petitioner in this.
Yes.
Lordship, the case, the petitioner herein, the accused in the CC number 204 of 2016, Lordship. Initially, the offences are included section 341, 323, 354A, 506 of IPC, Lordship. The later, the respondent number 2 prosecution have filed 323 CRPC application to include section 376 and 511 of IPC, Lordship. The application got allowed without having any sufficient evidence, Lordship. No medical report, not considering all these material fact, the application got allowed, Lordship. And kindly see the statement given by the respondent number 2 in this case, Lordship.
376 and 511 were included.
511, Lordship.
Yes.
Well, page number 51, Lordship, Annexure E.
51.
Yes, Lordship. The operating portion from last.
Read the whole thing.
Yes, Lordship. Lastly, ಆದರೆ ಆ ದಿನ ಆರೋಪಿ ನಾನು ಈ ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ವಾಸವಾಗಿರುತ್ತೇನೆ. ದಿನಾಂಕ 9/12/2014 ಸಂಜೆ 6 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ನನ್ನ ಮೇಲೆ ಬೊಬ್ಸಿರಿ ವಾಸಿ ಮಂಜಪ್ಪಗೌಡ ಇವರು ಹಲ್ಲೆ ಮಾಡಿದ ಬಗ್ಗೆ ನಾನು ಈಗಾಗಲೇ ಮೇಗರವಳ್ಳಿ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಹೇಳಿಕೆ ದೂರನ್ನು ಕೊಟ್ಟಿದ್ದು, ಸದರಿ ದೂರಿನಲ್ಲಿ ಮಂಜಪ್ಪಗೌಡ ಈತನು ಕಲ್ಮನೆಯಲ್ಲಿರುವ ತನ್ನ ತರಿ ಜಮೀನಿನಲ್ಲಿ ನನ್ನನ್ನು ಅಡ್ಡಕಟ್ಟಿ ತಡೆದು ಎಂದು ನನ್ನ ಜಮೀನು ನೀನು ಏಕೆ ಇಲ್ಲಿಗೆ ಬಂದಿದ್ದೀಯೆ ಎಂದು ಅವಾಚ್ಯ ಶಬ್ದಗಳಲ್ಲಿ ಸುಮ್ಮನೆ ಬಿಡುವುದಿಲ್ಲ ಎಂದು ತನ್ನ ತಲೆ ಕೂದಲು ಹಿಡಿದು ಎಳೆದಾಡಿ ಕೆಳಗೆ ಬೀಳಿಸಿ ಬೆನ್ನಿನ ಕೈ ಮೇಲೆ ಗುದ್ದಿ ನನ್ನ ಎದೆಯ ಹತ್ತಿರ ಕೈ ಹಾಕಿ ನಾನು ತೊಟ್ಟಿದ ಕುಪ್ಪಸ ಹರಿದು ಮಾನಭಂಗಕ್ಕೆ ಪ್ರಯತ್ನಿಸಿದಲ್ಲದೆ ಇನ್ಮುಂದೆ ಗದ್ದೆಯ ಹತ್ತಿರ ಬಂದರೆ ಕೊಲೆ ಮಾಡುತ್ತೇನೆಂದು ಜೀವ ಬೆದರಿಕೆ ಹಾಕಿರುವುದಾಗಿ ದೂರನ್ನು ಕೊಟ್ಟಿರುತ್ತೇನೆ. ಆದರೆ ಆ ದಿನ ಆರೋಪಿ ಮಂಜಪ್ಪ ಗೌಡ ಈತನು ನನಗೆ ಅವಮಾನ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ನನ್ನನ್ನು ಅಡ್ಡಗಟ್ಟಿ ಅವಾಚ್ಯವಾಗಿ ಬೈದು ಕೈನಿಂದ ಹೊಡೆದು ನನ್ನ ಎದೆಗೆ ಕೈ ಹಾಕಿ ನಾನು ತೊಟ್ಟಿದ ಕುಪ್ಪಸ ಹರಿದು ಹೊರತು ಮಾನಭಂಗ ಪ್ರಯತ್ನಿಸುವುದಿಲ್ಲ ಕೊಟ್ಟ ನನ್ನ ಮರು ಹೇಳಿಕೆ. ಇನ್ ದಿಸ್ ಶೀಸ್ yes lordship.
ಫಸ್ಟ್ ಪ್ರಯತ್ನಿಸಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ.
And there is no medical evidence regarding 376 to attract lordship. May I read the ingredients of that lordship?
Yes, Mr.
Earlier, my lord, she gave a statement. That, my lord, while giving evidence, further statement, I have not given further statement. Earlier statement has to read. And the further statement, my lord, the police written the 161 statement is saying submitted that in the court, my lord, she said, I have not given any further statement. My first statement is I stick on my first statement.
Evidence ellide?
Evidence. Page number, annexure D. Page number 22, my lord.
Annexure D.
Annexure D, page number 22.
Page 49.
ಅಲ್ಲ ಅವ್ರ ಕಾಪಿ ಕೊಟ್ಟೆ.
27 ಪೇಜ್ ಏನಾಯ್ತು
ಗೊತ್ತಿಲ್ಲ ಅವ್ರ ಕಾಪಿ.
ಇದು ಟೈಪ್ ಕಾಪಿ.
Page number 24.
24 ಇಲ್ಲ.
ಅಲ್ಲ ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಬಂದಿದೆ, ನಮಗೊಂದು ಕಾಪಿ ಬಂದಿದೆ.
24 is annexure B.
Yes, annexure D. ಲಾಸ್ಟ್ ನಾನು ಆರೋಪಿ ನನ್ನ ಬಗ್ಗೆ ಪ್ರಯತ್ನ ಮಾಡಲಿಲ್ಲ ಎಂದು ಮರು ಹೇಳಿಕೆ ಕೊಟ್ಟಿರುವುದಿಲ್ಲ. ಲಾಸ್ಟ್ ಇಂದ 4ನೇ
ಮರು ಹೇಳಿಕೆ ಕೊಟ್ಟಿರುವುದಿಲ್ಲ. The issue is first time she gave the statement.
Yes, lord.
Which is supposed to have been retracted is what your contention is.
My lord,
Question of
there is
retraction.
section 376 does not attract lordship. That is only the ground I am.
Even an attempt.
My lord, may I read the ingredient of section 376?
Yes.
Essential ingredients of section 376 lordship. A man has sexual intercourse with a woman. B, such intercourse fall under one of the 7 clauses of the section. The case does not fall within the exception to the section. Section 375A. And there is also no medical report recorded, lordship.
Not an attempt, it is.
Not at all attempted, lordship. There is no intention or.
The ingredients are not there, Ms. Prasad. For 376. ಪ್ರಯತ್ನಿಸಿದ್ದ.
Yes.
At the most,
Yes.
best case scenario. It's an attempt. Attempt would not come under 376. 354 next. That already is there. What is the reasoning given by the court?
Well, at page number 59. Reasons, point number 1.
59.
59. Point number 1, the police have filed charge sheet against the accused for the offense under section 341, 323, 354, clause A, 506 of IPC. As per the charge sheet document, it discloses that there is a further statement given by a complainant denying the allegations of rape. However, when the evidence of the complainant was recorded, the complainant has stated that she has not given any such further statement to the police. On the other hand, stated that the accused caught hold of her faint and bent her neck and
So
punched
what
her.
has been added is an only attempt to rape.
So while reading the evidence.
So attempt ಬಗ್ಗೆ ಇದೆ.
One moment I read the evidence of the victim. ಚಾಸ ಇದು ನನ್ನ ಗಂಡ, ನನಗೆ ಚಾಸ 2, 3, 4 ಪರಿಚಯ ಇದೆ, ಆರೋಪಿ ಪರಿಚಯವಿದೆ. ದಿನಾಂಕ 9/12/2014 ಸಂಜೆ 6 ಗಂಟೆಗೆ ಹೊಸಬಾಳೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಜಮೀನಲ್ಲಿ ದನ ಬೆರೆಸಿಕೊಂಡು ಹೋಗಿದ್ದಾಗ ಅಲ್ಲಿ ಒಮ್ಮೆಲೆ ಆರೋಪಿ ಬಂದು ಸೋ ಅಂಡ್ ಸೋ ನೀನ್ಯಾಕೆ ಜಮೀನಿಗೆ ಬಂದಿದ್ಯಾ, ನನಗೆ ಸುಮ್ಮನೆ ಬಿಡು ಎಂದು ಹೇಳಿ ತಲೆ ಜುಟ್ಟು ಹಿಡಿದು ಕುತ್ತಿಗೆ ಬಗ್ಗಿಸಿ ಬೆನ್ನಿಗೆ ಗುದ್ದಿ ಮೈಯೆಲ್ಲ ಪರಿಚೆ ಸೋ ಅಂಡ್ ಸೋ ಅತ್ಯಾಚಾರ ಮಾಡಲು ಪ್ರಯತ್ನ ಪಟ್ಟಿದ್ದರು. ಕೆಳಗೆ ಬೀಳಿಸಿ ಸೋ ಅಂಡ್ ಸೋ ಪ್ರಯತ್ನ ಪಟ್ಟಿದ್ದರು. ದಟ್ ಒನ್ ಇಸ್ ಕನ್ಸರ್ನ್ ಮೈ ಲಾರ್ಡ್. ಎಡಕೈ ತೋಳಿಗೆ ಮತ್ತು ಬಲಕೈ ಮೊಣಕೈಗೆ ಪೆಟ್ಟಾಗಿತ್ತು. ನಂತರ ನಾನು ಜೋರಾಗಿ ಕಿರಿಚಿಕೊಂಡಿದ್ದೆ. ತ್ಯಾಸ 2 ಮತ್ತು 3 ಅವರು ಬಂದು ಕಾಪಾಡಿದ್ದರು. ಜೀವ ಸಹಿತ ಬಿಡುವುದಿಲ್ಲ ಎಂದು ಜೀವ ಬೆದರಿಕೆ ಸೋ ಅಂಡ್ ಸೋ.
You are not being charged for 376. Attempt to commit 376. 511 read with 376. That attempt the grounds.
No, Lord. There is.
Attempt ಗೆ ಇಲ್ಲ ಅಂತ ಇಲ್ಲ. You can't say there is no attempt. Attempt is there.
Attempt, the section is not.
That will be trials. Well, 376 is not it.
Yes.
Attempt to commit 376.
Attempt also.
So attempt will be 1/2,
Yes, yes.
not full. So that we cannot, if you'll have to establish even attempt has not happened and only during trial.
Yes.
Not
Lord.
at this stage.
Attempt has been not committed is my also ground.
That cannot be ascertained factual.
Yes.
We cannot say that. And these are all serious offenses.
Yes. Lord.
Third. Petitioner is before this court seeking for the following reliefs. Respondent number 2, complainant, had lodged a complaint with the Agumbe police station on 10/12/2014, which came to be registered as crime number 122 of 2014. Initially for offences under section 341, 323, 354A, 506. Subsequently, on investigation being completed, ಯಾವ್ದು charge sheet ಯಾವತ್ತಾಯ್ತು?
Annexure Q.
Annexure Q, madam.
Page?
Page is a different color. It's page number 77 there.
Q na?
Annexure Q.
Charge sheet was submitted on 19/2/2015. While framing charges, the trial court, after examining the matter,
This is different.
323 application ಅಲ್ಲಿ
This is a different charge sheet. Sorry, madam. They produce a different charge sheet. This one,
Sure, F Lordship, page number 52.
52.
Annexure M. Annexure M is a charge sheet.
ಅಲ್ಲ.
Page.
66.
Annexure M.
ಬರೀ ಹಿಂದೆ ಮುಂದೆ
They
page
produced
number ಇಲ್ಲ,
two charge
66,
sheets, that's why.
Annexure N na?
M. 341, 323, 354A, 506.
Page 66, madam.
On 12/1/2015 for offences under section 341, 323, 354A, 506. 323 application ಅಲ್ಲಿ
323 application, annexure.
Annexure F Lordship, page number 52.
52.
Annexure G. allo. Annexure G.
Annexure F.
Sorry, annexure.
While examining the application under section 323 filed by the public prosecutor alleging that offences under section 376, offense of an attempt to rape under section 376, punishable under section 376, read with 511 has to be included. The trial court, while ordered 36/2018, taking into consideration the evidence of the complainant which was recorded, was of the considered opinion that there being allegation that the accused had caught hold of a plates and bent her neck, punched her on the back, tore her blouse, and attempted to rape her when she sustained injuries to her left thigh and right palm, was of the considered opinion that an offense of attempt to rape has been made out and as such included. Cognizance was taken for offenses under section 376, read with section 511 of the IPC. The petitioner agreed by the same is before this court. The contention of Ms. Shushmita K, and counsel for the petitioner, is that the ingredients of an offense under section 376 have not been made out, and as such cognizance could not be taken in respect of the said offense, since there is no penetration nor are any of the requirements laid down under section 376 satisfied. The B.S. Prasad, learned counsel for respond number 2 would sub that it is not for the offense punishable under section 376 that cognizance has been taken, but cognizance has been taken only as regards an attempt to commit rape, since the cognizance is for offenses under section 376, read with section 511 of the IPC. Having perused the papers, gone through the statement of respond number 2 and the evidence recorded by the trial court, at this stage, it cannot be said that the ingredients of the offense of attempt to rape are not made out. Though the counsel for the petitioner would be right in submitting that offense of rape under punishable under section 376 are not made out. The cognizance having been taken for attempt and not for the actual offense of rape, and the considered opinion, the same cannot be faulted with on the basis of the submission made by the counsel for the petitioner. In that view of the matter, no grounds having been made out, the petition stands dismissed. All
My lord, one
contentions are left
small
open to be raised before the trial court.
my lord, one small submission. It's not 376, lordship, it's 354 it will come, lordship. 354 will.
354 ಆಯ್ತು ಇವಾಗ attempt to rape, read with 511.
My lord, one judgment I will find.
What is- The attempt will be under 511.
No,
What attempt has to be read with say 376?
my lord, kindly see AIR 1955,
Huh?
NUC 470, volume 42, lordship.
470.
B, Penal Code 1860, section 354 and 376, lordship. The scope, no injury found, no private part or any other part of the body of the woman accused, however, found laying over her, accused held guilty under section 354 and not under 376.
Correct. This is after trial. We are on 482. At this stage, attempt is the cognizance taken for.
Attempt also, my lordship, it's
We cannot decide.
modesty it will come, lordship, not.
ಅದು ನಾವು ಹೇಳ್ಬಿಟ್ರೆ ಆಮೇಲೆ ನಿಮಗೆ ಕಷ್ಟ ಆಗುತ್ತೆ. Then you will be sentenced for 354. All conditions you are there. We cannot wash it at this stage.
Application may be that quashing 323 application may be quashed, lordship, there in trial court.
There are enough grounds to make out an attempt. Your client cannot assault only because there's a private
And
dispute
although
of a
it's
property.
70 plus years, lordship. It's a 70 plus age.
There are allegations which have been made, you have to stand trial for that. Yes.
It's a committal order, my lord, sir.
Committal
The order is committal order.
ಯಾವುದು 11 interim order.
Serial number 14.
Serial number 14, I'm proxy counsel for Pushpalata madam for petitioner. I'm told that the police have filed a B report and the petition becomes infructuous.
B report file ಆಗಿದೆಯಾ?
ಆಗಿದೆ ಅಂತ ಮೇಡಮ್.
Petitioner is before this court seeking for the following relief. That counsel for the petition submits that a B report has been filed rendering the above petition infructuous. In that view of the matter, accepting his submission, petition is dismissed as infructuous, reserving liberty to the petitioner to challenge any order passed on a protest memo if funds were filed.
Much obliged.
Serial number
Pending IAS.
Veeranajit Hegde.
Petitioner.
Yes.
I am for the respondent, my lords. File is misplaced somewhere, man. 376 offense. I pray for 1 week time.
76. $1310 disposed as acquitted or convicted.
Your Lordship, may kindly see, I have challenged the order of the magistrate taking cognizance for a limited purpose to see whether any offense is disclosed or not.
Your conviction ಆಗೋಗಿದೆ ಅಂತ.
ಅಲ್ಲ conviction ಅಲ್ಲ, committal ಆಗಿದೆ ಅಂತ. Committal ಆಗಿದೆ ಅಂತ.
Committed.
Committal. So Your Lordship, I have to consider whether from the allegations made in the complaint, can it be inferred that there was a consensual sex, and if that is the case, then matter need to be quashed, my lord. That is my humble submission.
Committed ಅಂದ್ರೆ will consider.
1 week time. I pray for 1 week time.
And the request of counsel for respondent released on 24th April
Great.
Serial number 16,
under admission.
Govindaraju K.
ಏನಾಗಿದೆ? ಅವರು ಬಂದಿಲ್ಲ. Despite the order dated so and so, none appears for the petition today also. It appears that the petitioner is not interested in prosecuting the matter. Petition is dismissed for non-prosecution.
17. Muralidhar R. Raghavendra K.
ಫೈಲ್ ಮಿಸ್ ಆಗೋಗಿತ್ತು. Actually, await notice ಅಂತಿತ್ತು. All along I was under impression that
ಬಂದ್ ಹೇಳ್ಬೇಕು ನೀವು. ಮೂರ್ ದಿನ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡೋದು?
next time.
ನಿಮ್ಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಇಲ್ಲ ಅಂತೀವಿ,
I'll
dismiss
proceed
ಮಾಡ್ತೀವಿ.
with.
Today, finally, the counsel for the petitioner is present. He seeks for a short accommodation, get ready and address. Released on 7th June under the category admission.
Serial number 18.
Memo. Postal acknowledgement. File a retirement memo.
Yeah, who has filed the Prasanna Kumara, Vandana PL?
Vandana PL, my lords.
Where is Mr. Prasanna Kumar? Prasanna Kumar, ಆಮೇಲೆ ವಕಾಲತ್ ಹಾಕಿದ್ರ ಮುಂಚೆನ?
Prasanna Kumar first.
First, ಆಮೇಲೆ ವಂದನಾ. ಇವಾಗ ವಂದನಾ is also retiring. Sri Prasanna Kumar had filed wakalatnama for the petitioner. Subsequently, Ms. Vandana PL had entered appearance for the petitioner. That view of the matter, Prasanna Kumar is discharged from the matter, registry direct delete his name as that appearing for the petitioner. A memo for retirement has been filed by Ms. Vandana PL enclosing dated 6/3/2024, enclosing a letter date ಏನಪ್ಪ ಇದಕ್ಕೆ? Date ಹಾಕಲ್ಲ ನೀವು ಲೆಟರಲ್ಲಿ.
ಇದೆ my lords.
Letter addressed by her to her client, the petitioner hearing, informing him about her proposed retirement. A postal receipt was enclosed therewith. Since acknowledgement has not been produced, the petitioner she was directed to produce the acknowledgement. Today, another memo dated 5/4/24 has been filed, producing the returned cover. And what is the endorsement?
ಬರ್ದಿದೆ.
Insufficient address.
He given a wrong address, my lords. And we have intimated,
Address, wrong address, bada differences.
we have intimated through the messages also, my lords. It's not
Kalleri
responding.
Road Cross, Malur Town, Kolar District andre insufficient address. How will you serve?
No, my lords. So we have intimated to the messages also, my lords. It's not responding at all.
This cannot be served. So if it cannot be served, we cannot accept your memo. Schedule of the return cover indicates that the said notice has been returned on account of insufficient address. If such a return cannot be accepted as valid service, hence memo of retirement filed by Ms. Vandana PL stands rejected.
No, not we will file, we will send another notice.
Another notice ಆದ್ಮೇಲೆ ಇನ್ನೊಂದ್ ಸತಿ ಆಗಿ.
Um,
ಕರೆಕ್ಟ್ ಆಗಿ ಅಡ್ರೆಸ್ ಆದ್ರೆ ಇಟ್ಕೊಳ್ಬೇಕು ನಿಮ್ ಕ್ಲೈಂಟ್. ನಿಮ್ ಕ್ಲೈಂಟ್ ಅಡ್ರೆಸ್ ಇಲ್ಲ ಅಂದ್ರೆ
we'll file it another notice.
memo is rejected. Relist on 4th June to enable the petitioner to address arguments. If arguments are not advanced on that date, petition will be liable to dismiss for non-prosecution.
Serial number 19, N. Sriram
For the
Reddy.
petitioner, my lord.
Yes.
My lord,
Police report.
kindly pass over, my lord. ರಿಪೋರ್ಟ್ ಗೋಸ್ಕರ ಹೇಳಿದ್ವಿ ಶರ ಕಳಿಸ್ತೀನಿ ಅಂತ.
Pass over.
ಮಚ್ಚ
Admission, serial number 20.
But the matter is still pending. The writ petitions, my lord. Lordship may call this matter immediately after vacation.
Both the councils submit that WP number 48877 of 2015 is still pending.
Please proceed.
And relist on 28th August.
21, Nishant Devi.
Thus, the matter before the Supreme Court is still pending, my lords. I called the matter after the vacation.
Previous interim order.
Interim order. 21, learned counsel for the petitioner submits that SLP criminal 2157 of 2021 is still pending before the Honorable Apex Court. Relist on 11th December.
Please, my lord, the interim order.
Interim order later.
Much obliged.
Serial number 22,
Preparing for
Rupesh Abhi.
petitioner, my lord. Offense under section 504,
Mohan Kumar. ಬರ್ತಾ
My
ಇಲ್ಲ.
lord, previous date settlement ಅಂತ ಏನೋ ಹೇಳಿದ್ರು.
ಇಲ್ಲ. ಅದ 4-5 ಡೇಟ್ ಇಂದ ಬರ್ತಾ ಇಲ್ಲ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹಾಕ್ಸಿದ್ವಿ. ಕಳಿಸಿದ ಆರ್ಡರ್ ಶೀಟ್
Settlement talks have failed.
ಫೇಲ್ ಆಗಿದೆ. ಅದರ್ ಸೈಡ್ 4-5 ಡೇಟ್ ಇಂದ ಬರ್ತಾ ಇಲ್ಲ, ನೋಟ್ ಮಾಡಿದ್ರಿ ಸರ್.
ಅವರು ಬಂದಿಲ್ಲ. ಆಯ್ತು ಹೇಳಿ.
Offense under section 504, 506, 3110 of SC/ST Act, my lord. SC/ST Act, my lord, page number 15, my lord. Present petition is accused number 2, my lord.
Accused number 2 is the petitioner, right?
Petitioner, my lord. Page number 15, my lord.
Yes.
Contents of the complaint ಕೆಳಗಡೆ ಬಾಟಮ್ ಇಂದ 3ನಲ್ಲಿ ಇವರ ಮಗ ವಕೀಲ ವೃತ್ತಿಯಲ್ಲಿರುವ ಸಂದೀಪ ಎಂಬುವರು ನೀನ್ಯಾವ ಕುಳುವಾಡಿ ನೀನು ಇಲ್ಲಿಂದ ದಾಟು ಎಂಬುದಾಗಿ ಬೈದರು. ಒಂದು ಎಲಿಗೇಷನ್.
ಎಲ್ಲಿ? Where did this happen?
ಟೈಪ್ಡ್ ಕಾಪಿ ಪೇಜ್ ನಂಬರ್ 15, my lord.
Where did it happen?
ಅಲ್ಲಿ ತೋಟದಲ್ಲಿ ಸ್ವಾಮಿ, ಸಿವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆ ತೋಟದಲ್ಲಿ.
ತೋಟದಲ್ಲಿ. ಬೇರೆ ಯಾರು ಇರ್ಲಿಲ್ಲ.
ಇಲ್ಲ. ಅಟ್ ದ ಟೈಮ್ ಆಫ್ ಇನ್ಸಿಡೆಂಟ್ ಸಿವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆ ಸ್ವಾಮಿ, ಸಿವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆ.
Petitioner is before this court seeking for the following relief.
ಐ ವಿಟ್ನೆಸಸ್ ಇದಾರೆ ಮೇಲೆ.
ಇಲ್ಲ ಇದ್ದಾರೆ, ಅವರು ಇದು ಸೇಮ್ ಹೇಳೋದು.
2 and 3
ಸೇಮ್ ವರ್ಷನ್ ಇದೆ.
ಯಾರು ಐ ವಿಟ್ನೆಸ್?
ನಾನು
CW2 and 3, my lord.
ಅದು ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ. ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ
ಪೂರ್ಣೇಶ್, my lord, CW2 and CW3 ಸತೀಶ್, my lord.
ಅಲ್ಲ, CW2 and 3 ಇನ್ಸಿಡೆಂಟ್ ಆನ್ 6/10/2016. ಪ್ರೆಸೆಂಟ್ ಗೆ 5 ಟೈಮ್ಸ್ ಇನ್ಸಿಡೆಂಟ್ ಇದೆ. ಇವ್ರು 6/10 ಅಂತ ಹೇಳ್ತಾರೆ. ಅವರು ಸೇಮ್ ಅದನ್ನೇ ಹೇಳೋದು ಸ್ವಾಮಿ, ಸೇಮ್ ವರ್ಷನೇ ಹೇಳ್ತಾರೆ. ಇದು ಇವ್ರದ್ದು ಏನಂದ್ರೆ ಇವ್ರ ತಂದೆದು ಇವ್ರದ್ದು ಜಮೀನು ಗ್ರಾಂಟ್ ಆಗಿರ್ತದೆ ಸ್ವಾಮಿ. 2004 ಅಲ್ಲಿ 3 ಎಕರೆ 18 ಗುಂಟೆ ಒಂದು ಸ್ಕೂಲಿಗೆ ಜಾಗ ಕೊಟ್ಟಿರ್ತಾರೆ.
ಏನಿಲ್ಲ,
ಅದು
ಸಿವಿಲ್
ಚಾರ್ಜ್ ಶೀಟ್ ಕಾಲಮ್ ನಂಬರ್ 17, my lord. ಆರೋಪಿ 2ರವರು ನೀನ್ಯಾವ ಕಳುವಾಡಿ ಇಲ್ಲಿಂದ ದಾಟು ಎಂದು ಬೈದು ಬೆದರಿಕೆ ಹಾಕಿ.
ಹೌದು, ಕುಳುವಾಡಿ ಅಂದ್ರೆ ವಿಲೇಜ್ ಸರ್ವೆಂಟ್ ಅಂತ ಆಕ್ಯುಪೇಷನ್ ಸ್ವಾಮಿ.
ಆರೋಪಿ ನಂಬರ್ 3ರವರು ಸಹ ನೀನು ನಮ್ಮೂರ ಹೊಲೆಯ ನಿನ್ನ ಮುಖಕ್ಕೆ ಉಗಿದು ಉಡಿಸುತ್ತೇನೆಂದು ಜಾತಿ ನಿಂದನೆ ಮಾಡಿರುವುದು.
ಅಲ್ಲ, ಅಬ್ಯೂಸ್ ಆಫ್ ದಟ್ ಆಕ್ಟ್ ಅಷ್ಟೇ.
Yes, my lord.
ಪಾಪ ಯಾರು ಆಕ್ಚುಲಿ ಸಫರ್ ಆಗ್ತಾರೋ ಅವ್ರಿಗೇನು ಸಿಗಲ್ಲ.
Yes, my lord.
ಇದು ಹಿಂಗ ಅಬ್ಯೂಸ್ ಮಾಡಿ. Petitioner is before this court seeking for the following reliefs. Respondent number 2 filed a complaint on Date ಏನಿದೆ?
My lord.
Issue date on 5/10/2016,
5/10/2016, my lord.
ಅಲ್ಲ, complaint date 6/10/2016
6/10, sir.
Yes, my lord.
One day delay ಇದೆ.
with the Arehalli Police Station, Belur Circle on 6/10/2016, on which basis crime number 160 of 2016 came to be registered for offences under section 504, 506, 34 of the IPC, read with section 31X of the SCST Prevention of Atrocities Act
3110 ಮಾಡಿದೆ sir.
1989. The essential allegation made in the said complaint is that there being a dispute as regard the property between the complainant and the petitioner. The complainant as the accused has abused the complainant by using his caste in their property, in the disputed property, and there is a threat held out. And in furtherance, it is in furtherance thereof that action is proposed to take. Challenge is subsequent thereto, investigation having been completed, a charge sheet has been laid on 19/1/2017.
ಅದ್ರಿಗೆ ಇನ್ನೊಂದು ಡೇಟ್ ಬರ್ದ್ಬಿಟ್ರು my lord. 21/4/2017 ಅಂತ ಇದು ಮಾಡಿದ್ದಾರೆ ಮತ್ತೆ.
19/1 ಅಂತಿದೆ ಇಲ್ಲಿ.
Yes, yes, my lord.
Correct.
24/1 ಎಲ್ಲಿದೆ?
ಅಲ್ಲಲ್ಲ, ಅವ್ರು ಯಾರೋ ರೆಡ್ ಇಂಕ್ ನಿಂದ ಬರೆದು ಕೊಟ್ಟಿದ್ದಾರೆ.
ರೆಡ್ ಇಂಕ್ ಯಾವುದು ಇಲ್ಲ.
Charge sheet filed on 25/3/2017.
21/4 ಅಲ್ಲ?
25/3/2017.
ಇಲ್ಲ.
Annexure CL 19/1 ಅಂತಿದೆ ಅಲ್ಲ?
19/1/2017 ಅಂತಿದೆ ಮಲ್ಲ.
ಹಾ.
Yes, yes, my lord.
19/1/17. It's agreed by the same petitioner is before this court.
Also.
The continued learned counsel for the petitioner is that there is a dispute between the petitioner and the respondent as regard the property in question, as a property in OS number 118 of 2010 pending on the file of Civil Judge Belur. It is in that background that a false complaint has been filed by the respondent to coerce the petitioner to come to terms. His submission is also that even on a perusal of the entire complaint, the background of the complaint being the civil dispute, it cannot be said that there was an intention on part of the petitioner to abuse the complainant by using his caste. Furthermore, the incident having occurred in the property, in the subject property, and not in front of the end public, no offense can be said to be made out, and in this regard, it relies upon the decision of the Honorable Apex Court in Hitesh Kumar versus so and so. Though the respondent has been represented by a counsel, none has been appearing for the respondent, and this court, while it's order dated, (23, 2024), observing the same, had noted that in the event of there being no representation on part of respondent number 2, the matter would be taken up for consideration on the basis of the submission of the counsel for the petitioner. As such, the same was taken up today. There is substance in the submission made by learned counsel for the petitioner inasmuch as the place of occurrence is stated to be the property in dispute which has been decreed in favor of the petitioner in OS number 118 of 2010 by the Civil Judge Belur. When the petitioner is a decree holder, the respondent having having come to the said property, the complainant, the accused is stated to have abused the respondent by using his caste. If the respondent who has come to the property would indicate that there was no particular reason for the petitioner to have abused the respondent, since it is not the petitioner who has gone to the property of the respondent. In view of the decision of the Honorable Apex Court in Hitesh Kumar's case, the alleged offense being not a standalone offense but related to a civil dispute and having occurred in the property in dispute and not before the general public, I have the considered opinion that the offenses under Section 3(1)(x) of the SC and ST Prevention of Atrocities Act cannot be said to be made out. This offense, the cognizable offense not having made out, the non-cognizable offense and 506 and 504 would not sustain. As such, I pass the following order. Criminal petition is allowed. The proceedings in FIR number 160 of 2016 registered by the Arayalli Police Station, Berur Circle, now pending in Special CC 96 of 2017 before the Principal District and Sessions Court, Asan, are hereby quashed.
Serial number 23. Chauri HR.
Lordship, kindly pass over lordship. Senior is held up with
So
other,
rather reach agala.
he has been held up with other matter in Court Hall 24 lordship.
We will adjourn it. The request of counsel for the petition released on 23rd April.
Much obliged.
24. Narasimha Raju.
The offense of 420.
Who is for respondent? Last time in a settlement anta
Settlement ಅಂತ ತಗೊಂಡು
ಏನಾಯ್ತು?
communicate ಏನ್ ಮಾಡಿದ್ವಿ?
ಕಮ್ಯುನಿಕೇಟ್ ಆಗಿಲ್ವಾ?
Communicate ಆಗಿಲ್ಲ.
ಇಬ್ರು ಮಾತಾಡಿಲ್ವಾ? ನಿಮ್ಮಿಬ್ರು ಮಾತಾಡಕ್ಕೇನ್ರಿ?
24.
ನೀವು ಪೆಟಿಷನ್ ಆಗಿರೋ ನೀವು ಮಾತಾಡ್ಬೇಕು.
ಅದು ಸೂಟ್ ಒಂದು ಪೆಂಡಿಂಗ್ ಇತ್ತು.
ನೀವು ಮಾತಾಡೇ ಇಲ್ಲ ಅಂತಿರಲ್ಲ. ಮಾತಾಡ್ತಿರೋ ಇಲ್ವೋ?
2 weeks ಆದ್ಮೇಲೆ. That time.
Counsel for the petitioner seeks for, though counsel for the petitioner is present, none appears to respond. Released on 4th June, interim order earlier granted is extended till next date.
Please.
25. Prasad.
The petitioner. This earlier this case was resolved, disposed, is a transfer.
It is only transferred.
Transfer.
The report has been received.
Transfer. 4/2/2022
Pending
ಅಲ್ಲಿ
some other
transfer
court.
ಆಗಿದೆ.
That CC number 526 to
526/16 my lord.
Yeah.
Third additional JMFC court at Davangere my lord.
which was pending before the third JMFC court at Bangalore, Davangere,
Yes my lord.
Yes, please, sir.
has now been transferred to
Transfer to ಅದು
Some other court, ಅಲ್ಲೇ, so it's a senior.
First
Reported.
additional civil judge.
first additional civil judge,
Davangere.
Davangere. The endorsement on the CIA's website is only as regards transfer. And since the matter is disposed before the third JMFC court on account of transfer, the endorsement read as disposed. The Registrar General and Registrar Computers are directed to look into the matter so that such confusion is not created. If there is a transfer of a case from one court to the other, it should be categorically mentioned that the case has been transferred from Court A to Court B with details of the case number before Court B. Furthermore, it should not be shown that the earlier case in Court A has been disposed since there is no disposal.
Yes, disposed.
In view of the transfer which has been made, the number, the case is now re-registered as, renumbered as?
Renumber.
Start.
ಹಳೆ ನಂಬರ್ ಅದು
526.
ರೀನಂಬರ್ ಇಲ್ಲ
CC number 526 of.
526 but 2006 ಹಳೆ ನಂಬರ್ ಮೇಲೆ
First ACJ ಗೆ.
First ACJ.
You will have to amend the prayer. Otherwise, this order will not help you.
ಹಳೆ ನಂಬರ್ ಅದು.
That is not taken instructions, Your Honor, like.
Has been renumbered.
Renumbered.
The counsel for the petition seeks
Next time
for
I'll,
granted 2
find it.
weeks' time
Yes, please.
to file necessary application for amendment of the prayers
Yes,
in view of the renumbering.
yes, interim order can be.
Relist on 5th June, interim order earlier granted is extended till next date of hearing.
Please.
Serial number 26. Venkatesh Abhay.
Means, by then, the report by the Registrar General and Registrar Computers to be placed on this file. Yes, Mr. Bhagat? Where is Mr. Balraj?
Last time on the ground of ill health, time was taken.
Has he come or?
I ಗೊತ್ತಿಲ್ಲ.
Balraj under tax then? This is in his private practice, huh?
Yes, ma'am. And some proxy counsel has made a submission that he is unwell.
Offense
Your Lordship.
323, 324, 504, 506 million.
This is regarding the accepting
Second
the B
respondent
report.
is a police constable. Offense under? $88. 323. 200, 323, 320. Balraj ಏನಕ್ಕೆ?
Only order of accepting B report, my lord, that's all. Opportunity is not given. I should have been given the opportunity to file a protest petition. Without that, on 9/5 it was filed, it is accepted.
Today also none appears for respond number 2. Unwell ಅಂದ್ಮೇಲೆ ಸ್ವಲ್ಪ ಇದಾಗುತ್ತೆ. ಅದಕ್ಕೆ unwell ಅಂದ್ಮೇಲೆ today also none appears for respond number 2. On the last occasion it was submitted that he was unwell. In that view of the matter, relist on 4th June, if none were to appear for the petition, for respond number 2 on that date, it will be taken up as disposal on the basis of submission made by counsel for the petition.
57. Udita Ramesh.
Respondent.
petitioner
Needs to serve a copy on us.
Copy serve ಆಗಿಲ್ಲ.
Right now.
Counsel for respond number 2, acknowledge receipt of a copy of the petition along with annexures. He seeks for and is granted 3 weeks' time to file a statement of objection. Objection, if any, to be filed on or before 6th May, relist on 4th June.
28. Srinivasan G.
Respondent.
Petitioner, my
Last occasion, they submitted that, my lord, accused number 2 is concerned, discharge application is allowed.
Charge
And accused number 1 is concerned, my lord, dismiss. And that point of time, this petition will not survive. They have to challenge that discharge, dismissal of discharge application order.
Discharge
Petition
application.
filed by whom?
Accused number 1 and 2.
Discharge application before the trial court was filed by only the petitioner number 2, my lord.
Accused number 3 and 6 euro.
Accused number 3 and 6.
ಇವಾಗ ಯಾರು who had filed the application, discharge application?
Only accused number 6, that is the petitioner number 2.
Accused number 6 had filed. ಏನಾಯ್ತು discharge application?
ಅದು ಅಲೋ ಆಗಿದೆ ಅಂತ, ಅದು ಕಾಪೀಸ್ ಇನ್ನು ಸಿಗ್ಲಿಲ್ಲ ನನ್ಗೆ ಅದು.
ಅಲೋ ಆದ್ರೆ ಹೋಯ್ತು ಇದು petition.
ಅದು ಹೋಯ್ತು. In respect of petitioner number 2
ಹೋಯ್ತು.
ಹೋಯ್ತು. Only petitioner number 1 will remain.
ಅದೇನ್ ಮಾಡಿದಾರೆ ಅವರು?
ಅದು I'll seek instructions.
ಏನಾಗಿದೆ petition, accused number 3 ಇದು?
ನನಗೆ
ಗೊತ್ತಿಲ್ವಾ?
ಬಂದಿಲ್ಲ. And I was under the impression that this petition will not survive, both the petitioners have filed.
Only petitioner number 2 at filed.
That is only petition number 2. Petition number 1 will survive.
They are saying that, my lord, they are not, last occasion, I was under the impression that both the petitioners filed and discharge application.
ಬರೀ
As I get the accused number 1 dismiss, they submitted like that. That's why I was under. the
Current counsel for petition submitted a discharge petition is filed by petition number 2 and the same has been allowed.
Yes.
Bari petition number 2. ನೀವು ಯು ಆರ್ ನಾಟ್ ಅವೇರ್ ಅಂತ ವೆರಿಫೈ ಅಂತ ಹೇಳಿದ್ರೆ ವೆರಿಫೈ ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲ. And
both the councils seek for and are granted 4 weeks' time to ascertain the status of the discharge petition filed by petition number 2, as also if any orders have been passed insofar as petition number 1 is concerned. Relist on 4th June.
29. KG Sadashivaya.
So Sadashivaya. Despite the order dated 23/2024, none appears for the petitioner today also. It appears that the petitioner is not interested in prosecuting the matter. Petition is dismissed for non-prosecution.
Serial number 30. P. Prashant Kumar.
Petitioner, my lord, requesting 2 weeks time.
Yavudralli new petitioner?
Prashant Kumar, my lord.
Prashant Kumar.
I am his junior.
Where is Mr. Devraj? Raghu Prasad Bandilla. Shri S.T. Prashant Kumar, counsel for the petitioner in criminal petition number 1890 of 2018, seeks for a short accommodation. There is no appearance for the petitioner in criminal petition number 5006 of 2018. There is no appearance of the counsel for respondent in the said matter. If none were to appear for respondent number 2 and 8, 2 to 8, on the next date of hearing, matter would be taken up for consideration on the basis of submission made by counsel for the petitioner. 30.1, none appears. If none were to appear, the petition would be liable to be dismissed for non-prosecution. Relist on 5th June.
That interim order to be.
Interim order earlier granted is extended.
Much obliged.
Serial number 31, adjourn 32. Srinivasan T.
Petitioner, madam.
Yes.
This is a matter pertaining to release of the vehicle which was seized by the police from the custody of the petitioner. And
What happened to the lorry? 2014 ಅಲ್ಲಿ seizure ಆಗಿತ್ತು.
ಸೀಸರ್ ಆಗಿರೋದು. ಅದು ಫೋನ್ ಮಾಡಿದ್ದೆ ಅದೊಂದು ನಂಬರು ಇದಾಗಿಬಿಟ್ಟಿದೆ.
ಏನಾಯ್ತು CGP? ಇದೆಯಾ ಗಾಡಿ?
ಇದೆ ಬಿಕಾಸ್ ಅವ್ರ ಡಿಸ್ಪ್ಯೂಟ್ ಬಿಟ್ವೀನ್ ದಿ ಓನರ್ಸ್ ಮೇಲೆ
ಅಲ್ಲ ಎಲ್ಲಿದೆ ಗಾಡಿ?
ಇದು ಕೋರ್ಟ್ ಅಲ್ಲೇ ಇರ್ಲಿ ಅಂತ ರಿವಿಷನ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಯ್ತು.
10 ವರ್ಷ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದ್ರೆ ಅದು
ಬಿಕಾಸ್ ಪಾಸ್ವರ್ಡ್ ಮೇಲೆ ಅಲ್ಲಿ 230 ಮೇಲೆ
ಪಾಸ್ವರ್ಡ್
ನೆಕ್ಸ್ಟ್ ನಾನು ಅಸರ್ಟೈನ್ ಮಾಡ್ಕೊಳ್ತೀನಿ ಸರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ಅದೇ ಲಾಸ್ಟ್ ಟೈಮ್ ಕೇಳಿದ್ ನೀವು ಮತ್ತೆ ಇನ್ನ
ಅವ್ರು ಫೋನ್ ಮಾಡಿದ್ದೆ ಅವರು ಬೇರೆ
council seek fund granted 10 days time to ascertain if the vehicle is still available. Relist on 23rd April.
33, Ravindra Yamini.
Respond number 1, 2 served, 3 served. Yes.
Respondent number 3 is
ಬರ್ತಾ
the,
ಇಲ್ಲ.
respondent number 3 is the adjournment of the petitioner.
3 is the husband.
Please,
Yes.
there is the business between respondent number 1 and 3. Petitioner is housewife. There is no, she is nowhere concerned to business.
Your husband has not appeared to support you.
Please. Falsely made complaints against the petitioner. Just to harass her. This check was issued for the security of amount for the.
ಯಾರು ಇಶ್ಯೂ ಮಾಡಿ ನೀವು ಮಾಡಿದ್ರ?
ಇಲ್ಲ ಅವ್ರೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 3 ನೇ ಇಶ್ಯೂ ಮಾಡಿದ್ದು. ಇವ್ರ ಹೆಸರಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಯಾರ್ದು ಚೆಕ್ ನಿಮ್ಮ ಅಕೌಂಟ್ ದ?
ಅವ್ರದ್ದು ಹಸ್ಬೆಂಡ್ ಬೇರೆ.
ನಿಮ್ಮ husband.
Please, accused number 3, respondent number 3 here. Business between 1 and 3.
Petitioner is before this court seeking for the following relief. Respond number 1 had filed a private complaint under section 200 of the CRPC, read by section 138 and 142 of the Negotiable Instruments Act in PCR number 13620 of 2016. cognizance for the said offences have been taken. Summons have been issued. The petitioner is before this court, challenging the same and seeking the aforesaid reliefs. Learned counsel for the petitioner submit that the check in question which has been issued is neither the counsel for the learned counsel for the petitioner, the allegation made in the complaint is that the first accused company therein, that is the second respondent herein. New director adike,
ಇಲ್ಲ ಸ್ವಾಮಿ, ಏನು ಇಲ್ಲ, ಹೌಸ್ ವೈಫ್ ಅಷ್ಟೇ. ಹಸ್ಬೆಂಡ್ ಡೈರೆಕ್ಟರ್ ಆಗಿದೆ.
what have you produced to show? ಇವ್ರು ಬರೋದೇ ಇಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗ್?
ಬರೋದಿಲ್ಲ, ಅವ್ರು 2 ಸಲನೂ ಹಾಗೆ ಅಡ್ಜೆಂಟ್ ಆಗಿದೆ. ಅಲ್ಲಿ ಸ್ಟೇ ಇದೆ ಅಂತಾನೆ ಅಲ್ಲೂ ಕೂಡ ಹಾಗೆ ಪೋಸ್ಟ್ ಆಗ್ತಾ ಇದೆ. ಇಲ್ಲಿ ಸ್ಟೇ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿಲ್ಲ.
The first company, second respondent herein had borrowed monies for purchase of a truck for running of a business, as regards which, truck alla, earth excavator tipper vehicle. We'll truck and ಹೇಳ್ಬಿಟ್ಟಿದ್ದೀರ. As regards which periodical payments had to be made by the second respondent. An agreement having been entered into between the complainant and the second respondent for sharing of
ನೆಕ್ಸ್ಟ್ ಸರಿ ಇದೆ ಅಗ್ರಿಮೆಂಟ್.
a loan was borrowed from a bank,
ಪ್ಲೀಸ್.
not from you.
ನೋ.
What is that? The second respondent had purchased an earth excavator tipper vehicle by borrowing certain monies from its bankers, as regards which a EMI was to be paid. A vehicle agreement was entered into between the complainant and respondent number 2. Annexure?
ಈಸ್ 32. ನೆಕ್ಸ್ಟ್ ಸರಿ.
Wherein the complainant handed over the vehicle to the second respondent for a period of 4 years, with an obligation on the second respondent to maintain the truck and make payment of a sum of rupees 60,000 per month to the bankers and a sum of rupees 40,000 as profit to the complainant. The said vehicle not having been maintained, the loan amount not having been paid, the bankers seized the vehicle, in persons of which the second respondent had handed over a check for a sum of rupees 15,00,000,000, which when presented by the complaint was returned dishonored for insufficient funds. it is in that background that alleging accused number 2 and 3, that is the petitioner and respondent number 3 to be directors of respondent number 2, the aforesaid complaint has been filed. The contention of the learned counsel for the petitioner is that the petitioner is neither a director of the second respondent nor as a petitioner signed the said check. None has been appearing for the respondent. This court, while it's order dated 28/2/2021, had observed that if none were to appear for respondent number 1, the matter would be taken up for consideration on the basis of submission made by the counsel for the petitioner. And as such, the matter was taken up. A perusal of the papers which have been filed by the petitioner, there being no objections filed by the respondent or no papers produced, would not indicate any directorship held by the petitioner in the second respondent company. There is no particular document which has been placed on record indicating that the petitioner is a director of respondent number 2 or that she has signed the check. In that view of the matter, the offense under section 138 read with section 142 of the Negotiable Instruments Act cannot be said to be made out. As such, I pass the following order. Prudent petition is allowed. The proceedings in PCR number 13620 of 2016, now pending in CC number 3108 of 2017 before the 20th Additional Chief Metropolitan Magistrate are hereby quashed.
Serial number 34.
In this matter, my lord, the report is filed, my lord, and the complainant also filed the protest memo, my lord.
My lord,
But
I
they are
am for-
not appearing before the court below.
My lord, I am for the petitioner, my lord. Due to some inconvenience, my senior is not there here, my lord.
A B report has been filed. So this petition goes, if there's an order passed on the protest memo, you come back.
My lord,
You have
kindly-
succeeded there.
Both complainant and accused not going to the court, my lord. They are absent.
Adu dismiss agata. Petitioner is before this court seeking for the following relief. Learned SCGP submits that a B report has been filed on
Date.
date ಹೇಳಬೇಕು ನೀವು.
Sorry, that is,
ನೀವು ಸುಮ್ನೆ B report ಅಂದ್ರೆ ಅವ್ರಿಗೆ problem.
that is the information. B report challenge protest ಹಾಕಿದ್ದಾರೆ.
A B
but
report
both-
has been filed in the said in the proceedings in time number 17 of 2018 pending on the file of the additional civil judge, junior division, MFC, HD Kote. If that be so, the above petition has been rendered infructuous, reserving liberty to the petitioner to challenge any order passed on a protest memo if filed. Petition stands disposed.
35. T.N. Vishwanatha.
So Vishwanath. Shekhar Shetty. None appears for today. On the last occasion, the matter was adjourned to explore the possibility of settlement. Relist on 7th June.
Serial number 36, adjourned. 37. Narendra D.B. Gowda.
My lord,
Yes.
the complainant had lodged a complaint making an allegation that have committed an offense punishable under section 308. Offense punishable under section 138 of NI Act. my lord.
ಜಾಸ್ತಿ ಬೇಕಾ?
Sorry,
300 series ಹೋಗ್ಬಿಡ್ತೀರಲ್ರಿ?
138. Whereafterwards, my lord, they make an application under section 311 of the Code of Civil Procedure for recalling the PW1 for further examination in chief. My lord, this application has been filed at the stage of arguments after the completion of the evidence of the complainant and the statements of the accused, my lord, 313 statement of the accused. My lord, in the application, they refer to 3 checks, my lord, bearing number 186874 for rupees 1 lakh and 1666875 for 1 lakh and 837712 for 1 lakh, my lord. 3 checks. With respect to these 3 checks, my lord, there is no notice issued to me. And there is no allegation in the complaint. In the complaint, the notice has been issued in respect of check bearing number 020122, my lord. Only to that check, my lord, only to that check, my lord, notice has been issued. Only in respect of that check, my lord, complaint has been made. In respect of these 3 checks, there is no notice issued, there is no complaint, my lord. And therefore, my lord, this application cannot be allowed.
Where is the notice?
Notice, my lord, page. Petition for the application. Notice, Your Honor. 1. The notice is here. Notice.
ಇಲ್ಲಿಲ್ವಾ?
I'll page number 12.
Page 12.
Please.
Page 12 ಇಲ್ಲಲ್ಲಪ್ಪ, order sheet.
Order sheet ಇದೆ. ಅಲ್ಲ, I have not produced my, but in the
So it was issued only for 020122.
Please, my lord.
Complaint
Even in the complaint, my lord, page number 20.
only said check.
In para 5, my lord.
Examination chief, same check.
Please, my lord.
My lords.
Examination ಬೇರೆ ಬೇರೆ check.
Please, my lord.
311 ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ?
311 my lord. Ali, the purpose of 311 is, my lords, to rectify, my lords.
Rectify what?
What has happened, my lords, in PCR, actually, my lords, what is given in the notice, the same check has been put. In para 7 in the affidavit, where the complainant has filed, cut and paste ಮಾಡಿದಾಗ he has referred this check.
He referred
In para 7 of the affidavit.
1, 2, 3, 4 checks. 3 checks.
Affidavit. Yes, exactly, that, my lord.
My lord, if it is cut and pasted, my lord, at least in the notice should have.
Actually, my lord, the subject.
ಅಲ್ಲ ಇವಾಗ ಏನ್ ಕರೆಕ್ಟ್ ಮಾಡ್ಬೇಕು ಅಂತ?
My lord, it is as simple as this. We give a notice for that 6 lakhs amount, not disputed.
Correct, bearing check number
Check number
020122.
Correct, madam. Then we filed a PCR with regard to the same. And affidavit, while filing an affidavit, my lords, in the para 4.
You mentioned different check number.
No. Para 4 is the same thing. Para 7 ಅಲ್ಲಿ ಏನಾಗುತ್ತೆ? Cut and paste ಮಾಡಿದಾಗ they have made an error. For that.
ಇವಾಗ 7 ಡಿಲೀಟ್ ಮಾಡ್ಬೇಕಾ?
7 ನಾವು ತಪ್ಪು ಮಾಡಿದ್ವಿ because we added some other.
ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
311 application ಹಾಕಿದ್ವಿ. That was allowed to do that.
ಅಲ್ಲ,
311 ಅಲ್ಲಿ ಏನು ಹೇಳಿಲ್ಲ, ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇರೋದು.
311 application was allowed, my lord. They have challenged that and got a stay.
311, what they have sought is for the further examination, not for the deletion, my lord.
Exactly, further examination, my lord, so rectify that. If your lordship can.
What is the rectification you want to do is not mentioned in 311.
Adalli mention ಮಾಡಿಲ್ಲ.
So what is, how to ascertain this? Impugned order ಅಲ್ಲೂ ಏನಿಲ್ಲ.
311 ಅಲ್ಲಿ, my lords, it is there, my lord, in the para, it is submitted on behalf of the complaint that in the examination if chief filed by the.
ಇಲ್ಲಿದೆ ಒಂದು ನಿಮಿಷ.
Complaint.
Para 7.
To rectify that, I filed 311. And it is stated in para second my.
We'll have to allow it. It's a mistake. Bona fide mistake. ನೀವು ಮಾಡ್ತೀರಾ?
Printing mistake ಅಂದ್ರೆ, my lord, in the year 2015 itself, they had the knowledge. After 3 years.
ನಿಮ್ದು ಯಾವ್ದು affidavit ಅಲ್ಲೂ ಆಗಿಲ್ವೇನ್ರಿ ಹಿಂಗೆ?
ಆಗಿದೆ.
ಮತ್ತೆ?
But my lord, ಅಲಿಗೇಷನ್ಸ್ ಇಲ್ದೇನೆ ಇದ್ದಾಗ and
Allegation is there for 0201.
021 and with respect of these three checks, there is no allegation. madam.
They are
Nor
not
in the
going to
complaint
insert,
have
they are
made any-
deleting it.
There is deleting that.
with that statement record my lord.
ಆ ಚೆಕ್ ಕೊಟ್ಟಿದ್ದೀರಾ ನೀವು?
Delete paragraph.
ಅಲ್ಲ ಆ ಚೆಕ್ ಕೊಟ್ಟಿದ್ದೀರಾ? ಮತ್ತೆ ಬಿಡಿ.
ಅದು ಆ ಪ್ಯಾರಾ ಡಿಲೀಟ್ ಆದ್ರೆ
ಆ ಪ್ಯಾರಾ ಡಿಲೀಟ್ ಆಗಿ they will lead the evidence for that. Petitioner is before this court seeking for the following reliefs. Respondent had filed a private complaint in PCR number 1869 of 2013 under section 200 of the CRPC, read by section 138 of the Negotiable Instruments Act for a dishonor of check bearing number 020122 for a sum of rupees 6,000,000 dated 23/2013, drawn on Tumkur Grain Merchants Cooperative Bank Limited. Evidence have been laid by the petitioner, by the complainant in para 7, reference to certain other checks was made in the affidavit in lieu of evidence, which allegedly came to the knowledge of the complainant at the time of arguments. Hence, an application under section 311 of the Code of Criminal Procedure was filed to delete para 7 of the said affidavit and to permit the petitioner to lead further evidence so as to place on record the corrections carried out and amendments only as regards the check which has been dishonored as issued by the petitioner herein. The said application having been allowed, the petitioner who is the accused therein is before this court challenging said order. Contention of learned counsel for the petitioner is that in the affidavit, there were 3 other checks which had been mentioned, which had not been issued by the petitioner. There is a defect in the evidence which had been led by the complainant. An application could not be filed at the stage of evidence, at a belated stage of
at the
evidence.
stage of arguments. At the stage of arguments.
At the stage of
Argument.
belated stage of arguments to correct the evidence
Yes, madam.
already recorded long ago. He submits that a right vested with the petitioner would be taken away if such an application is allowed. Learned counsel for respondent would however submit that there is no such right which is vested with the petitioner, inasmuch as what is sought to be corrected is only reference to 3 other checks in para 7, whereas para 4 refers to the check in question as regards which a notice had been issued on 2/5/2013 and the private complaint as filed refers to the said check. And on this ground, we submit that the order passed by a trial court is proper and correct and does not require interference. Heard, so and so, peruse papers. The facts having been narrated above, it is seen that an extra paragraph in paragraph number 7 has been inserted in the affidavit in lieu of evidence of the petitioner, which allegedly came to the knowledge of the complainant, which allegedly came to knowledge of the complainant only at the time of arguments. The deletion of para 7, in my considered opinion, would not in any manner adversely affect the petitioner in the present matter, since para 4 already relates to the dishonored check. The petitioner is not being prosecuted for the checks which have been mentioned in para 7, but only as regard the check which has been mentioned in para 4. That being the case, I do not find any infirmity in the impugned order dated 26/2018, passed in CC number 1300 of 2015 by the 4th JMFC at Mysore. The petition stands dismissed. The portfolio.
38, Aarti KB.
ಏನಾಗಿದೆ?
ಅರ್ಜಿ ಫೈಲ್ ಮಾಡಿದ್ರೆ ಸ್ಟೇ ತಗೊಂಡಿದ್ದಾರೆ.
Stay ಇದೆ. None appears for the petitioner. If none were to appear for the petitioner on the next date of hearing, petitioner would be liable to dismiss for non-prosecution. Relist on 11th June.
Serial number 39. Chandrasekhar and connected matter.
Yes.
My lord, yesterday, my lord, the head counsel who is on record has given a proposal stating that my lord, the dispute is in respect of 5.5 acres. The entire dispute. During pendency of the proceedings, my lord, so the accused who were party to the suit, and the family member had executed release deed in respect of 5.5 acres. Knowing fully well, my lord, in collusion with the accused number 125, had executed my lord, sale deed in respect of the entire extent, including the property fallen to the share of the, my lord, the respondent.
Even settlement act idea.
Settlement, our proposal kotru. And they say that, my lord, the 5.5 acres is in the middle of the property. Entire property is surrounded by the, my lord, Nandis Reddy, who is one of the petitioner in the criminal petition. And he says that, my lord, the property 5.5 acres na kortive anta heltare. And I have no access to that 5.5 acres. And the offer given by them, so far as the money is concerned.
Who has given the offer?
My lord, the
But
petitioner.
we have given an offer, my lord, because similar circumstances have arisen where other petitioner, other parties have also filed a suit for declaration. We have went there and on the first day
They
of
have
hearing
also
itself, we
filed
have consented for giving the lands, whatever allotted to them under the release deed.
Access ಕೊಡ್ತೀರಾ?
My lord, release deed ಅಲ್ಲಿ ಇಲ್ಲ ಅವ್ರಿಗೆ.
ನೀವು ರಿಲೀಸ್ ಡೀಡ್ ಅಲ್ಲಿ ಇಲ್ಲ ಅಂದ್ರೇನು 5.5 ಗುಂಟಾಸ್ಗೆ ಇಟ್ ಇಸ್ ಈಸ್ಮೆಂಟ್ ಆಫ್ ನೆಸೆಸಿಟಿ 100 feet ರೋಡ್ ಕೊಡಿ. ಎಷ್ಟು ಗುಂಟೆ ಹೋಗುತ್ತೆ ಅದ್ರಲ್ಲಿ? ಎಷ್ಟು ಗುಂಟೆ ಹೋಗುತ್ತೆ ಅದ್ರಲ್ಲಿ ಹೇಳಿ?
20 ಗುಂಟಾಸ್ ಎಕ್ಸ್ಟ್ರಾ ರೋಡ್ ಕೊಡ್ಬೇಕಾಗುತ್ತೆ.
ಅದಕ್ಕೆ 5.5 ಗುಂಟೆಗೆ 20 ಗುಂಟೆ ಕೊಡ್ಬೇಕಾಗತ್ತೆ.
They filed a suit for declaration.
So ಇವಾಗ 5.5 ಗುಂಟಾಸ್ ವಿತ್ ರೋಡ್ ಆಕ್ಸೆಸ್ ಕೊಡಿ ಮುಗಿಯತ್ತೆ.
ರೋಡ್ಗೆ ಇನ್ಫ್ಯಾಕ್ಟ್
ಇಲ್ಲ ರೋಡ್ ಪಕ್ಕದಲ್ಲಿ ಕೊಡಿ.
ರೋಡು
ಆಲ್ರೆಡಿ ಇರೋ ರೋಡ್ ಇರ್ಬೇಕಲ್ಲ.
It's not that they don't have a road, my lord. They are demanding a road my lord, where my land is passing. They have got an access, my lord, from the Kere.
We don't know the facts of the matter. ಇವಾಗ
My lord, they have an
opportunity ಇದೆ ನೋಡಿ ಇಲ್ಲ ಅಂದ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟ್.
They have an access.
In the release deed, my lord, among the family, initially she filed a suit for partition. During the pendency of the suit, my lord.
Mr. Lakshman is saying that if
I-
the
I-
act
I
is given, he will
understand that
accept.
if
We
it
can
is-
close it. Otherwise, we could say no settlement and you argue the matter. Either of those two ಅಷ್ಟೇ.
ಅಲ್ಲ ನಾನು ದಾರಿ ಕೊಡ್ಬೇಕಾದ್ರೆ ರಿಲೀಸ್ ಡೀಡ್ ಅಲ್ಲಿ ಇರ್ಬೇಕಾಗಿತ್ತು ಅಯ್ಯಮ್ಮನಿಗೆ.
ನಿಮ್ಗೆ ಏನಿಲ್ಲ ನಾನು ಈಸ್ಮೆಂಟ್ ಆಫ್ ನೆಸಿಟಿ ಬಂದೇ ಬರುತ್ತೆ.
ನನಗ್ ಗೊತ್ತೇ ಇಲ್ಲ ಅದು ಅವ್ರು ಮಾಡ್ಕೊಂಡಿರೋದು.
ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ ಇವಾಗ ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರೆ ಯು ಆರ್ ಬೌಂಡ್ ಬೈ ಇಟ್.
Yes, in a partition suit, my lord.
Subsequent purchaser.
It was a party to the.
I was a party to the proceedings. I am bound by, now the original suit has been filed, suit for declaration. And where is the question of cheating by me and the trial court, my lord, took cognizance as against 1 to 5.
So you want to argue? You're ready for argument? Argue the matter.
No, it can be passed over, my lord. I'll play.
Passed over reach ಆಗಲ್ಲ. ಇವಾಗ ಮಾಡಂಗಿದ್ರೆ ಮಾಡಿ.
Monday.
Monday ಇಲ್ಲ. It will go to 20, it will go to 16th. That day you argue. ಮತ್ತೆ ಇದು settlement ಮಾಡ್ಕೊಳಂಗಿದ್ರೆ ಮಾಡ್ಕೊಳ್ಳಿ.
Even before the other, but the only contention raised in the one of.
ನೀವು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳಂಗಿದ್ರೆ ಮಾಡ್ಕೊಳ್ಳಿ. ನಮ್ಗೇನು ಯಾವ ಸೆಟಲ್ಮೆಂಟ್ ಅಂತಾನು ಹೇಳೋದ್ ಬೇಕಾಗಿಲ್ಲ.
Please.
ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂತೀವಿ ಅಂತ ಹೇಳ್ಕೊಂಡು ಹೋಗ್ಬೇಡಿ.
ಇಲ್ಲ ನಾನು ಅಲ್ಲ ಪ್ರಪೋಸಲ್ ಕೊಟ್ಟಿದೆ ಅವರು. We didn't ask for any settlement. They gave the proposal.
So what do we record? No settlement and record ಮಾಡೋಣ?
Please, because they are not ready.
Both the council submit that there is no settlement which has been arrived at between the parties and they would address arguments on merits. Relist on 16th.
Serial number 40 adjourn, 41. Vijay Kumar Bhatt.
Private complaint was dismissed for non-prosecution.
Where is Mr. Harish and we?
Implementation of the labor court order, my lord. Last time they took time. For it.
ಬರ್ತಾ ಇದ್ದಾರೆ. Today none appears for respondent. The period of the order sheet indicates that the council has been representing respondent on the earlier occasions. To enable respondent to be represented, released on 23rd April.
42, James Subbareddy.
Covering for respondent to mind.
Lordships leave my lords, I file a memo for retirement. Client is not responding, my lords.
ಏನು argument ready ಆಗಿ ಬಂದ್ರೆ retirement.
Also sent a legal notice, my lords, with respect to the parties.
Counsel for the petitioner has filed a memo dated 5/4/2024 seeking permission to retire. In the said memo, it is stated that the petitioner has telephonically informed the council has telephonically informed the petitioner about said intention. A notice dated 2/4/2024 has been issued. The courier receipt and the tracking report of the courier has been produced, indicating that the said notice has been served on the petitioner on 4/4/2024. In that view of the matter, the memo of retirement is accepted. Shri Subbareddy KN is permitted to retire from the present matter, is discharged. Registry is that print the name of the petitioners and relist on 23rd. If none were to appear for the petitioner on that date, petition will be liable to be dismissed to non-prosecution.
Serial number 43, Jeta
That's on
Nayak.
for the petitioner in this case. That's agreed, please, my lords, by the order, my lords, of the learned sessions judge, in having dismissed my application, please, my lords, on under 397 CRPC, please, my lords, arising out of a situation where the charge sheet being filed, please, my lords, I had approached the learned judge, please, my lords, for discharge. Now, that discharge applications to dismiss, my lords, revision was maintainable. I filed a revision application.
Yes.
397, that was dismissed, please, without going into the merits of the case. So wherefore, please, my lords, I am before my lords. The case, my lords, of the petitioners are, my lords, the petitioner is running a school, please, my lords. It is a very prominent school, please, my lords, in Dasarahalli village, Dasarahalli. Now, my lords, they have about 200, 300 schools, my lords, other locations in India. Now, what the contention urged, my lords, by the complainant is, my lords, the Deputy Director of Public Instruction is, without, my lords, obtaining the sanctions, my lords, I have started a school and I have started to collect monies and so on and so forth. But grossly, my lords, false complaint has been instituted for the simple reason, please, my lords. I have already secured, please, my lord, the necessary licenses, my lords, from the state of Karnataka, the Public Instruction Department. And my lord, the rule is, if there is a permission granted, please, my lord, by the Public Instruction Department, I can apply, please, my lords, online to the CBSE. And I can initiate the CBSE course. In the event, please, my lords, the Public Instruction Department, on receipt of my online application, do not, my lords, object for that.
So you are running a state syllabus school or?
So initially I have started a state syllabus school.
Yes.
Now I have transferred, I have got that, my lords, secured it, my lords, to CBSE.
You cannot do that.
We can do that.
CBSE guidelines also don't allow.
Lords, it allows, my lords. I have page number 39, my lords.
Page 39.
Yes, my lords.
Yes.
Lords, earlier, please, my lords, the existing rule did not permit. They have amended, my lords, the existing rule. May I read, please, my lords, the amended rule 3.3?
Yes.
Lords, the school seeking provisional affiliation with the board must have formal prior recognition of the state, union territory government, and also produce evidence to this effect, and that the applicant school had intimated to the concerned education department of the state about the application made to CBSE for seeking affiliation with the board. In case the board receives any objection during the process of application of the school, the board may ask the concerned school to produce the no objection certificate from the state government, or otherwise it would be assumed that the concerned state, union territory government has no objection.
Where have you informed the state?
My lords, I have already, please, my lords, informed, please, my lords, they have, on my application, they have granted the permission.
Where have you informed?
My lords, online, please, my lords. Online is.
How can such a rule be there?
It is there, and they have granted me permission. Subsequently, they have granted me the permission.
You inform them no objection, it will be presumed no objection.
No, my lord, that is how it is. I mean, they will have to see, please, my lords, if there are.
Where have you informed?
Lords, I have informed them, please, my lords, online process, and lords, I will bring
Where
that.
have you informed? Documentally there.
It is available. Please, my lord, 58.
58.
Yes, my lord. That is the online process. I apply online. I have an existing, please, my lord's license. I have applied online. And thereafter, my lords, my affiliation is also granted at page number 43.
Where have you informed that you are going to be
This is
applying
the online
CBS?
process, please, my lords. That is the acknowledgement.
Online and nalaksati ಹೇಳಿದಿರಪ್ಪ.
Please, please.
Here, what it says is.
You have
that
successfully submitted application online. Kindly take the printout of this page and send the same along with each alone copy to so and so, so and so. Kendra, Bangalore, Delhi, for further
You
process.
just read out the amended rule.
Yes, my lords. Based on the, I have already.
Evidence to the effect that the applicant school had intimated to the concerned education department of the state about the application made to CBSE for seeking affiliation with the board.
Yes, please. my lords.
So where have you informed the
Let's
state
58.
education department about your application to CBSE for seeking affiliation?
That much is online, but they have already granted me the approval. CBSE grants me the approval.
CBSE
Grants me the approval.
approval subject to your informing the state department,
No, but
education department.
if there is a grievance, if there is a specific grievance,
Then we'll direct them to take action against CBSE also,
no, kindly
if that
appreciate.
is the case.
No, kindly appreciate this aspect.
First show us, where is this document
Please, my lords.
informing the state education department about your application to CBSE?
Lords, they come and inspect my premises, please, my lords, at page number.
ಯಾರಪ್ಪ?
See, your state ಅವರೇ inspect ಮಾಡಿದ್ದಾರೆ.
For giving permission to
Please.
run
No,
Kannada syllabus 1 to 5.
1 to 5 ನನಗೆ ಕೊಟ್ರು.
There's no problem.
Pending that, I have applied to CBSE.
Now you have stopped 1 to 5 and gone to CBSE.
CBSE.
Therefore, you have given up on Karnataka government.
State.
Huh.
Now I am running a CBSE.
For that particular purpose, you have to inform the change in the syllabi.
No, my lords, I have to apply online. And in the event, please, my lords, there is any.
Notes at the online here, Prayer Naila, Mr. Munish, you have to show us where you have informed the state government about your application.
My lords, my only endeavor is based on this, please, my lords, that they have granted me, please, my lords, that what we call.
You're not answering the question after asking 10 times, it is
Lord,
not.
I'm sorry, my lords, at page number, my lords, 47.
Yes.
The
is this?
entire thing meets the parameters, please, my lords. Thereafter.
No, you are not informed.
Lords, I have informed them, lords, to an extent, please, my lords, that this is what it is. So and so is registered under so and so.
You
Thereafter, my lords,
will
I have-
direct them to take action against CBSE also for not
Okay,
having carried
CBSE
out.
has
proper.
given me.
That's why we'll make them also accused number 2.
I'll do one thing, please, my lords. I will, that record will be available. I'll get it and place it before my lords.
So if CBSE is not verified your
And I'll get that record.
statement,
They
then
would have gone through. They would
they
have,
deserve to be accused too.
no, they will have gone through, please, my lords. I will place that record before my lords.
ನೀವೇ document ಕೊಡ್ತಾ ಇಲ್ಲ, ಅವ್ರು ಹೆಂಗ್ ಬಂದ್ರು?
ಇಲ್ಲ, ನಾನು ಕೊಡ್ತೇನೆ.
After arguing for some time, learned counsel for the petitioner seeks for and is granted a week's
Monday only
time
I'll place it.
to place on record the intimation provided by the petitioner to the education department of the state about the application made by the petitioner to CBSE seeking affiliation with the CBSE.
Please.
Released on 16th at 2:30 PM for further.
Please.
Sorry, 15th at 2:30 PM for further. The criminal petition, la?
Criminal.
16th.
Apply.
Serial number 44, Prasanna BR.
My lord,
Yes.
senior civil judge and JMFC Odavkere in PCR number 73/18 disposed, my lord. 13/11/2020, my lord.
Plus, the FIR, my lords, under 156(3), my lords, case is referred. And the police, respondent, police filed the FIR, my lords. On that stage, they obtained the stay, my lord, it can't be disposed. No.
156
13/11/2020.
FIR is filed, my lords, they start obtain the interim order, my lords, stay.
Yes, disposal doubt. 156(3) CC ಆಗಿರ್ಬೋದೇನೋ.
Disposed 13/11/2020 ಅಂತ ಇದೆ.
ಇದೆಲ್ಲ ಡಿಸ್ಪೋಸ್ ಅಂತ ಆಗ್ತಾ ಇರೋದು ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತಾ ಇದೆ. ಪ್ರಿಂಟ್ಔಟ್ ಇದೆಯಾ?
Print out ಕೊಡ್ತೀನಿ, kindly pass for me.
Learned SCGP submits that in the CIS, it is stated PCR number 73 of 2018
73/18.
pending before the senior civil judge and JMFC Odalkere has been disposed. Yes. He is directed to place the copy of the order. Yes. A printout of the website on record. Counsel for the petitioner and respondent seek for and are granted 10 days time to make the inquiry and make the.
One more submission, my lord, my lordship suggested. for
Dictate
settlement.
ಮಾಡಕ್ disturb ಮಾಡ್ಬಿಟ್ಟು obtain instruction, make the submission. ಹೇಳಿ.
My lordship suggested for my lord settlement.
This is
My lords.
regarding the sale deed executed by the petitioners. But then, my lord, the other third party filed a suit and obtained the decree against us, both the complainant and accused. Last occasion, lordship suggested for settlement. But our parties, my lord, said that he will ready to pay that whatever the amount paid under the sale deed. But they have to say, my lord.
Because in the. my
ನಿಮ್ಮಿಬ್ರು
lord,
ಮಾತಾಡಿ, ನಮ್ಗೆಲ್ಲ ನೆಗೋಸಿಯೇಷನ್ ನಿಮ್ಮಿಬ್ರು.
Please.
the negotiation,
ಮೈನರ್ ಎಲ್ಲಾರು ಬಂದ್ರೆ ಆಮೇಲೆ ಏನಾರು ಹೇಳ್ಬೋದು.
negotiation, it can't be done, my lord.
ಆಗಲ್ವಾ? ಆಗಲ್ವಾ?
Please.
ಆಗಲ್ಲ ಅಂದ್ರೆ ನಾವೇನು ಹೇಳಕ್ಕಾಗಲ್ಲ.
Please. Madam.
That counsel for the respondent submit that there is no possibility of a settlement in the present case.
Here, no, first petitioner is died, my lord, on 21/2020.
Counsel for the petition submit that the first petitioner is expired. And in this regard, a memo has been filed. Memo dated 4/4/2024 has been filed enclosing the death certificate of the first petitioner. Same is taken on record. Petition in respect of petition number 1 is dismissed as abated. Released on 23rd April.
They extend the interim order.
Interim order earlier granted is extended.
My lord, can I interrupt your lordships for a minute? My lord? There's some grave urgency. That's the reason why I'm troubling your lordships. My lord. This is the excise matter, my lord. It normally would have come before his lordship, Justice Hemant Chandan Gowda, but he's not sitting today.
Yes.
Therefore, my lord, I apologize for interrupting your lordship's list. My lord,
A colleague did mention in the
my lord,
morning.
what has happened? My lord, since morning, there has been a big problem. My lord, what has happened, my lord, is factory worth 98 crores.
Raghavan, we will also be raising at 3 o'clock because
No,
we have to take a flight.
All that I want to.
So we won't be.
No, I understand. Lord, all that I wanted. Lord, even if a notice is ordered on my petition, if I'm able to convince your lordships, which I'm confident, my lord, I'll be able to.
Notice will order.
That will put the fear of God. Or when I say God, your vision.
Only notice 2:30.
That's all. My lord, I'm not, in fact, I understand my ex parte order in a matter of because I will not even press. Great. So
2:30 will take.
Lord, I apologize for.
Only for notice.
Yes, Lord, yes, yes.
Yes.
Grateful, Lord. I'm sorry, my lord, I apologize also.
Serial number 45. M.R. Nanjita Gowda.
Petitioner.
Respondent number 1.
Lord, criminal revision petition 3/2017 district court Kolar allowed, my lord, on 22/6/2018, my lord.
3 of 2017 allowed. ಅದನ್ನೇ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು.
Challenge before the court, my lord.
ಅದೇ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು.
Filed our synopsis. I have filed our synopsis.
You filed a filing.
We have filed.
You filed. Ready na?
Ready.
Argument ready na?
Ready.
ಹೇಳಿ.
I am not the accused, my lord. Trial court, I am not the accused, my lord. Respondent number 1 is that trial court is accused number 2, my lord. Offense under section 353 and 502.
Not the accused.
No, I am not accused.
ಮತ್ತೆ ಇನ್ನೇನಕ್ಕೆ ಬಂದಿದೆ?
Trial court proclamation issue ಆಗಿದೆ, respondent number 1. After proclamation issued, land is action before public action. Amount is purchased the petitioner, my lord. Public action le ತಗೊಂಡಿದ್ದಾರೆ petitioner. Court order ಪ್ರಕಾರ public action 60,000 paid amount and received after filed by the respondent number 1 filed by trial court. I am not the accused. Trial court by mistake ಗೋವಿಂದ ಬೇರೆ ಗೋವಿಂದಪ್ಪ ಬೇರೆ, ಅದರಿಂದ ನಮ್ಮ ಪ್ರಾಪರ್ಟಿಯಿಂದ ಪ್ರೊಕ್ಲಮೇಶನ್ ಇಶ್ಯೂ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಪ್ರಾಪರ್ಟಿ ಆಗಿದೆ, ಅದರಿಂದ ನಾವು ಎಂಟೈರ್ ಅಮೌಂಟ್ ವಾಪಸ್ ಕೊಡ್ತೀವಿ, ನಮ್ಗೆ ಇದು ಮಾಡಿ ಅಂತ ಇದು ಮಾಡೋರು. I before the challenge in the revision petition allowed.
Accused Govinda. He was absconded. His property was brought for sale. You purchased
ಮಾಡಿ.
Now applicant respondent number 1 is claiming that the property belongs to respondent number 1.
Respondent number 1
and not to respondent number 2.
Respondent number 2.
Property ಯಾರ ಹೆಸರಲ್ಲಿದೆ?
Respondent number 1 ಹೆಸರಲ್ಲೇ ಇದೆ.
ಮತ್ತೆ ಹೆಂಗ್ ಸೇಲ್ ಮಾಡಕ್ಕಾಗಲ್ಲ?
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ರಾಂಗ್ ಇದಾಗಿದೆ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಸಮನ್ಸ್ ಇಶ್ಯೂ ಮಾಡಿದಾಗ ಪ್ರೊಕ್ಲಮೇಶನ್ ಇಶ್ಯೂ ಬೈ ರಾಂಗ್ ರೆವಿನ್ಯೂ ಅಥಾರಿಟಿ ಇದು ರಾಂಗ್ ಮಿಸ್ಟೇಕ್, ಅದರಿಂದ ಎಂಟೈರ್ ಅಮೌಂಟ್
ರಿಸೀವ್ ಮಾಡಿ ಇದು ಮಾಡಿ ಅಂತ ಚಾಲೆಂಜ್ ಮಾಡಿ
You
ಬಟ್
will have-
ನಮ್ ಕಂಟೆನ್ಷನ್ ಪ್ರಾಪರ್ಟಿ ಆಲ್ರೆಡಿ 2 years ನಾವ್ ಇದು ಮಾಡಿ ಡೆವಲಪ್ ಮಾಡಿದೀವಿ. ನಾವು
ಏನ್ ಡೆವಲಪ್ಮೆಂಟ್ ಮಾಡಿದೀರಾ?
ಬೋರ್ ಎಲ್ಲ ಹಾಕಿದೀವಿ, ಡೆವಲಪ್ ಎಲ್ಲ ಮಾಡಿ ಇದು ಮಾಡಿದ್ವಿ ನಾವು ಅಗ್ರಿಕಲ್ಚರ್.
ಬರೀ ಬೋರ್ ಹಾಕಿದೀರಾ?
ಹೌದು. ಅದರಿಂದ 60,000 ನಾವು ಆಲ್ರೆಡಿ 2 years ಡೆವಲಪ್ ಮಾಡಿ ಇದು ಮಾಡಿದೀವಿ.
ಅಲ್ಲಪ್ಪ, ಬೇರೆ ಯಾರ್ದೋ ಪ್ರಾಪರ್ಟಿ ನೀವ್ ಹೆಂಗ್
ಅಲ್ಲ,
ಪರ್ಚೇಸ್
ನಾವು ಕೋರ್ಟ್ ಆರ್ಡರ್ ಪ್ರಕಾರ ನಾವು ತಗೊಂಡಿರೋದು ಸ್ವಾಮಿ. ಕೋರ್ಟ್ ಆರ್ಡರ್ ಪ್ರಕಾರ
ಮಾಡಿದ್ರೆ
ಅಟ್ಯಾಚ್ಮೆಂಟ್
ಇಟ್ ಕೆನಾಟ್ ಎಫೆಕ್ಟ್ ದಿ ಒರಿಜಿನಲ್ ಓನರ್.
ಅವ್ರು
ಎಫೆಕ್ಟ್ ದಿ ಒರಿಜಿನಲ್ ಓನರ್.
ಲಾಂಗ್ ಟರ್ಮ್ ಬಂದಿಲ್ಲ ಅಂತ ಇದು ಮಾಡ್ತಾರೆ. ನಾನು ಅಕ್ಯೂಸ್ಡ್ ಅಲ್ಲ ಅಂತ ಟ್ರಯಲ್ ಕೊಡಲ್ ಕಂಡೀಷನ್.
ನೀವ್ ಅಕ್ಯೂಸ್ ಬೇಕಾಗಿಲ್ಲ, ನೀವು ಪರ್ಚೇಸರ್.
ಹೌದು, ಪರ್ಚೇಸ್ ನಾವು ಗೌರ್ಮೆಂಟ್ ಪ್ರಕಾರ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಪ್ರಕಾರ ನಾವು ತಗೊಂಡಿದ್ದೀವಿ.
ನೀವು ಬರೀ ಎರಡನೇ ರೆಸ್ಪಾಂಡೆಂಟ್ ಪ್ರಾಪರ್ಟಿ ತಗೊಳಕ್ಕೆ ಅರ್ಹರು.
ಹೌದು.
ಕೋರ್ಟ್ ಸೇಲ್ ಮಾಡೋದು ಬರೀ ಎರಡನೇ ರೆಸ್ಪಾಂಡೆಂಟ್. ಕೋರ್ಟ್ಗೂ ಪವರ್ ಇರ್ಲಿಲ್ಲ ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಪ್ರಾಪರ್ಟಿ ಸೇಲ್ ಮಾಡಕ್ಕೆ. ಇತ್ತ ಯಾರ್ದಾದ್ರು ಪ್ರಾಪರ್ಟಿ ಸೇಲ್ ಮಾಡಕ್ಕಾಗತ್ತಾ ಕೋರ್ಟ್ಗೆ? ಬರೀ ಅಬ್ಸ್ಕಾಂಡರ್. ಯಾರು ಅಬ್ಸ್ಕಾಂಡರು? ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್. ಅದಕ್ಕೆ ಸೇಲ್ ಮಾಡ್ಬೋದು. ಬಟ್ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಹೆಸರಲ್ಲಿ ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಲ್ಲಿ ಇರೋ ಪ್ರಾಪರ್ಟಿ ಮಾಡಕ್ಕಾಗತ್ತಾ?
ಮಾಡಕ್ಕಾಗಲ್ಲ. ಬಟ್ ಕೋರ್ಟ್ ಮಿಸ್ಟೇಕ್ ಇಸ್
You can claim, you'll reserve your right to claim damages. You claim against the revenue department, against the court. File a suit. If the court has committed a mistake, they'll have to pay for it.
ಲಿಬರ್ಟಿ ಟು
They'll reserve that liberty.
ಲಿಬರ್ಟಿ.
The mistake which has been committed, you are entitled.
Please, liberty.
And one more submission at para 6 of, page 6 of the synopsis, my lord.
Hmm.
Taking advantage of this pendency of criminal petition, this petitioner has filed a revenue appeal.
ಎಲ್ಲ ಹೋಗುತ್ತೆ.
And there he is claiming that since petition is pending, he is taking entry, has trying to take entry on.
He was entitled to on the basis of the sale, but once we set it aside, he won't be. Third, petitioner is before this court seeking for the following reliefs. On 18/8/1997, one S. Hanumantappa, District Manager, Karnataka SC/ST Development Corporation, Kola, had filed a complaint against Shankar and Govinda of Gangara Narsanalli village, Srinivaspura Taluk. In furtherance of which, crime number 98 of 1997 was registered by the Gulpet Police for offences under section 354, 504, 506, read with 34 of the IPC. On investigation, charge sheet and CC number 133 of 02 was filed. Bail, non-bailable warrant was issued against accused number 2, Govinda therein, who could not be secured. Therefore, proclamation having been issued on 6/8/2003, he was proclaimed as absconder on 1/3/2004. Notice having been issued to the village accountant seeking for details of movable and immovable properties of the said Govinda. The village accountant on 11/8/2004 had produced RTCs to evidence that accused number 2 was owning property bearing survey number 81. They said Govinda, accused number 2, was owning property bearing survey number 81/P8 to an extent of 2 acres situated at Gangarasanalli, Olur Obli, Kolar Taluk. The said property therefore was brought for public auction when the petitioner purchased the same for a sum of rupees 60,000 on 25/1/2005. The petitioner claims that the petitioner has developed the property by sinking a bore well and carrying out agriculture activities. In the meanwhile, respondent number 1 filed an application under section 148 of the CRPC in CC number 133 of 02 contending that the land belonging to him has been, the land in survey number 81/P8 belongs to him, which has been unauthorizedly and illegally auctioned, thereby depriving the true owner of the said property taking into consideration the said contention and the documents that have been produced by respondent number one, the ಯಾವತ್ತು ಅಲೋ ಆಯ್ತದು
Application allowed on 20.
DC 1333. The said application
Allowed on 31/12,
came to
2016.
be rejected
31/12/16, my lordship.
by order date 31st December 2016 on the ground that the application is barred by time and unsustainable. Challenging said order, a revision petition under section 397 was filed in criminal revision petition number 3 of 2017. ಯಾವುದು 3 of 2017 or 6 of 2017?
3 of 2017.
3 of 7.
3 of 2017.
Yes.
ಅಲ್ಲ 3 ನೀವು ಹಾಕಿದ್ರು ಡಿಸ್ಮಿಸ್ ಆಯ್ತಲ್ಲಪ್ಪ.
ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ಅವ್ರು ಚಾಲೆಂಜ್ ಮತ್ತೆ ರಿವಿಷನ್ ಚಾಲೆಂಜ್ ಮಾಡೋದು.
ಯಾವ್ದ್ರಲ್ಲಿ?
ಅದೇ ಆರ್ಡರ್ನ ಚಾಲೆಂಜ್ ಮಾಡೋದು.
ಯಾವ ಪೆಟಿಷನ್ ಅಲ್ಲಿ? 3 of 2017.
3 of 17.
3 of
Filed by respondent number 1.
ಏನಾಯ್ತದು?
That has been allowed
When?
Remanded back.
on
22/6/2018.
22/6/2018.
Page number?
17 daughter. Sir, could you-
On 22/6.
2018, my lord.
18.
2018.
Yes, ma'am.
Allowed the same on 22/6/2018. The order passed by the Principal Senior Civil Judge and CJM Kolar and CC number 1333 of 2002 dated 31/12/2016 was set aside. The revenue authorities were of Gangasarnalli village, Holu Robli, Kolar Taluk were directed to rectify the revenue entries in the name of respondent number 1 herein. And the amount of rupees 60,000 paid by the petitioner was directed to be returned to the petitioner herein, who is the purchaser, within 30 days of the order. This challenge is same, the petitioner is before this court. The contention of learned counsel for the petitioner is that the petitioner has acted upon a public notification issued by the court, has participated in a public auction and been declared as a successful auction purchaser, in furtherance of which the necessary amounts have also been paid. Thus, the petitioner having acted in a bona fide manner on an application filed by respondent number 1, the petitioner cannot be deprived of the property which the petitioner has purchased in a public auction. Learned counsel for respondent number 1 would submit that the property belonging to respondent number 1, the court could never have auctioned the said property. Respondent number 1 being the owner of the property was never in the know of the said auction or the sale. As soon as respondent number 1 came to know about it, necessary applications had been filed. And as such, the right of respondent number 1, ownership right of respondent number 1 cannot be disturbed. And on this ground, she submits that the order passed by the trial court, by the revision court, is proper and correct and does not require any interference. Heard so and so produced papers. Admittedly, it is the second respondent, Govinda, who was an accused who had been declared an absconder, proclaimed an absconder, and it is his property which were required to be brought on sale in CC number 1333 of 2002. The trial court having called upon the village accountant to furnish the details of the property, the village accountant has furnished the details of the property bearing survey number 81/P8 of Gangasaranalli village, Kolar Taluk, as that belonging to Govinda, the accused therein, when in fact the said property belongs to B.V. Govindappa, respond number 1 herein. Though there may be a similarity in the name of the proclaimed offender and the owner of the land, inasmuch as the proclaimed offender is known as Govinda and the owner of the land is known as B.B. Govindappa, there are various other details which are required to be ascertained and verified, including the father's name, address, etc., before the village accountant would have given any report as regards the ownership of the property in the name of the proclaimed offender. The powers of sale of a property of a proclaimed offender being drastic, it is required that these powers are exercised in a proper manner, in a proper and bona fide manner, by verifying and ascertaining all the details so that no third party is caused any inconvenience or injury. In the present matter, though the property belonged to B.V. Govindappa, the same was brought to auction as that belonging to the proclaimed offender Govinda, thereby seeking to deprive the ownership of B.V. Govindappa, who was the true and lawful owner of the property. The contention of the counsel for the petitioner also cannot be lost sight of. The petitioner had nothing to do with the village accountant having submitted his report and the property having been brought for auction by the court. The petitioner, in a bona fide manner, participated in the auction, bid the market value, was declared the successful purchaser, paid the amounts due thereon, bid thereon, and a sale deed was executed in favor of the petitioner. The petitioner also claims to have dug a borewell and improved the land after having received the sale of the property. He submits that in the interregnum, the property value is also corner, which the petitioner would be deprived of on account of the sale being set aside and the revenue entries being corrected in the name of Sri B.V. Govindappa. All these submissions are also true and correct and have to be given due credence. However, the interest of B.V. Govindappa in the property being ownership rights cannot, as aforesaid, be sold on account of Govinda being a proclaimed offender. In that view of the matter, I pass the general directions. In order to general direction better. In that view of the matter, I pass the following order. The petition stands dismissed. Liberty is however reserved to the petitioner to submit necessary representation to the Principal Chief Judicial Magistrate Kolar, placing on record the details of expenses which have been incurred by the petitioner for sinking of the borewell along with supporting documents, the payment of stamp duty and registration fee thereon, etc., which shall be considered, and an order passed by the said court directing payment of the amount, payment of compensation towards these losses which have been caused. In the event of any of the representation and or request of the petitioner being disregarded or dismissed by the said court, the petitioner would always be at liberty to file necessary suit seeking for damages, which shall be considered on merits. In the event of the Principal Chief Judicial Magistrate being of the opinion that any loss has been caused and directing payment of such losses, the state shall ensure such payments are made in view of the losses have been caused on account of negligent act of the village accountant. Liberty is also reserved to the state to initiate such action as may be permissible under law against the village accountant for such delinquency.
Serial number 48. Harish Bandari.
Can I ask, secure loss after vacation? ಒಂದು ಮೆಟೀರಿಯಲ್ ಬೇಕಾಗಿತ್ತು ಒಂದು ಒರಿಜಿನಲ್
ಅದೇ.
ಸೂಟ್ ಒಂದು ಏನಾಯ್ತು ಅಂತ ಬಿಕಾಸ್ ಫ್ಯಾಮಿಲಿ ಡಿಸ್ಪ್ಯೂಟ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಸೂಟ್ಸ್ ಆರ್ ಪೆಂಡಿಂಗ್ ಅಂಡ್ ಪಾರ್ಟಿಷನ್ ಹ್ಯಾಸ್ ಬೀನ್ ಟೇಕನ್ ಪ್ಲೇಸ್
ಏನ್ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ತಾ ಇದೀರಾ ಏನ್?
ಇಲ್ಲ ಇಲ್ಲ
My lord, ಇದು CCS 72 ಅಲ್ಲಿ in SC number 1088/2017 accused absconding, my lord.
ಅಕ್ಯೂಸ್ ಅಬ್ಸ್ಕಾಂಡಿಂಗ್.
Yes, my lord. ಇವರು ಶ್ಯೂಟಿ ಕೊಟ್ಟಿರ್ತಾರೆ my lord, ಆ ಶ್ಯೂಟಿನೇ ಇಲ್ಲಿ ಇದು
ಹೌದು. ಇಲ್ಲ ಫ್ಯಾಮಿಲಿ ಡಿಸ್ಪ್ಯೂಟ್ ಅಂತ ಇದ್ದಾರೆ.
ಶ್ಯೂಟಿ
ಇಲ್ಲ
46 sir.
49
49.
48.
48.
This case, your lordship, is a family dispute, your lordship, partition suit was, the RAP is also pending before this court now.
447, 379.
Yes.
ಏನ್ ಸೆಟಲ್ಮೆಂಟ್ ಇದೆಯಾ?
ಇಲ್ಲ ಸೆಟಲ್ಮೆಂಟ್ ಅಂದ್ರೆ ಫ್ಯಾಮಿಲಿ ಒಳಗಡೆ ಮಾಡ್ಕೊಂಡಿರೋದು ಬಿಕಾಸ್ 7 ಜನ ಅಣ್ಣ ತಮ್ಮಂದಿರು 7 ಜನ ಅಣ್ಣ ತಮ್ಮಂದಿರು ಪ್ಲಸ್ ಹೆಂಡತಿ ಎಲ್ಲ ಸೇರ್ಕೊಂಡು
The
ಪರ್ಚೇಸ್
request of counsel for the petition relist on 7 June. Interim order earlier granted is extended till next date.
49.
For us, for the petition counsel in this case, please, Manoj. For us, the matter arises under the Legal Metrology Act, please, Manoj.
Yes.
The petitioners are the manufacturers of electronic goods.
Hmm.
For us, in the name of
Yeah, who appears? Ready?
ಸ್ವಲ್ಪ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಲ್ಲ
Karnataka.
ಹೇಳಿದ್ದೀನಿ tomorrow
ಬಂದ್ಮೇಲೆ ಅವ್ರನ್ನ ಕೇಳ್ಬೇಕಾಗತ್ತೆ ರೆಡಿನಾ ಅಂತ.
28 ಮೇಲೆ ಶಾರ್ಟ್ ಡೇಟ್
ಯಾವಾಗ ರೆಡಿ ಆಗ್ತೀರಾ?
10 ಮೇಲೆ 10 10ನೇ ತಾರೀಕು
10ನೇ ತಾರೀಕು. At the request, though counsel, senior counsel for the petitioner is present and ready to address argument, Learned HCGP seeks for a short accommodation to get ready and address his argument. Relist on 11 June, interim order earlier granted is extended.
please.
Serial number 50. Akram Pasha.
None appears for the petitioner today also. It appears that the petitioner is not interested in prosecuting the matter. Petition is dismissed for non-prosecution.
Serial number 51 adjourned. 52. Siddhartha HM.
previous date or not of non-appearance of for the petitioners, my lord. Petitioner and respondent number 2.
In status ಏನಿದೆ?
My lord.
Status ಏನಿದೆ?
Status ಅದು ಬರ್ತಾ ಇಲ್ಲ ಮಂತ.
FIR. Interim order ಏನಿಲ್ಲ, FIR ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು. 2018 ಅಲ್ಲಿ ಇಷ್ಟೊಳಗೆ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿರ್ಬೇಕಲ್ಲ, ಇಲ್ಲ ಬಿ ರಿಪೋರ್ಟ್ ಆಗಿರ್ಬೇಕು. ಇವರಂತೂ ಬರ್ತಾನೆ ಇಲ್ಲ. None appears for the petitioner today also. It appears that the petitioner is not interested in prosecuting the matter. Petition is dismissed for non-prosecution.
53. B. Latif.
Petitioner notice to respond number 2 dispensed with.
My lord,
Who is
AMFC
respondent?
at Koppa, my lord, in CC number 401/2018, my lord, committed to the district court of Chikmagaluru. Committed ಆಗಿದೆ.
Commit ಆಗಿದೆ.
Yes, ma'am.
You can still challenge.
27/10/2018, ma'am.
Commit ಆದ್ರೇನು the petition will be
That
made.
is committally so far as way 1 and 2 is concerned. I have the charge note of the committal. So far as this petitioner is concerned, Lord, still the pending before.
You're
the magistrate.
challenging the charge sheet.
Please. Lord, the case of the prosecution,
Who is respond number 2? Why is notice dispensed?
the original complainant,
Notice ಹೆಂಗ್ dispense ಆಗದಪ್ಪ? Complaint ಹೋಗ್ಬೇಕಲ್ಲ notice. We have to issue
the
notice.
allegation that I'll narrate.
Yavudidranu, they have to be heard if they want to come. If they don't want to come, fine. But we can't dispense with notice. Issue notice to respond number 2, returnable by 18th June.
Interim order.
Interim order earlier granted is extended till next.
Serial number 54, adjourn, 55. Prasad BS.
Twenty-one Narmal Bandilla. None appears for the petitioner, released on 11th June.
Serial number 56, adjourn, 57. Praveen Kumar K. and Sandeep Patel.
Lords, the serial number 57, my lord, is ended up in acquittal. So maybe
Did in acquittal.
acquittal by
So-
judgment dated 17/6/23. So maybe dismissed.
Acquittal of accused number 2.
How soon?
Petitioner is before this 57. Petitioner is before this court seeking for the following relief. That counsel for the petitioner submit that by way of order dated
17/6/23, man.
76/2023 passed by the 11th additional CM Bangalore.
Yes.
The proceedings have ended up in the accused number 3 as accused number 2
ಅಲ್ಲ ಇದು
petitioner.
ಕನೆಕ್ಟ್ ಅಲ್ಲ ಅದು ಯಾಕೋ ಕನೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. Other matter is not connected.
The accused number 2 petitioner has been acquitted.
Acquitted.
Placing on record his submission, the petition is dismissed as infructuous.
Other matter, my lord, it is not a connected matter. I need 2 weeks time, my lord, for that.
57.1.
It's not a connected one.
ಯಾಕೆ ಬಂತು?
ಅದೇ ಬೇರೆ ಕ್ರೈಮು ಇದೆ ಬೇರೆ
Last date ಅಲ್ಲಿ
connected ಅಂತ
ಅನ್ಕೋತೀನಿ.
ಇದು ಮಾಡಿದ್ದಾರೆ madam.
It's a totally different case, man. Number ಹತ್ರ ಹತ್ರ ಇದೆ ಅಂತ ಕನೆಕ್ಟ್ ಮಾಡ್ತಾರೆ ಅನ್ನೋದು.
Registry is directed to connect the above matter with 8813 ಅಂತ submission ಯಾರೋ ಮಾಡಿದ್ದಾರೆ.
ಇಲ್ಲ ನಾನು ಮೇಬಿ
57 ಇನ್ಯಾವುದು connected 8814 ಗೆ ಏನಾದ್ರು connected ಇದೆಯಾ?
ಇಲ್ಲ ಇಲ್ಲ
ಯಾವುದು ಇಲ್ವಾ?
ಇಲ್ಲ 1880 connect ಇದೆ.
Mistake, it has been
It's
connected,
one
my lord.
case, my lord.
In this case, I appear for the
The state case only the one
complainant,
case.
respondent number
ಅಲ್ಲ,
2.
ಇನ್ನೇನಾದ್ರು connected matter
ಯಾವ್ದು ಇಲ್ಲ
ಇದೆಯಾ?
sir.
ಯಾವುದು ಇಲ್ವಾ? So ಇನ್ನೇನ್ connect ಮಾಡೋದು ಬೇಕಾಗಿಲ್ಲ.
No.
57.1 learned counsel for the petition seeks for and is granted 4 weeks time to get ready and address arguments, released on 11th June.
Interim order. maybe.
Interim order earlier granted is extended till next date.
Grateful.
Number 58, adjourn, 59. MS Venugopal.
ಬರ್ತಾ ಇದಾರಾ?
ಬರ್ತಾ ಇದೆ.
None appears for the petitioner today. If none were to appear for the petitioner next date, dismissal released on 11 June.
Serial number 60, Satish TS.
Same 11 June.
61, L Ballesh.
For the petitioners,
Hmm.
this petition, my lord, is filed challenging the charge sheet filed by the first respondent. Because it's the petition, my lord.
Yes.
In this case, my lord, the wife of the petitioner has purchased a property bearing survey number 62/4.
Wife of the petitioner.
Petitioner, my lord. From one HB Govindaraju, who in turn purchased the said property from the parents and brother of the second respondent, my lord. Under a registered said deed dated 24/6/2006, my lord. Petition by purchased on 6/6/2007, my lord. And subsequently, the second respondent has filed a suit against the wife of the petitioner and others invoice number 938/2014, my
The
lord.
father and mother and brother of the complainant sold it to HV Govindraju.
Please, my lord.
Who sold it to
The
your wife.
precious wife, my lord. And in fact, because the property was sold even on behalf of the second respondent also, my lord. At that time, she was a minor.
Minor.
Subsequently, she filed a suit against her parents and also the wife of the petitioner, my lord, for partition invoice number 938/2014. And the said suit is being contested by the wife of the petitioner, my lord. And the said suit still pending, my lord. When that being the case, my lord, on 1/5/2018, the second respondent has given a past complaint against the petitioner, my lord. The husband of the second petitioner is working in police department, my lord. For the offense punishable under 341, 504, 506, and 448, my lord.
Suit in
Suit of 2014, my lord.
14.
Complaint is given in the year 2018 when the suit is pending.
18. Sale is of the year 2006.
Please, my lord. And the husband of the second respondent, my lord, is working in police department.
That is not. Really.
Please, my lord. Says given a past complaint against the petitioner, my lord. I may permit to read the complaint allegations, my lord. It is at page 30, type copy is at page 35, my lord.
Yes.
ಈ ಮೂಲಕ ತಮ್ಮಲ್ಲಿ ಕೋರುವುದೇನೆಂದರೆ ನನ್ನ ತವರು ಮನೆಯಾದ ಹೊಸಕೋಟೆ ತಾಲೂಕು ಕಾಚರನಹಳ್ಳಿ ಗ್ರಾಮವಾಗಿದ್ದು ನಮ್ಮ ಪಿತ್ತರಾಜಿತ ಸ್ವತ್ತಾದ ಕಾಚರನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 48 ಮತ್ತು 62/4 ವಿಚಾರವಾಗಿ ನಾನು ಭಾಗಾಂಶ ಕೋರಿ ಮಾನ್ಯ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ದಾವೆ ಹೂಡಿದ್ದು ವಯಸ್ ನಂಬರ್ 938/2014 ರಲ್ಲಿ ವಿಚಾರಣೆಯಲ್ಲಿರುತ್ತದೆ. ಈ ದಿನಾಂಕ 1/5/2018 ರಂದು ಬೆಳಿಗ್ಗೆ ಸುಮಾರು 11:30 ಗಂಟೆಯಲ್ಲಿ ನಾನು ಮನೆಯಲ್ಲಿ ಒಬ್ಬಳೇ ಇದ್ದಾಗ ನನ್ನ ಗಂಡನು ಮನೆಯಲ್ಲಿ ಇಲ್ಲದ ಸಮಯ ನೋಡಿ ನಮ್ಮ ಕೇಸಿನ ಪ್ರತಿವಾದಿಗಳಾದ ಶ್ರೀ ಕೃಷ್ಣಪ್ಪ ಎಂಬುವರು, ಇನ್ಫ್ಯಾಕ್ಟ್ ಈಸ್ ನಾಟ್ ಅ ಪಾರ್ಟಿ ಬಿಫೋರ್ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಇನ್ ದಟ್ ಸೂಟ್, ಮೈ ಲಾರ್ಡ್. ಕೃಷ್ಣಪ್ಪ ಎಂಬುವರು ಏಕಾಏಕಿ ನಮ್ಮ ಮನೆಗೆ ಅತಿಕ್ರಮ ಪ್ರವೇಶ ಮಾಡಿ ನನಗೆ ನೀನೇನ ದೀಪಿಕಾ ನಮ್ಮ ಮೇಲೆ ಕೇಸ್ ಹಾಕಿರುವುದು ನಿಮ್ಮ ಅಪ್ಪ ಮಾರಿ ಆಗಿದೆ, ನೀನು ಒಳ್ಳೆ ಮಾತಿನಿಂದ ನಾನು ತಂದಿರುವ ನೋಟಿಸ್ ಪತ್ರಕ್ಕೆ ಸಹಿ ಹಾಕು, ಇಲ್ಲವಾದರೆ ನಿಮ್ಮ ಮತ್ತು ನಿಮ್ಮ ತಾಯಿಯ ಕುಟುಂಬದವರಿಗೆ ಒಂದು ಗತಿ ಕಾಣಿಸಿ ಜಮೀನನ್ನು ಹೇಗೆ ಪಡೆಯಬೇಕೆಂದು ನನಗೆ ಗೊತ್ತು ಎಂದು ಬೆದರಿಕೆ ಹಾಕಿದರು. ಆಗ ನಾನು ನನ್ನ ಗಂಡ ಬಂದ ನಂತರ ಮಾತನಾಡಿ ಎಂದು ಹೇಳಿದ್ದಕ್ಕೆ ಬಲವಂತವಾಗಿ ನನ್ನ ಕೈ ಹಿಡಿದು ಎಳೆದಾಡಿ ಸಹಿ ಮಾಡಿಸಿಕೊಳ್ಳಲು ಪ್ರಯತ್ನ ಪಟ್ಟರು. ಆಗ ನಾನು ಕಿರಿಚಿಕೊಂಡಾಗ ನನ್ನ ಅತ್ತೆ ಶ್ರೀಮತಿ ಸುಶೀಲಮ್ಮ ಮತ್ತು ನನ್ನ ನಾದಿನಿ ಆದ ಶ್ರೀಮತಿ ಕೀರ್ತನರವರು ಬಂದು ನನ್ನನ್ನು ರಕ್ಷಣೆ ಮಾಡಿದರು. ನಾನು ಈ ವಿಚಾರವನ್ನು ನನ್ನ ಗಂಡನಿಗೆ ಫೋನ್ ಮಾಡಿ ತಿಳಿಸಿದ್ದೆ. ನನ್ನ ಗಂಡ ಕೃಷ್ಣಪ್ಪನವರಿಗೆ ಫೋನ್ ಕೊಡು ಎಂದು ಹೇಳಿದಾಗ ನಾನು ಹೋಗಿ ಫೋನ್ ಕೊಡುವಷ್ಟರಲ್ಲಿ ನಾನೇ ಮಾತನಾಡುತ್ತೇನೆ ಎಂದು ಹೇಳಿ ನನ್ನ ಗಂಡನ ಮೊಬೈಲ್ ನಂಬರ್ ಅನ್ನು ಪಡೆದು ನನ್ನ ಗಂಡನಿಗೆ ಕರೆ ಮಾಡಿ ಬಾಯಿಗೆ ಬಂದಂತೆ ಬೈದು ನಿನ್ನ ಮೇಲೆ ಪಿಟಿಷನ್ ಹಾಕಿ ನಿನ್ನ ಕೆಲಸಕ್ಕೆ ತೊಂದರೆ ಕೊಡುವುದಾಗಿ ಮತ್ತು ನಿನ್ನ ಕೈಕಟ್ಟಿ ನೇರಿಸುವುದಾಗಿ ಮಾಡುವುದು ಹೇಗೆಂದು ನನಗೆ ಗೊತ್ತು ಎಂದು ಏರು ಧ್ವನಿಯಲ್ಲಿ ಮಾತನಾಡುತ್ತಾ ಕಾರಿನಲ್ಲಿ ಹೊರಟು ಹೋಗಿರುತ್ತಾನೆ ಮತ್ತು ನನಗೆ ಸಹಿ ಮಾಡುವಂತೆ ಅಡ್ಡ ಹಾಕಿರುತ್ತಾನೆ. ಈತ ನೋಟಿಸ್ ಅಥವಾ ಇತರ ಯಾವುದೇ ಸರ್ಕಾರಿ ವಕಾಲತನ್ನು ವಕೀಲರ ಮುಖಾಂತರವಾಗಲಿ ಅಥವಾ ಸರ್ಕಾರದಿಂದ ಯೋಜಿಸಲ್ಪಟ್ಟ ಸಿಬ್ಬಂದಿಯಿಂದಾಗಲಿ ಜಾರಿ ಮಾಡದೆ ತಾನೇ ಏಕಾಏಕಿ ಹೆಣ್ಣು ಮಗಳಿಂದ ನೋಡದೆ ನನ್ನ ಮೇಲೆ ದೌರ್ಜನ್ಯ ಮಾಡುತ್ತಾನೆ. ಅಲ್ಲದೆ ಈತನಿಂದ ನಮ್ಮ ಮತ್ತು ನಮ್ಮ ತಾಯಿಯ ಕುಟುಂಬದವರಿಗೆ ಪ್ರಾಣ ಭೀತಿ ಇರುವುದರಿಂದ ನಮಗೆ ರಕ್ಷಣೆ ಕೊಡಬೇಕೆಂದು ಹಾಗೂ ಈತನ ಮೇಲೆ in this case, Your Honor, I see in the charge sheet, the first 7 witnesses have been cited, my lord. First witness is the complainant. Second witness is none other than our mother-in-law. Third witness is our sister-in-law. Fourth witness is our husband. And the other 2 witnesses are mother witnesses.
Yes.
All relatives of the second respondent, my lord. No independent witness.
Suit was filed in 2014 and 2018.
Please, my lord. When the suit is pending and that is being contested by the wife of the petitioner, my lord, before the trial court, that is pending. And she is given a past complaint, my lord.
Yes. Petitioner is before this court seeking for the following reliefs. Respondent number 2 had lodged a complaint on
1/5/2018,
1/5/2018 with the Hoskote police station, on which basis crime number 238 of 2018 was registered for offences under section 341, 504, 448 and 506. The essential allegations made in the said complaint by respondent number 2 was that when respondent number 2 was at home, the petitioner against whom she had filed OS number 938 of 2014 as regards the property belonging to the family sold in his favor had barged into the house at 11:30 a.m., threatened her and her family with dire consequences, and called upon her to sign certain documents that he had got. At that stage, the mother-in-law of the complainant and the mother-in-law and sister-in-law of the complainant came to her rescue. She had called her husband and thereafter lodged a complaint. It is challenging the same. The petitioner, the investigation having been completed, a charge sheet came to be laid on 36/2018 for the aforesaid offences. Challenging the same, the petitioner is before this court. Learned counsel for the petitioner submits that the father, mother, and brother of the complainant had sold the property covered under survey number 62/4, measuring 1 acre 11 guntas, situated at Kacharkanahalli village, Jadgenahalli Obli, Hoskote Taluk, to one Shri H.V. Govindaraju by way of a registered sale deed dated 24/6/2006, who in turn sold the property to the wife of the petitioner, Mrs. Govindamma, by way of a registered sale deed dated 6/6/2007. A suit had been filed by the complainant in OS number 938 of 2014 seeking for partition. And it's in that background that a false complaint has been filed in the year 2018. His submission is that no such incident has occurred. The petitioner had never visited the house of the respondent, of the complainant. All the witnesses who have been arrayed, who have been shown in the charge sheet are relatives of the complainant. Taking into account the conspectus of the matter, the complaint being a false one, complainant's husband being in the police department, the petitioner has been harassed. Notice having been issued to respondent number 2, though she has been served, she has chosen not to enter appearance and make a submission. The factual matrix as detailed above would indicate that a sale by the father, mother, and brother of the complainant has occurred on 24/6/2006. The purchaser thereunder has sold it to the wife of the petitioner on 6/7/2007. 6/6/2007. As regards which a suit for partition has been filed in OS number 938 of 2014. In that background, when a suit has been pending from the year 2014, the complaint which has been filed on 1/5/2018 smacks of malafide and illegality, inasmuch as the allegation made therein are not supported by any independent witnesses but by the relatives of the complainant. The suit being pending where the civil dispute as regard the property is required to be resolved, a criminal twist is sought to be given to the civil disputes by lodging the aforesaid complaint. In that view of the matter, I pass the following order. Criminal petition is allowed. The proceedings in
CC number 7.
crime number 238 of 2018, registered with the Hoskote Police Station, now pending as CC number 712 of 2018, on the file of the Principal Civil Judge in JMFC Hoskote, Bangalore Rural District, I hereby quashed.
Serial number 62, K. Ravishankar.
Ravi Shankar. 498A. Any settlement has happened or? None appears for the petitioner. Relist on 11 June, interim order earlier granted is extended to next day.
63. Satish G.
None appears for either of the parties. Then SCGP is directed to ascertain the status of the matter before the trial court, released on 11th June.
64. Surya Narayana P.
The offence is under the Legal Metrology Act, my lords. In fact, it is covered by a decision of the coordinate bench. The requirement under the act is, my lords, they would issue a show cause notice, my lords.
Yaro, ready na?
Please.
First ready na? Ready. Ah,
Please, my lords.
ready.
My lords, if the show cause notice is noticed, my lords.
Hmm.
My lords, the notice
Page?
under section 48 is annexure E at page 63.
63.
63. It's, three soaps, my lords. Dove is a soap. Additionally, while mentioning the date, my lords, what is mentioned is 10/15. So October 2015 anta. But the legal metrology would say you can't show it as 10/15. You have to show it as 10/2015, 2015 anta. That is the offense. My lords, if this notice under section 48, my lords would get that. That's for compounding, my lords. Section 48.
The declaration made on the packages are not legible
Yes,
and
my lords,
prominent.
and
The
prominent. I will
wholesale
show it-
packet does
I'll
not
show it-
bear
Yes, my lords.
the legible, definite, plain and conspicuous declaration as to the total number of retail package contained or the net quantity in terms of standard units, weights, measurements. The above violation constitutes so and so.
But this changes in the complaint. I'll show that, my lords. In the complaint, they say those Dove, what was shown is 10/15. It should have been shown as
Where is that allegation in the
in the notice.
annexure E ಅಲ್ಲಿಲ್ಲ.
Notice alilla.
Annexure E ಅಲ್ಲಿ it does not bear the requirement ಅಂತ ಹೇಳ್ತಾರೆ.
E notice gave, we sought for time, my lords. Give us 15 days time to give a reply. My lords would get that at page 65. My lords, the requirement under the act would be, my lords, they have to pass an order, my lords, after issuing a show cause notice, whether they're permitting compounding or not. Because there's a right of
Compounding
appeal.
was not
No,
made
no.
available.
And we have a right of appeal against that.
Yes.
Now, instead of doing that, they would straight away file this private complaint. In this private complaint, my lords would get the private complaint as annexure A at page 22, my lords. Page 22. A3 is Hindustan Unilever. A4 is the
They
director.
sought for 15 days time to reply or compound.
Yes, my lords.
You did not compound.
Yes, my lords. They did not pass an order. Requirement is for them to pass an order, my lords, which we can appeal against. I will show that, my lords.
40?
My lords, 48 is the compounding section. 50 would be the appeal, my lords. So notice was issued under 48.
Yes.
50 may be noticed, my lords. Section 50.
So now what do you want to do? You want to compound or?
No, my lords, this complaint which has been filed, the complaint will be liable to be quashed on that score is what the coordinate bench has held, my lords. The coordinate bench says, if there is an provision for appeal, and if you have not passed an order, you can't set the criminal law in motion. My lords,
But do you want to compound?
Yes, my lords.
You had an option to compound.
Yes, my lords.
So you want to compound now.
We are
So compound it and pay some money. You can't go so scot free.
ಅಲ್ಲಲ್ಲ ಈಗ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಬೇರೆ ತಾವು ಈಗ ಶೋಕಾಸ್ ನೋಟಿಸ್ ನೋಡಿದ್ರಿ ಮೈ ಲಾರ್ಡ್
ಆಯ್ತು.
ಈಗ ಕಂಪ್ಲೇಂಟ್ ನೋಡಿ ತಾವು
Where is the complaint?
ಪೇಜ್ 22
Yes.
22 A3 and A4 my lords Hindustan Unilever and the director of Hindustan Unilever my lords would get that at page 22
Yes.
and then the offense my lords would notice in the complaint my lords what exactly is the offense. We would get that at page 25 in the bottom, my lords. Bottom only, assistant controller, my lords, you get that? 25 in the end only, bottom, my lords.
That is one.
That is so far as the Dove soaps, 10/15 was shown, it should have been 10/2015. And the next one is, my lords, 8 only, Neem active toothpaste, it was in a packet. So the packet outside also should have contained the provisions. But anyway, we are not concerned with Neem, we are only
That is
concerned.
somebody else.
Yes, my lords, we are concerned only with this. So what was shown in the show cause notice and what is shown in the complaint is different, my lords.
Don't say that clearly, but this is nothing. 15 andre yav, 15 cannot be 1915.
But normally, my lords, under
2015.
under legal metrology offences, which normally they find out are all these only, my lords. Now, my lords,
Inmele 2015 anta.
2015 ಹಾಕ್ಬೇಕಾಗಿತ್ತು, ನೀವು 15 ಅಂತ ತೋರಿಸಿದ್ರಿ.
Inmele haki anta.
My lords, just this.
Here the judgment of the court.
And also, it is not legible ಅಂತ.
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್
ಅವ್ರದಲ್ಲ ಅದು ಇದು
ಅದು
Neem active toothpaste of Jyoti Laboratories.
we are only concerned with the dough, which is a product of HUL. My lords, in this decision, my lords, my lords may kindly notice paragraph.
This is Supreme Court.
No, my lords, it's our court. Our
You
court
quoted a
decision.
Supreme Court.
Padal, sorry, my lords. Court.
Yes.
My lords, if my lords would notice, page 28, my lords, in that judgment. 28, the court commences with section 48, my lords. Page 28. only.
There is a reasoning.
Reasoning, I'll come to that, my lords. If my lords would kindly notice these two sections and then the reasoning, my lords, 28 only starts with 48.
Page 33. Okay.
Yes, my lords.
Third. Petitioner is before this court seeking for the following reliefs. Petitioner claims to be the directors of as a Hindustan. No, the first petitioner, who is accused number 3, is a company known as Hindustan Unilever Limited. The second petitioner is a director of the first petitioner, who has been arraigned as accused number 4. They are in the business of manufacture and sale of cosmetics. They're in the fast-moving consumer goods, including a soap sold under the name and style of Dove. The inspection of the premises of one of the
My lords, they did that inspection
the wholesaler or retailer,
at a retailer's place, my lords.
retailer,
Yes, my lords.
namely
He would be a stockist, my
Dayalal,
lords.
stockist.
Stockist.
Stockist
Annapurna
Dayalal.
agencies.
Illappa. Dayalal, son of Shankarlal Lucky Stationery Mart.
My apology, my lords. Inspector Dayalal, please, my lords.
Dayalal, son of Shankarlal
Chitradurga.
Lucky Stationery Mart, Navratna Building, Santapete, Chitradurga, had issued a show cause notice on 18/1/2016, alleging that the declaration made on the package is not legible and prominent and does not bear the legible, definite, plain and conspicuous declaration as to the total number of retail packages contained or the net quantity in terms of the standard units of weights, measures, or numbers. The petitioners replied to the said show cause notice on 5/4/2016, seeking for 15 days' time to reply to the said notice without providing an opportunity to do so. The respondent filed a complaint.
My lords, one edition, my lords. After we sought time, we replied, my lords. That reply, my lords, should get at 73, my lords.
Replied.
Yes, my lords, 26
Thereafter,
February
the petitioners
2016.
replied on
26th February 2016, my lords.
26th February
73.
2016. Even though a reply had been issued without passing any order, the petitioner respondent filed a complaint under section 200 of the CRPC, read with section 48 of the Legal Metrology Act, which came to be registered as PCR number?
CC number 133.
CC ಆಮೇಲೆ ಆಗಿದೆ PCR
PCR. Illana?
PCR number blank.
Yes, my lord. CC
Birth
number
body.
1338.
Before the Principal Civil Judge Junior Division JMFC at Chitradurga on 18/1/2016. Cognizance having been taken, the same came to be registered as CC number 1338 of 2016. Showing same, the petitioner is before this court. Now, counsel for the petitioner by relying Shri Sandeep Chautal and senior counsel standing counsel for the petitioner appearing for the petitioner by relying upon a decision dated 26th August 2021 in WP number 51116 of 2017 contained that once a show cause notice had been issued and a reply thereof having been submitted by the noticee, it was obligatory on part of the respondent to pass necessary orders so as to make available the appellate remedy under section 50 of the LM Act. No order having been passed, the petitioner has been deprived of appellate remedy and instead been forced to contest a criminal proceedings which could not have been issued without such an order having been passed. Having gone through the papers, it is clearly and categorically seen that no order has been passed subsequent to the reply submitted by the petitioners on 26/2/2016 to the show cause notice. The respondent has directly gone ahead and filed a criminal complaint which is not permissible or maintainable as held by the coordinate bench in the aforesaid decision. In that view of the matter, I pass the following order. Criminal petition is allowed. The proceedings in CC number 1338 of 2016 arising out of PCR number so and so pending on the file of the Principal Civil Judge Junior Division and JMS Chitradurga insofar as the petitioners who are accused number 3 and 4 therein are concerned are quashed. It is made clear that this court has not expressed any opinion as regards the other accused.
Deeply obliged.
Yes.
Serial number 60, my lord. I had just stepped out. I was here. I had just stepped out, but maybe taken number 230.
2:30, we are sitting only for half an hour. It's unlikely that we'll be able to take up their education matters. Interim order will be extended. All, ನೀವು ಇಲ್ಲ ಅಂದ್ರೇನು interim order extend ಆಗುತ್ತೆ.
Your lordship. Serial number 77, my lord. So, your lordship have done Monday after session for personal inconvenience.
77 will be after, now most of them will go after vacation. Except for further hearing.
Number 84 will, I think, may not reach because your
Ella will be adjourned.
ಸ್ವಲ್ಪ ಶಾರ್ಟ್ ಡೇಟ್ ಅವ್ರು
Short date.
ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ತಾ ಇಲ್ಲ, ಮುಗಿಸ್ಬಿಟ್ರೆ ಒಳ್ಳೇದು.
ಎಲ್ಲ ಜೂನ್ ಅಲ್ಲೇ ಹೋಗುತ್ತೆ.
ಅವ್ರು ಅದು ಬೇಡ, ಅದಕ್ಕೆ ಬೇಡ ಅಂತ ಅಷ್ಟೊಳಗೆ
ಯಾವುದು?
ಅಷ್ಟೊಳಗೆ ಅವರು ಕಾಂಪ್ರಮೈಸ್ ಸೀರಿಯಲ್ ನಂಬರ್ 84 ಅವ್ರು ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ತಾ ಇಲ್ಲ. ಅವ್ರು ಮಾಡಿರೋ ಚಾಲೆಂಜ್ ಮಾಡೋ ಚಾರ್ಜ್ ಶೀಟೇ ಬೇರೆ, ಅಲ್ಲಿರೋ ಚಾರ್ಜ್ ಶೀಟೇ ಬೇರೆ.
ಯಾವ್ದಿದು?
ಸೀರಿಯಲ್ ನಂಬರ್ 84 ಒಳಗೆ ಕೃಷ್ಣ ಭಟ್ ಅಂತ
ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದ್ಯಾ? ಶುರು ಆಗ್ಬೇಕಾ?
ಅವ್ರು ಶುರು ಆಯ್ತು. ಅವ್ರೇನು ತಾವ್ ಹೇಳಿದ್ರೆ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡೋಂಗಿದ್ರೆ ಮಾಡ್ಬಿಡಿ ಶಾಸ್ತ್ರಿಗಳ ಹತ್ರ ಅಂತ ಅವ್ರೇನು ಬರ್ತಾ ಇಲ್ಲ. ಲಾಸ್ಟ್ ಟೈಮ್ ನಾವು ಬರೋಕ್ ಮುಂಚೆ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಂಡು ಹೊರಟೋಗ್ಬಿಡಿದಾರೆ, ಇನ್ಫಾರ್ಮೇಶನ್ ಕೊಟ್ಟಿಲ್ಲ. ಡೇಟ್
ಕೊಡ್ತೀವಿ, ಎಲ್ಲ ಡೇಟ್ ಕೊಡ್ತಾರೆ.
ಯಾವ್ದಾದ್ರು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ಬಿಟ್ರೆ ಒಳ್ಳೆದು ಅಷ್ಟೇ.
ಎಲ್ಲ ಡೇಟ್ ಕೊಡ್ತಾರೆ, ನೋಡ್ಕೊಂಡು ಹೆಂಗೆ ಅಂತ ಮಾಡ್ತಾರೆ.
ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಟ್ಬಿಟ್ರೆ ಮುಗಿಸ್ಬೋದು.
Mallards entry matter.
ಎಲ್ಲ ಎಂಟ್ರಿ ಮಾಡಿ
Extend 60.
This afternoon, I think we'll only be able to take up education matters.
Non-appearance was noted. That's the reason.
Non-appearance,
Non-appearance was
ಯಾವುದು 50?
60, my lord.
60. At the request of the counsel for the petitioner adjourned.
My lord, serial number 91 was supposed to be heard at 2:30 in the afternoon, my lord. Mr. Krishnamurthy Hasigara appears for the petitioner in the other.
Although it may not be possible today.
Very well.
Will 91 relist on a check bounce alla?
ಹೌದು ಸರ್.
Relist on 16th at 2:30.
Very well. my lord.
One-
77.
65, 66,
66.
ಯಾವತ್ತು?
16th.
After ಎಲ್ಲ vacation.
Vacation. ಯಾವಾಗ?
ಮಾಡ್ತೀನಿ, entry ಮಾಡ್ತೀನಿ. 68,
68.
after vacation ಎಲ್ಲ. ಅದು ಅಷ್ಟೇ, after vacation.
68 after vacation.
ಬಿಡ್ರಾ, ಈಗ submission ಮಾಡ್ಬೇಕಿತ್ತು ಈಗ ಮಾಡಿದ್ರೆ 68.
Madam, 68 after vacation.
After
Interim order.
vacation, okay.
ಎಲ್ಲ
sir.
ಡೇಟ್ ಕೊಡ್ತಾರೆ.
69. ಇವಾಗ ಬೇಡ. After vacation. ಅಲ್ಲ ಈ ವೆಡ್ನೆಸ್ಡೇ ಎಲ್ಲ ರಜಾ. ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಒಂದು ವೆಡ್ನೆಸ್ಡೇ ಹಾಕ್ಬೇಕಾ? ನೋಡೇ ಬಿಡ್ತೀನಿ. ಯಾವ್ದಾದ್ರು ಸರಿನಾ? ಸರಿ ಹಾಕ್ತೀನಿ. 71, 72, 73, 74.
Ma'am, ನಾನು petitioner
75.
ಪರವಾಗಿ appear ಆಗ್ತಾ ಇರೋದು. 73 for the petitioner, ma'am. 10th April, ma'am. 10th.
ಇಲ್ಲ 10th ರಜಾ ಇದೆ ಸರ್.
17th,
17th ಆಲ್ಸೋ ರಜಾ.
18th, ma'am, 18th.
18th ಕಂಪನಿ 23rd
23rd ಹಾಕಿ.
74, 75.
From 75. Interim order extension madam.
ಆಗುತ್ತೆ.
Monday ಗಿರ್ಲಿ madam.
After
Monday.
vacation.
Ma'am, ಇಲ್ಲ,
Monday ಇಲ್ಲ.
urgency ಇದೆ.
ಏನ್ ಅರ್ಜೆನ್ಸಿ?
Final year trial ಇಲ್ಲ ನಮ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮುಂದೆ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ.
ಆಫ್ಟರ್ ವೆಕೇಶನ್.
Ma'am, ಇಲ್ಲ ಲಾಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ
ಯಾವ ಮಂಡೇ? ಮಂಡೇ ಎಲ್ಲ ಇಲ್ಲ ಬರೀ
ಎನಿ ಡೇಟ್ madam.
20.
Please. Thank you.
76, 7 ಯಾವತ್ತು? ಆಫ್ಟರ್ ವೆಕೇಶನ್. 77.
After vacation. Interim order section.
ಇದ್ರೆ ಎಕ್ಸೆಪ್ಟ್ ಆಗುತ್ತೆ. 78.
78.
ಆಫ್ಟರ್ ವೆಕೇಶನ್.
Interim order.
ಇದ್ರೆ ಎಕ್ಸೆಪ್ಟ್ ಆಗುತ್ತೆ. 79, 80, 81, 82, 83, 84, 12 ಇಲ್ಲ ಸರ್ ಎಲ್ಲ ರಜಾ.
ಮುಂಚೆ ಎನಿ ಡೇ ಕನ್ವೀನಿಯಂಟ್.
23rd
23rd ಗಿಂತ ಮುಂಚೆ
ಅಷ್ಟೇ.
ಅಂದ್ರೆ ಇಯರ್ ಸ್ವಲ್ಪ
ಅಲ್ಲ ಒಂದೊಂದ್ ದಿನ ಒಂದೊಂದ್ ಮ್ಯಾಟ್ರ್ ಇದೆ. ಇಲ್ಲ ದಿನ ಇರಲ್ಲ ಕ್ರಿಮಿನಲ್ ಮ್ಯಾಟರ್ಸ್.
ಅಲ್ಲ ಅವ್ರೇನು ಇಲ್ಲ ಎರಡೇ ಪಾಯಿಂಟ್ ಮುಗಿಸ್ತಾರೆ ಸರ್.
ಇನ್ಯಾವತ್ತೂ ಇಲ್ಲ ಸರ್. ಅಷ್ಟೇ ಬರಲ್ಲ.
ಬರೀ half an hour sitting ಅಂತ.
ಯಾವತ್ತು
ಏನಿದೆ
ಕನ್ವೀನಿಯಂಟ್ ಅಂತಂದ್ರೆ 16. ಈಚೆ ಆಗಲ್ಲ, ಹಿಂಗೆ ಕಾಯೋದು. ಹಿಂಗೆ ಕಾಯ್ತೀರಾ?
85
ನಾನ್ ಹೇಳ್ತೀನಿ ನೋಡಿ ಬೇಕಾದ್ರೆ.
ಏನು ಮಾಡೋದು ಚಾನ್ಸ್ ಮುಗಿಸ್ಕೊಳ್ಳೋಣ ಅಂತ ನಾವು ಆಫ್ಟರ್
ರೀಚ್ ಆದ್ರೆ ಅಲ್ವಾ ಮುಗ್ಸೋದು? ರೀಚ್ ಆದ್ರೆ ಅಲ್ವಾ ಮುಗ್ಸೋದು?
Madam, 85.
84 ಇವಾಗ ಅವ್ರು ಕೇಳಿದ್ರಲ್ಲ.
Madam, 85.
ನಿಮ್ದೇನಾ? ಸರ್
70.
ಇಬ್ರು ಸೇರ್ ಒಂದ್ ಡೇಟ್ ಹೇಳಿ. 85.
85, madam, after vacation.
ಆಫ್ಟರ್ ವೆಕೇಶನ್.
Interim order extend, madam.
ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ತದೆ.
ಇದೆ madam.
Madam, 86.
ಯಾವತ್ತು?
ಆಫ್ಟರ್ ವೇಕೇಶನ್. ಟೈಮ್ ತಗೊಂಡು ಹೋಗ್ತೀರಾ?
89.
ಟೈಮ್ ತಗೊಂಡು
87 ಬೆಳಗ್ಗೆನೆ ಅಡ್ಜರ್ನ್ ಆಗೋಯ್ತಪ್ಪ. 4, 6. 89 ಯಾವತ್ತು ಸರ್?
Ma'am, 70. 70.
70 ಯಾವತ್ ಬೇಕು? ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಎಂಟ್ರಿ ಮಾಡಿ.
ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಬೇಡ. ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಬೇಡ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕೊಡಿ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ರೀಚ್ ಆಗ.
20 ಕೊಡಿ.
ಮೇಡಮ್ 10th
23 ಅಥವಾ 22.
23 ನೇ ಹಾಕಿ.
Interim order extension.
ಆಗುತ್ತೆ ಇದ್ರೆ ಯಾವತ್ ಬೇಕೋ? 71
ಸೆಟಲ್ಮೆಂಟ್ ಆಗೋದಿಲ್ಲ.
ಬಂದಿದಾರಾ? ಬಂದ ತಕ್ಷಣ ಒಂದ್ ಸ್ವಲ್ಪ ಮುಂದೆ ಬರ್ತೀರಾ? ಧಾರವಾಡದ ಮ್ಯಾಟ್ರ್ ಒಂದಿದೆ, ಅದಾದ್ಮೇಲೆ ಮುಂದೆ ಬಂದಿದೆ ಸರ್. ಫೈಲ್ 71.
ಮೇಡಮ್
ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ. ಹೇಳಿ ಸರ್ ಪಾಟೀಲ್ ಸರ್.
ಇದು ಮಧ್ಯಾಹ್ನ ಬರೋದಾ ಬೇಡ?
ಮಧ್ಯಾಹ್ನ
2:30 ಕ್ಯಾಬ್ ಇಲ್ವಲ್ಲ?
ನೀವು ಇದೊಂದಿದ್ದೀರಾ ನೋಡಿ, 71 ಸೆಟ್ಲ್ ಆಗ್ತಾರಂತೆ.
ಓಕೆ,
ಅದೊಂದ್ ಇರ್ತೀರಾ.
ಮತ್ತೆ ಮೇಡಮ್
ಮಿಕ್ಕಿದ್ದೆಲ್ಲ ಬಿಡಿ ಸರ್. ಇಲ್ಲ ಎಲ್ಲ ಎಂಟ್ರಿ ಮಾಡ್ತೀನಿ. ಈಗ ಊಟ ಮಾಡ್ಬೇಕು
ಮ್ಯಾಮ್. ಇದು
ನಂದು 2:30 ಅಲ್ಲಿ ಬೇರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದೆ
ಸರ್. 19 ಒಂದು ಪಾಸ್ ಓವರ್. 19, 71 ಅಷ್ಟೇ.
ಮ್ಯಾಮ್, ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 73 23rd ಗೆ ಹಾಕಿದೀರಾ?
ಅದೇನಾ?
ಆಫ್ಟರ್ ವೇಕೇಶನ್ ಒಂದು ಸ್ಟಾಪ್ ಪ್ರಾಕ್ಟೀಸ್.
ರವಿ ಸರ್ ಅವರು ಡೇಟ್ ಕೊಡ್ತಾ ಇದಾರೆ, ಸಾಹೇಬ್ರು ಕೂತ್ಕೋತಾ ಇಲ್ಲ.
ಅವ್ರು ಕೂತ್ಕೊಳ್ತಾ ಇಲ್ವಾ?
ಕೂತ್ಕೋತಾ ಇಲ್ಲ. ಅದು ಒಂದ್ ಡೇಟ್ 23rd ಹಾಕ್ಸ್ಕೊಳ್ಳೋಣ ಸರ್.
ಬಹಳ ಲೇಟ್ ಯಾಕೆ? 15ಕ್ಕೆ ಹಾಕ್ಸಿ.
15. ಆಯ್ತು ಸರಿ ಸರ್, 15ಕ್ಕೆ ಹಾಕ್ಸ್ಲಾ?
15th
ಅವ್ರ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್ ಹೇಳ್ಬಿಡೋಣ.
ಹೇಳ್ಬಿಡೋಣ.
ಯಾವ್ದು ಬೇಕು ಹೇಳಿ ಸರ್. ರವಿಕುಮಾರ್ ಸರ್
15th ಗೆ ಹಾಕಿ ಮೇಡಮ್.
15th ಗೆ ಹಾಕಿ ಮ್ಯಾಮ್.
ಮೇಡಮ್
15th.
73 15th ಗೆ ಹಾಕ್ತೀರಿ ಮ್ಯಾಮ್.
2:30 ಹಾಕಿ 15th ಗೆ.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 19 ಮೇಡಮ್.
ಓಕೆ ರವಿ ಸರ್, ಅದಕ್ಕೆ ಫೋನ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
ಆಯ್ತಾಯ್ತು, ನಾನು ಟ್ರೈ ಮಾಡ್ತಿದ್ದೆ. ಎನಿವೆ 15th ವಿಲ್ ಟೇಕ್ ಇಟ್.
ಮೇಡಮ್
ಓಕೆ ಸರ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 19 ಮೇಡಮ್.
Whether it is 2:30 or not, do not know. ನೋಡೋಣ.
Anyway, let it get decided, sir.
2:30.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 19
2:30 ಯಾ?
Done.
Okay.
Madam, serial number 19, madam. Madam,
ಸರ್ ಹೇಳಿ ಸರ್.
serial number 19 pass over ಆಗಿದೆ ಮ್ಯಾಟ್ರು.
19 ಪಾಸ್ ಓವರ್ ಹಂಗೆ ಇದೆ ಸರ್ ಅದು ಬಂದ
ಕರಿತೀರಾ
ತಕ್ಷಣ
ಮೇಡಮ್ ಇಲ್ಲ ಡೇಟ್ ಕೊಟ್ಬಿಡಿ ಮೇಡಮ್ ಪ್ಲೀಸ್ ಒಂದು.
ಡೇಟ್ ಕೊಡ್ಬೇಕಾ? ಅದರ್
ಹೌದು.
ಸೈಡ್ ಸರ್ ಅವ್ರಿಗೆ ಹೇಳ್ಬೇಕಲ್ಲ,
ಅವ್ರಿಗೆ
ಅದರ್ ಸೈಡ್ ಗೊತ್ತಾಗಲ್ವಲ್ಲ.
ಹೌದಾ ಅವರು ವಿಸಿನಲ್ಲೇ ಬರ್ತಾರೆ.
ನೀವು ಅದೇ ಶ್ರೀರಾಮ್ ರೆಡ್ಡಿ ಸರ್ ವಿಸಿಗೆ ಬರ್ತಾರೆ, ಅವರು ಪಾಸ್ ಓವರ್ ಅಲ್ವಾ, ತಗೊಳ್ಳೋದೇ 230 ಮೇಲೆ ಅದನ್ನ.
ಹೌದಾ ಮೇಡಮ್ ತಗೊಳ್ತೀರಾ ಮೇಡಮ್ ಅದು? ಹಲೋ
ಅಕಸ್ಮಾತ್ ತಗೊಳ್ಳಿಲ್ಲ ಅಂದ್ರೆ ಯಾವ ಡೇಟ್ ಕೊಡ್ಬೇಕು?
ಮೇಡಮ್ ಯಾವ್ದಾದ್ರು ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಪರವಾಗಿಲ್ಲ.
ಎಂಟ್ರಿ ಮಾಡ್ತೀವಿ ಸರ್, ಆಮೇಲೆ ಅಪ್ಡೇಟ್ ಆಗುತ್ತೆ. ಯಾವ್ದಕ್ಕೂ 2.5 ಇರಿ, ಯಾಕೆಂದ್ರೆ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ.
ಹಾ
ಅದು ಇದು ಬೇಲೆಬಲ್ ವಾರೆಂಟ್ ಎಲ್ಲ ಇಶ್ಯೂ ಆಗಿದೆ.
ಸರಿ ಮೇಡಮ್ ಓಕೆ.
ಅವರು ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಅಸರ್ಟೈನ್ ಮಾಡ್ತಾರಂತೆ.
ಸರಿ ಮೇಡಮ್ ಆಯ್ತು.
ರೀಕಾಲ್ ಆಗಕ್ ಚಾನ್ಸ್ ಇದೆ, ಯಾಕಂದ್ರೆ 3-4 ಅದ್ರಲ್ಲಿ ಏನು ಇಲ್ಲ, ಈಗಾಗ್ಲೇ ಕ್ಲೋಸ್ ಆಗಿರುತ್ತೆ ಕೆಳಗಡೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಂತಾನೆ ಒಂದು 3 ಚಾನ್ಸ್ ಕೊಡ್ತಾರೆ. ಅವ್ರು ಮಾತ್ರ ತೋರ್ಸಿದ್ರಾಯ್ತು.
Madam, 91.
91 16-4 230.
5 ನಿಮಿಷದಿತ್ತು ಸಾಹೇಬ್.
ಅದೇ 5 ನಿಮಿಷದಿತ್ತು ಅಂದ್ರೆ ತಗೊಳಕ್ ಆಗಲ್ಲ, ಅದೇ ಹೇಳಿದ್ರಲ್ಲ.
16th
ಹಾ 16th.
ಊರಲ್ಲಿರಲ್ಲ ನಾನು.
ಅಷ್ಟೇನಾ? ಕಾಂಪ್ರಮೈಸ್ ಆಗ್ತೀನಿ. ಹಾ ಹಾ ಸೈನ್ ಇದೆಯಾ ಅದ್ರಲ್ಲಿ? ಟೈಮ್ ಅಂದ್ರೆ ಇವಾಗ ಏನ್ ಗೊತ್ತಾ, ಒಂದು ಧಾರವಾಡ ಮ್ಯಾಟ್ರ್ ಬಂದ ತಕ್ಷಣ ಅದಾದ್ಮೇಲೆ ನೀವು ಬಂದು ಎಲ್ಲ ಪಾರ್ಟೀಸ್ ಎಲ್ಲ ಬಂದು ಮುಂದೆ ನಿಂತ್ಕೊಂಡ್ಬಿಡಿ. ಇದೊಂದು ಬೇಗ ಹೋಗೋ ಚಾನ್ಸ್ ಇದೆ. 71 ಯಾಕೆ ಗೊತ್ತಾ, ಎಲ್ರು ಎಲ್ಲ ಕೇಳಲಿಲ್ಲ, ನಾನೇ ಡೇಟ್ ಹಾಕೊಳ್ಳೋದು. ಹೌದು, ಅದಕ್ಕೆ ಆಮೇಲೆ ಮಾಡೋದೇ ವಾಸಿ. ಈಗ ಅರ್ಧ ಕೆಲಸ ಆಮೇಲೆ ಅರ್ಧ ಕೆಲಸ ಹಂಗಾಗುತ್ತೆ, ಮಾಡಿದ್ದೇ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದೆ. ಸರಿ. ಎಷ್ಟೊತ್ತಿಗೆ ಬರುತ್ತೋ ಗೊತ್ತಿಲ್ಲ. ಬೋರ್ಡ್ ಫೋನೇ ತಗೋತಾ ಇಲ್ಲ ಈಗ.
Serial number 3. They submitted that they were informed. ಯಾವತ್ತು ಹೋಗಿದೆ ಅದು?
16/4.
16/4 is Monday, Tuesday. What if 15th or 16th, what is the difference? It's coming physically. Next week there only Monday is working, 8th. You want it on 8th? 8th or 15th? Which? 15th, 15th. Inform the other side. Yes, Mr. Sridhar. New matters we are taking up. Fresh matters we are taking up. ಅದ್ಯಾವ್ದಾದ್ರು ಮೆನ್ಷನ್ ಮಾಡಿದ್ರೆ ವಿಲ್ ಟೇಕ್ ಇಟ್ ಅಪ್, ಇಲ್ಲಾದ್ರೆ ಎಲ್ಲ ಬಂದ್ಬಿಡೋದು ಬಿ ಗ್ರೂಪ್ ಎಲ್ಲ. ಯಾವ್ದು ಲಿಸ್ಟ್ ಮಾಡೋದು ಅಂತ. ಕರೆಕ್ಟ್. ನೀವು ಯಾವ್ದು ಅರ್ಜೆನ್ಸಿ ಇದೆಯೋ ಹೇಳಿ, ಅದು ವಿಲ್ ಟೇಕ್ ಇಟ್ ಅಪ್. Fresh matters we are taking up. If there's some urgency matter like admission and exam and admission ಯಾವ್ದು ಇದೆಯೋ ಅದು immediately will take it. ಯಾವುದು ನೀವು ಹೇಳಿ. It's being called out. Wait.
Dharwad bench matter. KL Patil.
Yes. ನೀವು ಯಾರಿಗೆ?
I'm for the
revision petition, review petition. No interim orders are there.
no interim orders.
Counsel for the petitioner released on 16th.
This number 2.
Yes. Just a moment, let's finish this list and come.
List number 2, order serial number 1.
Proposed respondent 6 and 7.
Yes. Yes, please.
You filed an impleading application. But filed a recall application and an impleading application. Recall on the ground that they have suppressed several facts and obtained the order from this honorable ground.
Yes, you had you wanted time to file objection. You filed your objection. Yes. So who wants to start?
It's my application, my lord, but if they've already come before the court, they've got an order.
Somebody start.
I'll start, my lord.
since the occupation certificate is of 31 villas.
Half of it,
Half of it, 33 villas.
more than half of it.
More than half of it. Why they had done it is, on the ground saying that there was somebody who complained from amongst these people who are residents there, saying that the villas, you could not have issued the occupation certificate. All the villas were issued occupation certificate after the authorities had visited, the PDO had given and inspected, placed before the committee, and thereafter it came to the occupation certificates came to be issued. And some of the grounds under which the occupation certificate came to be recalled was on the ground that some the electrical meters are not fixed.
Doors were not there, windows were not there, all those things. You said you needed 3 months' time to fix it.
Precisely.
So we gave you 3 months' time. Now is it done?
It is now the process. He had
Is it done?
It is not done. But
Your
my-
time is expired.
Time is expired. I filed an application well before the expiry of time for the purpose of extension of it, because
We are not going to extend. We told you we are not going to.
As on today, they will not
I
start.
will displace it.
We are not going to extend.
I will displace it.
You may place it.
I am only trying to say this. There was some, in so far as 29 villas are concerned. That is the subject matter. I have given it by way of a mortgage to the investor. Now, I am trying to get it back on them, and I am in the process of settling the issue.
And you already sold it to third party.
No, we are not sold it. It's all unsold villas.
Unsold.
Unsold villas. That is why I have kept it, because I didn't want to complete it fully, because most of it is.
The occupancy certificate is not for villa, it is for the project.
Project
The
is-
contention on this side is,
This is
you are
before I-
not there that day. The contention is that the PDO is not the authorized officer to issue it.
Yes.
So that is what your colleague was told to address arguments on.
Look, I have produced a particular document
Hmm.
in my statement of objections.
Yes.
In order to show that I had written to an unnecessary page number 11.
How long will this take? It will take some time.
It
Let's
takes some
finish
time.
the other matters and then come back to this. If we can, because we have to raise at 3 o'clock.
No, sir,
Unlikely.
My pressing difficulty at the moment is, my lord, is that they're not paying security. The security has left the project. There is no water for the last 1 month.
That's not something that we can decide in this
Understand,
matter.
lord, I understand, sir. But this
That
is
is
making
a-
it difficult for them, apart from the fact that the.
We are only to require to see if the person who has sanctioned the or issued the OC is the competent authority or not. If he is competent, if you have any other dispute between them, you will have to.
Why it is allied, my lord, if I may, my lord. This honorable court had passed an order for another allottee saying that RERA prevails over the arbitration act, my lord.
Hmm.
So before the RERA, liberty was given to them, my lords, to say that if the RERA were to hold that OCs are prior to the date of when RERA came into force, then liberty was given to them to come back here. RERA has now passed an order saying that the project comes under.
We'll hear you on another date. We'll hear you on
So these.
15th. Relist on 15th at 2:30 PM.
This once more.
Yes.
My statement. I have.
Your precursors itself quite a bit. So we'll hear you completely on.
Taxes.
Huh.
Say get a quote out.
Let us see it on 15th.
Very good.
Good. Next. Bega.
16.
16th. Sorry, 15th at 2:30.
16.
16th.
16 to 30.
Yes.
Serial number 2, H.C. Shivramu.
ಏನಿದೆ? The registrar computers has submitted a report dated 4/4/2024 stating that the details of the panel advocates of all Gram Panchayat, Taluk Panchayat, Zilla Panchayats with their names, mobile numbers and email IDs are web posted on the website of the High Court. Same is taken on record. Yes,
Serial number 3,
compliance is complete. Name the contemptor. You are appearing, no, you are not.
This is third matter. Serial number three.
Second matter. ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾ ಇದ್ದಾರೆ? ಎಲ್ಲಿದ್ದಾರೆ? ಅವ್ನು ಕರ್ಕೊಂಡ್ ಬನ್ನಿ ಅಂತ ಅದಕ್ಕೆ ಹೇಳಿದ್ ನಿಮ್ಗೆ. Relist on 15th, 16th. ಅವ್ರು ಬಂದ್ರೆ then we can consider.
Serial number 3. With Naga Reddy.
My request for 15th, my lord, has been done. There's another matter on 15th, my lord, where the email incorporation had to be done for the plan sanction.
15th at
Both have
2:30.
been done on this. Much of this.
Serial
Request
number
of
4.
respondent number 1 to 4.
Umapati, yes.
Right. Therefore, respond number 5.
Yes.
Our objections are ready. My
File my
objections
statement.
not are ready, we are.
Objections are ready.
Please.
Counsel for respond number 5.
5.
Has filed a statement of objection, copy thereof served on the counsel for the petitioner. The same is taken on record. You are,
You've admitted students already, my lord.
248-1 and 248-2 has been done, 248-3 has been done.
Yes.
So
Now
how are
that
you
has been
admitting
stayed.
students?
There's a stay, my lord, by the, we've challenged that order and it's been stayed. The order of status quo we maintain.
It may be stayed, but if your 248-3 is there, then you can't have students there. You can't run your business there.
My lord, there is. No, it's an educational institution.
Yeah, it may be so.
Then.
That is why it is more important that students are not there. In a building where 248-3 has been issued.
That order has been, there's an order of status quo. By the, in an appeal.
Status quo, then don't admit students and don't have students.
There are already students. It's not like it's a fresh school which is there.
Mr. Chinappa, if there is a problem with the building,
We have, my lord, lordship may
till
look at the
that building
document.
is sorted out, you should not have any students there.
No, my lord, there is, we have all clearances. Even the fire clearance is there. The lordship may kindly look at the documents of fire.
Why was 248-1 issued?
My lord, of course, I've not checked the circumstances.
The whole problem is that if 248 is there, then you can't have students there.
But 248 ultimately is saying that there's some violation in the building.
Some violation and the violation.
No, there is extra construction is what they are saying. Now, the allegation what they made was that it is on a drain. That the construction is on a drain.
Why was 248-1 issued?
No, 248-1 lot was that there's some construction which they say is in excess of what is permitted under the sanction plan. That is the allegation. Now, what it is, my lord, and how it is, according to us, my lord, we were not notified properly. Our explanation was not asked for, and therefore we've challenged it. There's an order, my lord, directing that there shall be maintained status quo. Now, that can't affect, my lord, insofar as educational institution is concerned is one thing. But ultimately, my lord, petitioner before your lordships.
Who are you? Locus.
I don't know who he is, my lord.
There is a public interest litigation. Who are you?
We are not not a parent, not a teacher, not a student.
Then we cannot take up this, Mr. Umapati. We can't pass any order. We don't have jurisdiction. It's always determined by our roster. For the roster. You are here as in public interest.
No, in the interest of the staff of the school.
Are you a staff member?
No,
He is the petitioner.
If any staff use the complaint, you will not be spared. You will be taken some action against those staff.
Then you have to file a.
The staff have come before me.
Then you go before the Chief Justice on the public interest litigation, make your submission. Not before this court. We don't have jurisdiction.
Public interest litigation, my lordship can tell you, I have registered 14 public interest litigation.
ಅದಕ್ಕೇನಪ್ಪ ಇದು ಅಲ್ಲೇ ಹೋಗಿ ಅಂತ ಇದು 15th ಆಗತ್ತೆ.
The public of weight is only a small institution where the Supreme Court order has been violated.
Mr. Umapati, you are ಎಷ್ಟು PL ಮಾಡಿದ್ರೆ ನಿಮಗೆ ಗೊತ್ತು ನಮಗೆ jurisdiction ಇಲ್ಲ ಅಂತ. Don't make us commit mistakes. You go there. You said you are representing the staff when you came before us, but the petitioner is not the staff. It's a public interest litigation.
Disclosed in the petition itself, how I got this information.
Whatever you may get, the staff is not before us.
It can be converted into a PL.
Correct.
Till that time, the admission is not done.
A reading of, no, we can't pass any orders. A reading of the above petition indicates that the petition has been filed in public interest and the petitioner claims to be a public interested person. If that be so, this court would not have jurisdiction. The matter would have to be considered by the concerned court having roster over public interest litigation. Registry is directed, accepting submission of the counsel for the petitioner. The above petition is treated as a public interest litigation and directed to be placed before the concerned roster court. The petitioner to comply with all requirements of public interest so and so rules.
In that any increase came around.
We don't have any jurisdiction.
That's all.
Serial number 5. Abdul Azhar.
For the
Accepting the
petitioner's
reasons stated
counsel, my lord.
in support
I
of IA
filed-
1 of 2024, the amendment sought for challenging the rules of the council are allowed. IA 1 of 2024 stands allowed counsel for the petitioner to carry out necessary amendment and file amended, sorry,
My lord,
IA
copies
3
have
of
not been served.
2024. Who is for the standing counsel for the council?
My lords, appearing on behalf of respondent 2 and 3, my lords.
Yes.
3 IAs have been filed, but none of them have been
ನಿಮಗೆ ಏನ್
served.
ಬೇಕಾಗಿ ನಿಮ್ಗೆ ಹೇಳಿದ್ದೆ ಅವತ್ತು.
Please, my
It's at your submission only this IAs have been.
Please, my lords.
Who is the standing counsel for the veterinary council?
Vaishali.
Council.
I'm not aware.
Who is the standing counsel, Mr. Shami?
ವೆಟರ್ನರಿ ಕೌನ್ಸಿಲ್ ಅವರೇ ಇರ್ಬೇಕು ಸ್ವಾಮಿ, ವೈಶಾಲಿ ಹೆಗಡೆ ಅವರೇ ಇರ್ಬೇಕು.
ಅವರು ಕಾಲೇಜ್ಗೆ, ಕಾಲೇಜ್ ಅಂಡ್ ಯೂನಿವರ್ಸಿಟಿ.
I'll have to ascertain.
ಕೌನ್ಸಿಲ್ಗೆ ಯಾರು ಇಲ್ಲ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು.
ಕೌನ್ಸಿಲ್ಗೆ
ಯಾರು ಇಲ್ವಾ? No idea. Issue notice on IA 3 of 2024, returnable by 3rd June.
ಇದು IA2 permission, my lord, because already your lordship permitted me to
No,
for
we
internal
can't do that.
examination permission ಕೊಟ್ಟಿದ್ದೀರಿ. ಈಗ otherwise 1 year waste ಆಗುತ್ತೆ.
Until a finding is given on the virus of that particular provision, we can't direct you to take it up. Next.
Internal examination already your lordship permitted me, and now the
We have already told you 4-5 times, Mr. Shami, let them come.
Please.
Serial number 6. Mohan B.
next date, my lord.
3rd June.
For petitioners, my lords. My lords, in this
Yes.
case, I have sought for the affiliation of CBSE syllabus, my lords.
Form 3, na?
Yes, my lords.
Learned AG accepts notice for respond number 1 to 4. Allowed, Form 3.
Oblige, my lords. My lords, may I make a request that the order be uploaded at the earliest, my lord, because I need to apply with the
It
principal.
will get uploaded only on Monday, Mr. Mohan.
Agmos. Grateful.
Hmm?
Well standard student looks. The deadline allows to file an application for the examination. So the deadlines fell on the dates of examination. The student was under a misconception about the deadlines are after the examination, which QC examinations. But 9th March, my lords, was the deadline, which was extended to 16th March. All examinations of second QC was from 1st to 18th of March. Genuinely, my lords, the student was under the impression, my lords, his intention, my lords, to take up that.
Who is the standing counsel for NEET?
Seven council. I had already.
Shalindra, you are standing counsel.
For
Union of India, Garrow.
Sadhana Desai.
I represent NTM.
Satna Desai accepts notice for respond number 1. Shri M.R. Shalindra accepts notice for respond number 2. ಇದು UG NEET.
Current petition of UG. But Supreme Court earlier for UG.
PG NEET is conducted by other agency. And as far as this is concerned, my lords, we take instructions and 5th of May examination. Prayer is to consider the representations made by the petitioner.
For what are you are looking at admission or?
He has not filed the application. Even after the extended last date, he has failed to make an application. That's what
The petitioner is, the respond number 1 and 2 are directed to permit the petitioner to submit his application for UG NEET 2024 entrance examination to be conducted from 5/5/2024, subject to the result of the above writ petition. Provided the petitioner submits his application on or before
So, when there, it's an online application, so they have to open the portal. Yes. I'm ready today, but they have to.
on or before 10th April, the respond number 1 and 2 are directed to open the portal for the same by end of day 6th April. Type ಮಾಡು.
Past or matters?
Last or the end of the list.
End of-
ಬಂದಿದೆ. ಹೆಂಗಾಯ್ತು? ಎಷ್ಟಿದಾವೆ? ಟೈಪ್ ಮಾಡಿ ಕೊಡ್ಬೇಕು.
Serial number 19, list number 1.
ಅವ್ರು ಹೋದ್ರು ಅಂತ ಎಲ್ಲ SCGP ಎಲ್ಲ ಹೋದ್ರು. Awaiting police report released on
And for the
4th
respond
June.
number 1 bank, my lord, it is
4th June.
much.
Serial number 71.
Settlement. Yes. Covered. Does not refer to mediation. Fair enough. You go to mediation because there are 3 other proceedings. DV Act is also there, Alva. From what does this arise out of? So 6 months are over. The petitioner is before this, petitioners are before this court, seeking for the following reliefs. Petition number 1 is the husband and petition, respond number 1 is the wife. Petition number 2 and 3. 2 is the mother of petition number 1. Who are petition number 3 to 5? Family members, Andre? Petition number 3 is the aunt of petition number 1. Petition number 4 is the maternal uncle. Petition number 5. Petition number 4 and 5 are maternal uncles. Petition number maternal uncle last time. In the proceedings which had been filed by respondent number 1, in CMS 59 of 2014, a joint memo had been filed. What happened in CMS? Came to be partly allowed. An appeal being filed in criminal appeal number 680 of 2015. Both the petitioner and respondent number 1 had filed a memo stating that they had amicably settled their disputes and the matter could be disposed. The trial court, however, gave 6 months' time to the parties to live smoothly and lead a comfortable marital life and did not accept. They said compromise. It is challenging the same. The petitioners are before this court. The memo before the trial court having been filed, the compromise having been filed in the year 2018, more than 6 months have elapsed from that date. Today, a compromise petition has been filed. A joint memo has been filed by the petitioners and respondent number 1, which reads as under. Both of you are living together. Any problem? They submit, the petitioner and respondent number 1 are before this court in person and are identified by their respective counsels. They submit that they have been living happily together as husband and wife subsequent to the compromise petition filed before the trial court and continue to do so even as on today. In that view of the matter, the joint memo is accepted. Since the only condition which has been imposed by the trial court was that they should live happily together for more than 6 months. In that view of the matter, I pass the following order. Criminal petition is allowed. The proceedings in CC number 10959 of 2015, pending on the file of the 24th ACMM at Bangalore, and consequently CMS number 59 of 2015 are herewith dismissed, hereby quashed. Sign the order sheet.
230 move matters. Nityananda KR.
Is Nityananda?
For the respondent, NCTE, my lord.
Yenidu? It's been complied.
My lord, they say as per the petition, 3 defects are there. Initial have been complied as per their records. Now, as per the latest meeting, my lord, it is found 3 documents. If they submit, we will consider and pass.
Verify Monday.
My lord, yes, my lord.
You will accept notice for?
NCTE, my lord. R1.
Accept notice for so and so. Bangalore University?
B Ramesh.
B Ramesh for respondent number 2. Counsel for the petitioner served 2 sets of the petition along with annexation said counsel. Both of them are directed to verify if all the requirements have been complied with by the petitioner. Relist on 8th.
Much.
Serial number 2. Yashodhar Hegde.
Yes. Notice, Mr. Raghavan. We'll issue only notice, let them come. Learned AGA accepts notice for respondent number 129. Counsel for the petitioner served 2 sets of petition along with annexation and the counsel for the respondent, learned AGA, relist on 8th. Wait for.
Serial number 3. Manjunatha AC.
Yes. Yesterday attendance. How much attendance do you have? In Mesro. Gururaja N. CL number
11.
11 Chaitra H. N.
Page 36, ma'am.
36. 65.63. What is the minimum requirement?
75% as per regulation, ma'am.
So theory is there. Practical is not there.
Please.
In reason, you know. Dialysis twice a week. Land AG accepts notice for respond number 1. Ms. Vaishali Agde accepts notice for respond number 2 and 3. Issue notice to respond number 4, returnable by 14th June. The petitioner is permitted to take up, the respondents are directed to permit the petitioner to take up the annual board examination, second year BVSC and AH, subject to the result of the petition. The respondent shall act on a uploaded printout of the uploaded copy of the order without insisting on a certified copy.
Madam, serial number 7, list 2 ಅಲ್ಲಿ memo for hand delivery ಆಯ್ತು.
No, no, it will be uploaded. ನಮ್ ಕೋರ್ಟಲ್ ಒಂದು ತಗೊಂಡಿಲ್ಲ ಇಷ್ಟ ದಿನಕ್ಕೆ.
ಮತ್ತೆ ಬರ್ತಾರ?
ಬನ್ನಿ.
ಎಲ್ಲ ಅನ್ಸುತ್ತೆ. ಎಲ್ಲ ಬಿ ರಮೇಶ್ 230 matters.
ಎಂ ವಿನೋದ್ ಕುಮಾರ್. ಬಿ ರಮೇಶ್. ಯೂನಿವರ್ಸಿಟಿಗೆ ರಮೇಶ್.
ಮೇಡಮ್ ಅಪ್ಲೋಡ್ ಆಗುತ್ತಲ್ಲ ಮೇಡಮ್?
ಅಪ್ಲೋಡ್ ಆಗುತ್ತೆ. ಇಲ್ಲಿ ಯಾವ್ದು ಇಷ್ಟ ದಿನಕ್ಕೆ ಒಂದು ಇಲ್ಲ, ಎಲ್ಲ ಅಪ್ಲೋಡ್.
ಅಲ್ಲ ಸಾಹೇಬ್ ಹ್ಞೂ ಅಂದ್ರು, ಅದಕ್ಕೆ ನಾ ಹೇಳಿದೆ.
ಸರ್ ಈಗ ಹೇಳಿ. ಹೌದು, ಆಫ್ಟರ್ ವೆಕೇಶನ್. ಅಲ್ಲ, ಅದು ಅವ್ರು ಇರ್ಲಿಲ್ವಲ್ಲ ನೀವು ಕೇಳಿದಾಗ, ಅದಕ್ಕೆ ರೀಚ್ ಆಗುತ್ತೆ ಅನ್ನುವಾಗ ಬಂದಿರ್ತಾರೆ.
ರಿಸ್ಯೂಮ್ ಆಗತ್ತಾ?
ಇಲ್ಲ, ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
ಕೊಡ್ತೀರಾ?
ಅದೇ ಯಾವತ್ ಬೇಕು ಸರ್? ಅದು ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಅಲ್ಲಿ ಇದೆ, ಅದಕ್ಕೆ ಡೇಟ್ ಹೇಳಿ. 23/4. 83 ಯಾವತ್ ಬೇಕು? ಆಫ್ಟರ್ ವೆಕೇಶನ್. ಅದೇ ಹಿಂಗೆ ಕಾಯೋದು. ಯಾವತ್ ಕಾಯ್ತೀರಾ ಹೇಳಿ, ಅವತ್ತೇ ಕೊಡ್ತೀನಿ. ಕಾಯೋದಿನ ಯಾವತ್ ಕಾಯ್ತೀವಿ? ಅದೇ ಅಪ್ಲೋಡ್ ಆಗ್ಬೇಕು ಎಜುಕೇಶನ್ ಮ್ಯಾಟ್ರು ಅಂತ.